My lords, I am for response number 6, my lords. My lords, I can't hear you, my lords. Some audio issues, my lords. Senior is out of station, my lords. Kindly taken on Monday, my lords.
My lords, is it serial number 4, my lords? Lords, court's audio is, my lords, muted, I believe. We are not able to hear the voice of the court, my lords. Please.
The petition has been filed way back on 27th May 2024. It was required of the respondents to have issued necessary instructions to the learned AGA by availing the facility provided in court case management system. The are directed to affidavits as to why, despite the file being uploaded onto the CCMS, no instructions have been transmitted to the learned AGA using the CCMS. Affidavit to be filed on or before 27th March, released on 27th March, 27th February.
This 117 ಇದು 117 ಸೇಮ್ ಈ ಲಿಸ್ಟ್ ನಲ್ಲಿ 117 ಕೇಸ್
117 connect to 3.
ಪ್ಲೀಸ್
ಅದೇನು ಯಾವ ಇಯರ್ ಅದನ್ನು
ಎರಡು ಸೇಮ್ ಅದು ಬ್ರದರ್ಸ್ ಇದ್ದಾರೆ ಅದನ್ನ ಅದು ಇದು ಆರ್ಡರ್ಸ್ ಲಿಸ್ಟ್ ನಲ್ಲಿ ಬಂತು ಅದು ಬಿ ಗ್ರೂಪ್ ನಲ್ಲಿ ಬಂದಿದೆ
117 connect to so and so.
Yes, my lord.
ಇದರಲ್ಲೂ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಬಂದಿಲ್ವಾ ಇದು 20 how can 1 year
for Siddhappa Sajjan?
Lords, I may be permitted to appear in this case, my lord.
Can you pass over, your lordship?
you can hear us now?
Now I can hear.
Now we'll hear you.
Please, my lords. My lords,
Can you pass over, your lordship?
Okay.
NH,
Because they are coming, they told that they are coming to your lordship to give.
Pass over.
I seek indulgence to take up at 2:30, my lords.
Yes, it will be at 2:30 only.
Great.
PC Jnanaya Swami.
Appearing for the petitioner, my lord. The petition writ of mandamus, my lord, considering the representation of annexure G, my lord, requested the respondent number 2 to mutate his name in column number 9. Is a granted land, my lord, and the Panchanama has been conducted. Based on the Panchanama, your lordship, On 23/6/2021, the Tahsildar, your lordship, has given a intimation to the concerned authority to enter the name of the petitioner in column number 9. May I permitted to read, my lord? ಕಾರಣ ಮೂಲ ಮಂಜೂರಾತಿ ಕಡಿತ ಸಂಖ್ಯೆ so and so ಪ್ರಕಾರ ಪಟ್ಟಾದಾರರಾದ ಶ್ರೀ ಕೆ.ಎಸ್.
Where is that recommendation?
My lord, page number 34, my lord. Annexure F, my lord.
Annexure F.
F. ಟಿಪ್ಪಣಿ ಅಂತ
ಕಾರಣ
ಇಲ್ಲಿ ಲಾಸ್ಟ್ ಇದರಲ್ಲಿ ಇದೆ ಸರ್.
Yes, Mr. Kanur.
File is not. File ಸಿಗ್ತಾರೆ.
File ಸಿಗ್ತದೆ.
They have not given the file.
29th
ಇಲ್ಲ, ಅದು
August
ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಇದೆ ಇಲ್ಲ.
29th August ಫೈಲ್ ಮಾಡಿ.
ಸರ್ವ್ ಆಗಿದೆ. 29/8/24. ಇದ್ರಲ್ಲೂ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಇಲ್ವಾ?
Your lordship, file trace ಆಗ್ತದೆ.
We'll allow it. Instruction ಇಲ್ಲ.
Yes.
Learned AGA accepts notice for respondent number 1 to 3. Petitioner is before this court seeking for the following relief. The grievance of the petitioner is that the representation submitted by the petitioner dated 26/8/2024 at Annexure G has not been considered despite an earlier order having been passed by the Tahsildar on 23/6/2021 directing the entry of the name of the petitioner in column number 9 of the RTC relating to survey number 6 of Alekote village, Siriguppa Taluk, Bellary district. When an order has been passed by the Tahsildar way back on 23/6/2021, that was required to be implemented within a short period of time, within a reasonable period of time. Not having done so, the representation submitted by the petitioner on 26/8/2024 also has remained unconsidered. In that view of the matter, I pass the following order. Writ petition allowed, a mandamus is issued directing respondents number 3 to act on the order passed by the Tahsildar dated 23/6/2021 at Annexure F in terms of the representation dated 26/8/2024 at Annexure G within a period of 30 days from the date of receipt of a copy of this order.
6, Sabil Ahmad.
My lordships, I appear for the petitioner in this matter, my lordships.
Yes.
Pursuant to the directions of this honorable court dated 13/2, I have filed an application for impleting the names, persons whose names is appearing in the RTC, my lordships.
IA 1 of 25 has been filed for impleading. Issue notice on IA 1 of 2025, returnable by 24th March.
Much obliged, my lordships.
7, Vinay Kumar Shetty.
Please, my lords. The petitioner is seeking writ in the nature of mandamus directing the respondents to consider the petitioner representation, my lords, which is here provided under Annexure F and F1, my lords. Wherein, my lords, the petitioner is the absolute owner of survey number 16/2A/1B, my lords, where he is purchased from the shaded, which is shaded is produced here at Annexure A, my lords. Thereafter, my lords, the record of rights in the name of petitioner at page number 24, my lords.
Mr. Kanur.
Direct.
Yes, because they are taking steps, your lordship, to delete, your lordship, the,
But how was the name deleted?
by oversight, your lordship, it was
Can it
mentioned.
be deleted by oversight?
Because they are taking steps, your lordship, in the month of December 2024.
Huh?
But on account of some technical problem, your lordship, they could not.
Oversight ಹೆಂಗೆ delete ಮಾಡ್ತೀರಾ?
Yes. Because some, your lordship, the portion, your lordship, are there, several portions in that survey number.
Tahsildar post delete ಮಾಡ್ಬಿಡೋಣ.
Because lordship, in the Tahsildar, your lordship, on in 12/2024, has stated that, your lordship, National Highway Authority of India, your ಹೆಸರು ತಪ್ಪಾಗಿ ದಾಖಲಾಗಿದ್ದು ಕಂಡು ಬರುತ್ತೆ. It is, your lordship, they are taking step to delete, your lordship. Within 15 days, your lordship, they delete, your lordship.
We'll direct the deputy commissioner to hold an inquiry and take action against the person who has deleted it without. You can't be deleting names of people in the revenue records without.
Because, your lordship, in they are trying, your lordship, but some technical problem they could not able to, your lordship.
First to delete ಹೆಂಗಾಯ್ತು?
Yes. Tahsildar has stated that, your lordship, I was ತಪ್ಪಾಗಿ ದಾಖಲಾಗಿದ್ದು ಕಂಡು ಬರುತ್ತೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ತಪ್ಪಾಗಿ ಅಂದ್ರೆ ಯಾರು ತಪ್ಪು
By
ಮಾಡಿದ್ರು?
oversight, your lordship.
Let the inquiry be. Petitioner is before this court seeking for the following relief. Petitioner claims to be the owner of the land in survey number 16/2A/1B, measuring 5 guntas, situated at Kunugol Cross Flyover in Kotagonda, Unshi village, Hubballi Taluk, Dharwad district. The name of the petitioner being entered into the revenue records, the petitioner was shocked to know that his name has been deleted and the name of National Highway Authority of India has been entered in his place. It is in that background that the petitioner had submitted a representation on 26/7/2021 seeking for necessary action to be taken to reinsert the name of the petitioner and delete the name of NHAI. Thereafter, the SLAO had also issued an endorsement stating that the land of the petitioner had not been acquired, and as such the name of NHAI could not have been entered into in respect of the aforesaid land. Once again, a representation was submitted by the petitioner on 27/8/2024, reiterating the earlier request. Thereafter, a legal notice also came to be issued. Though the Deputy Commissioner had also made a recommended the reinsertion of the name of the petitioner by deleting the name of NHAI in furtherance of the report of the SLAO, no action was taken. It is in that background that the petitioner is before this court. When the matter was taken up for consideration earlier on 13/2/2025, the learned AGA was called upon to inquire and make a submission as to how the name of the petitioner was deleted and the name of NHAI was inserted. Learned AGA today submits on instructions that the same was by inadvertence and mistake. The entry of the name of a person in respect of the property belonging to him in the revenue records cannot be deleted by mistake. In that view of the matter, the Deputy Commissioner, respond number 4, is directed to cause the inquiry and take necessary action against the concerned for having deleted the name of the petitioner without any reason. In that view of the matter, I pass the following order. Writ petition is allowed, a mandamus is issued. The respond number 3 is directed to reinsert the name of the petitioner in terms of the report of the SLAO and the recommendation made by the Deputy Commissioner in the record of rights pertaining to land in survey number 16/2A/1B so and so within a period of 30 days from today.
Please, my lords.
8, Santosh Maligwat.
My lords, I appear for respond number 5, my lords. Counsel on record is not well, my lords. I request for a week's time, my lords.
My lords,
5.
Yes, ma'am.
Lord, I may be given a week's accommodation to take steps, my lords, for R3 to R5.
R5 is here.
Yes.
Yes, my lords. Caveator.
R3 and 4 yaru?
R3 and 4.
3 and 4 Assistant Commissioner and Tahsildar.
Take notice.
My lords, please.
Take steps.
My lords,
ಎಷ್ಟಾಗುತ್ತೆ ಸ್ಟೆಪ್ಸ್ ಕ್ಲರ್ಕ್ಸ್ ಫಂಡ್ಗೆ ಡೆಪಾಸಿಟ್ ಮಾಡಿ.
I'll serve the copy, my lords.
ಒಂದು ಕಾಪಿ ಸರ್ ಮಾಡಿದೀರಾ ಆಲ್ರೆಡಿ, ಇನ್ನೇನು ಕಾಪಿ ಅದನ್ನು ಸೇವ್ ಆಯ್ತು ದುಡ್ಡು, ಅದನ್ನು ಡೆಪಾಸಿಟ್ ಮಾಡಿ.
Apologies.
Why do you do this? Now, AG accepts notice for respond number 3 and 4. Counsel for respond number 5 seeks for and is granted 10 days time. Relist on 10 days time.
My lord,
20th March.
my lord, interim order.
Interim order earlier granted is extended till next.
Please.
Obligement.
9, Srinivas P. Naik.
May I request your lordship to, Lord, take up the matter, Lord, 9.1, Lord, which has some 9.1.
Yes.
Lord, land, Lord, RS number 236 3A, Lord, is measuring 2 acres 33 guntas.
Certiorari right to set aside the compromise.
Yes.
Notice ಹೋಗ್ಬೇಕು. Issue notice to the respondents returnable by 7th April. In the meanwhile, after the office objections are complied.
Yes.
First matter ಅಲ್ಲಿ
First matter,
amendment ಏನಿದು?
matter ಅಲ್ಲಿ, if this matter is, Lord, 9.1 is allowed, Lord, that has a bearing on Lord 9, Lord.
So what is the amendment application to be filed?
No, I am not, Lord, pressing the amendment. No, that is not filed. Since I was required to file an amendment application, that was not filed. Therefore, I filed a separate writ petition challenging the Lord.
9 ಅಲ್ಲಿ learned counsel for the petitioner submits that in view of filing a separate writ petition in WP 101-288 or 25, he would not be filing an amendment application since the reliefs have been sought for in the other petition. His
In
statement is
first
taken.
matter, formal notice may be ordered, Lord.
ಆಗಿಲ್ವಾ ಅದು?
Agil.
Learned AGA accepts notice for respond number 1 and 2. Issue notice to respond number 3 to 7.
Yes.
Returnable by 7th April.
Please. Great.
10, DLR Khan.
My lord, petitioner is before this court seeking a writ of mandamus directing the register of birth and death to rectify the birth certificate issued consequent upon a Lok Adalat order, my lord. There was a first birth certificate issued in favor of the petitioner at annexure B, my lord. That page number 16. Therein, the month of the birth year is wrongly mentioned as April. In fact, it is March, my lord. That is the only thing that is been sought before this court. And thereafter, at annexure H, my lord, Lok Adalat petition came to be filed for no entry certificate. And there in the respondent register of birth and death was summoned and he was present, and a decree came to be passed consequent upon before the Lok Adalat, my lord. Now the petitioner has been directed to get only one certificate, either of the one to be retained with the register of birth, my lord, at annexure M.
Only one birth certificate will have to be there.
I'm seeking only direction as far as the first certificate is concerned. There has to be an endorsement to the effect that subsequent certificate is issued by the register.
Application file ಮಾಡಿದಿರಾ?
ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ, already request ಮಾಡಿದ್ದೀನಿ. Request, after request only this is endorsement is issued, my lord.
Where is your request?
At annexure L, my lord, page number 32, my lord.
ಏನು endorsement ಏನು ಕೊಟ್ಟಿದ್ದಾರೆ?
They can't maintain two birth certificate in the same in the name of one person. Either of the one has to be cancelled to the process known to law. They have directed me to approach the competent court for getting a cancellation.
Mr. Kulkarni.
Please, my lords. Earlier, my lords, it was mentioned as 15-4. He wants to get it rectified to 15-3.
SLC marks card, passport,
ಎಲ್ಲ ಇದೆ 15-3.
ನೋಡ್ಬಿಟ್ಟು ಡಿಗ್ರಿ ಆಯ್ತು. Now you are saying
ಅಲ್ಲ, 2 birth certificates in pursuance of the order passed by learned JMFC, ಅದು ಪ್ಲಸ್ ಇದು ಎರಡು ನಮಗೆ ಮೇಂಟೈನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. So one has to be cancelled.
that is understood.
Yes.
Person cannot be born twice.
Please.
So ಅದ್ ನೀವೇ ಮಾಡ್ಬೇಕಲ್ಲ, ಇವ್ರಿಗೆ ಯಾಕೆ ಕೋರ್ಟ್ಗೆ ಏನಕ್ಕೆ ಕಳಿಸ್ತೀರಾ?
We'll do it. If
Mr. Ladkan is happy.
Not me.
Petitioner is before this court seeking for the following reliefs. The petitioner, though born on 13/5/1993, on
15/3/1993,
15/3/1993, due to a mistake, the date given for the issuance of birth certificate was 15/4/1993. And as such, a birth certificate came to be issued at annexure B with the date of birth as 15/4/1993. The petitioner not having noticed this, the correct date of birth had been furnished for all other purposes, including education. The Karnataka Secondary Education Examination Board has issued a birth certificate, indicating date of birth to be 15/3/1993. The college has also recorded the name, the date of birth as 15/3/1993. Motor driving license, the voter ID issued by the Election Commission, the passport issued by the
No,
passport
in
authority.
passport, the earlier certificate was used, my lord. Earlier certificate was used and it discloses 15/4 as the date of birth.
15/3, page 21.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ ಡೇಟ್ ಆಫ್ ಬರ್ತ್
issue.
ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ.
Date of
ಥರ್ಡ್ ಲೈನ್ ಅಲ್ಲಿ ಬರುತ್ತೆ.
ಅದು 15/3 ಇದು ಬೇರೆ. Passport illa. In that view of the matter, the petitioner had filed a proceedings under section 13(3) of the Registration of Birth and Deaths Act, which came to be registered as criminal MC number 374 of 2020 before the second additional civil judge and JMFC Hospete, which on reference to a Lok Adalat, an order had been passed directing the issuance of a fresh birth certificate with the corrected date of birth as 15/3/1993. Pursuant thereto, a certificate had also been issued with that date. Subsequently,
She moved an application with the passport authority. There
the application was filed before the passport authority for correction of the date of birth. ಏನಂದ್ರೆ
ಅವರು 15/3 ಇದೆ ಇದರಲ್ಲಿ, ಪ್ರೀವಿಯಸ್ ಇದರಲ್ಲಿ 15/4 ಇದೆ. The competent authority has to issue the certificate to that effect ಅಂತ ಹೇಳಿದಾಗ it was brought to the notice.
Authority sought for a clarification since there were two birth certificates and a passport had been issued with the earlier the date of birth as per the earlier certificate as 15/4/1993. Hence, the petitioner moved an application before the respondent seeking for such clarification. When the respondent issued a endorsement at Annexure M dated 5/12/2024 that the authority cannot do so and necessary orders would have to be secured from the appropriate court. In that background, that the petitioner is before this court. The manner in which the above matter has come up before this court is very peculiar. The respondent having issued a birth certificate with 15/4/1994 as the date of birth, subsequently corrected the same as 15/3/1993 as per the order passed by a court. Naturally, when such a birth certificate had been issued, the respondent ought to have cancelled the earlier birth certificate. Without cancelling the earlier birth certificate, another birth certificate has been given with a different date. And now the respondent is calling upon the petitioner to approach a appropriate court of law to obtain necessary orders in order to correct the mistake committed by the respondent, driving the petitioner to this court in unnecessary litigation. In that view of the matter, I pass the following order. Writ petition is allowed. A mandamus is issued directing the respondent to cancel the earlier birth certificate of the petitioner bearing registration number 182 of 1993 at Annexure B, and further issue a clarification to the petitioner that the birth certificate bearing number 803-110/T/B/2020/000070 is the correct birth certificate. The registrar of birth ಯಾವ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಬರ್ತಾರೆ?
Milots, it comes under TMC, Milots.
TMC.
That it falls under DMA, Milots. DMA.
The Director of Municipal Administration is directed to take note of this peculiar facts and issue appropriate directions to all the registrar of births and deaths that in the event of any correction being carried out in a birth certificate already issued, the earlier birth certificate has to be cancelled by taking return of the original birth certificate issued to such person.
Corresponding entry has to be made in e-Janma portal, my lord.
Needless to say, necessary entries would also have to be made in the e-Janma portal.
Please.
Great.
11, Viresh Sajjan.
Lords, on the last occasion, the Honorable Court has ordered me to produce the document relating to the trial court advocate has taken his father for dialysis, my lords. There were 2 IAs filed in this petition, suit, my lords. The IAs were for recalling of the stage, recalling of a date.
What was the date of?
Lords, the order is at page number 43, my lords. The order is dated 9 January 2025, my lords. In that order, my lords, there were 2 reasons given. Sufficient opportunities were given. Still, it is not conducted. And thereafter, it is also noted that it is hit by res judicata. The applications were hit by res judicata.
15/3/24.
Please, madam.
What is the certificate you have produced? For what date? Only the 15/3/24.
Lords, first document, Pramana Patra. ಶ್ರೀ ಹನುಮಂತಪ್ಪ ನಾಗಪ್ಪ ಸವಣೂರು ಸಹ ಹಾನಗಲ್ ಇವರು ಕಿಡ್ನಿ ತೊಂದರೆಯಿಂದ ಬಳಲುತ್ತಿದ್ದು ಸಿಕೆಡಿ ಸ್ಟೇಜ್ 5 ತಾಲೂಕು ಸಾರ್ವಜನಿಕ ಆಸ್ಪತ್ರೆ ಹಾನಗಲ್ಲಿನಲ್ಲಿ ಡಯಾಲಿಸಿಸ್ ಘಟಕದಲ್ಲಿ ದಿನಾಂಕ 7/8/2023 ಇಲ್ಲಿಯವರೆಗೆ ವಾರದಲ್ಲಿ 2 ಸಲ ಡಯಾಲಿಸಿಸ್ ಮಾಡಿಸುತ್ತಿದ್ದು ಆ ಪ್ರಕಾರ ದಿನಾಂಕ 15/3/2024 ಸಹ ಡಯಾಲಿಸಿಸ್ ಮಾಡಿಸಿಕೊಂಡಿರುತ್ತಾರೆ ಎಂದು ನೀಡಿದ ಪ್ರಮಾಣ ಪತ್ರ.
ಇದಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಆಗಿರೋದು. And the court had to write a 4-page order because of that. Issue notice to the respondents, returnable by 7th April. The further proceedings in OS number 264 of 2015, pending on the file of the civil judge and JMFC Angal, is stayed till the next date of hearing. A memo along with documents filed by the petitioner is taken on record.
Please, notes.
12 ML20.
Of mandamus lordship to determine compensation, pay compensation. Road 1 to 3 government, 1 to 3 and 10 and 11.
And AGA accepts notice for respondent number 1 to 3,
10 and 11.
10 and 11.
For B. Sharan Basav.
B. Sharanbasava for 4.
5 to 9 Shivsai M. Patil.
Our illa ansati ivaga. Matpati. BP Matpati.
Please.
For respondent number 5 to 9. Counsel for the petition furnished 2 sets of petition along with annexure on the said counsels. Released on 21st March.
Obliged. 21st
March.
Short date because 78 years.
Dates illa. Next year bartara amale nammun bike onkodu.
The team, Kode Nagaraj.
Yes, Mr. Nagaraj.
Lord, shops belonging to the second respondent, my lord, were given lease and lease to the petitioners, my lord. And my lord, the said shops, my lord, were demolished by the order passed by the respondent number 3 for widening the road. Thereafter, my lord, after shops, 22 shops, my lord, dimension of 11 into 22 feet, my lord, were constructed under the scheme introduced by the government of India, my lord. Thereafter, my lord, the petitioners were continued in the shops, my lord. Lord, the writ petitions were filed by the petitioners in WP number 3845 or 3849 of 1998 before this honorable court, my lord. This honorable court, my lord, were given certain directions fixing the my lord, rent for 2,900, 4,001.
Yes.
Thereafter, my lord, writ appeals filed by the second respondent before the division bench of this honorable court, my lord. Annexure A, your lordship, may kindly, my lord. Ink page 41, your lordship, may kindly.
Why are you before us?
Well, my lord, now, my lord, auction was being held. Auction, note, annexure F, G and H, my lord.
Participate in the auction.
My lord, your lordship, may kindly, my lord. Auction, we are prepared to pay, my lord, 10% of the present rate of rent, your lordship.
You are prepared does not help.
Please.
You can only participate in the auction and succeed in that, or exercise right to first refusal.
Lord, in the auction, the problem is, Lord, now, Lord, they are small petty businessmen.
98 in the idira, sorry, 88,
ಇಲ್ಲ 99
98 is your writ petition.
96 ರಿಂದ ಇರೋದು.
ಹಾ.
96 ರಿಂದ ಇದ್ದಾರೆ.
ಆಯ್ತು.
ಅಲ್ಲ ಈಗ ನಾವು
30 ವರ್ಷ ಆಗಿದೆ.
they have acquired good will for the
If you have that much goodwill, participate in the auction, Mr. Nath.
auction, Lord, because auction, if auction was held, Lord, on unhealthy competition, Lord, would
Unhealthy
arise.
ಅಲ್ಲ, healthy competition.
Unhealthy competition
That
would
is why
arise.
the circular has been issued in further direction of the court. That circular will be applicable now.
Lord, your lordship may kindly. First, petitioner number 1, Lord, is running a business, Lord. Retail cloth shop. And Lord, petitioner number 2 is running, Lord,
We can't pass
pesticides.
an order against the law. That law is being declared now. That circular has to be followed. That is what all the courts have done. And AGA accepts notice for respond number 1. Arapnalli yaro? 1 and 3. TMC Arapnalli. Hospete, Vijayanagara district Hospete. V. Shivraj Remat is directed to accept notice for respond number 2. Petitioner is before this court seeking for the following reliefs. The petitioners claim that they are lessees of certain shops constructed by respond number 2 by utilizing the funds made available by the central government under the IDSMT scheme.
Please.
Another IDSMT scheme.
Okay.
Vide endorsement dated 17/9/2024. The petitioner, it has been indicated by respond number 2 that an auction would be conducted in which the petitioner could participate if the petitioner wished to continue with the possession of the said lease premises, the auction being conducted in furtherance of the circular issued by the government bearing NIE 301 JEL 2017 dated 19/7/2019. The Sri Gode Nagaraj, Learned Counsel for the petitioner, submit that the petitioners have been in possession of the said premises from the year 1996 and as such are agreeable to increase the rent which is now being paid by 10%. And as such, in the above reliefs have been sought for, including a direction to the respondents to fix the rent of the premises and permit the petitioners to continue as lessees of the premises. This court in several matters has considered the applicability of the aforesaid circular and has come to a conclusion that it is for the lessee to act in terms of the said circular dated 19/7/2019, and if the lessees are interested in continuing with the lease period after the expiry, when an auction is conducted, the lessee could participate in the auction for the very same premises, and if successful, could continue in possession thereof as per the results of the auction. If the lessee were not to participate in the auction, the lessee would be entitled to exercise right of first refusal and make payment of 10% over and above the auction bid amount by the successful tenderer and continue with the possession of the premises. In that view of the matter, the interests of the petitioners are protected by the circular dated 19/7/2019, and the petitioner could exercise those rights as indicated therein. Needless to say, until then, the petitioners cannot be dispossessed. As such, I pass the following order. Writ petition is disposed, directing the respondents to permit the petitioner to exercise their rights in terms of the circular dated so and so, and until then, not to dispossess the petitioners.
14, Arvind D. Kulkarni.
That's IPF for petition. This is pertaining to the Town Municipal Council Gajendragarh, wherein there were around 23 councillors. A whip was issued on 2/9/2024. That came to be violated by 7 out of 18, 7 councillors violated the whip. Therefore, a complaint came to be filed on 6/9/2024. Maybe the dates are important. 6/9/2024 complaint was filed. My lords may kindly see the page number. Annexure B, page number 30.
30.
30.
Yes.
This was the complaint on 6/9/2024. This was given to respondent number 2. He forwarded it to the deputy commissioner for taking further action in the matter. Plus on 6/9/2024 itself. Plus the deputy commissioner directs the respondent number 2 after 3 months of receipt of the complaint. That is on 19/12/2024. That can be seen at page number 40, annexure D. The reference is at in annexure D.
The document is at annexure C.
Please, yes.
Yes.
Annexure C. Plus the act itself prescribes. May I pass on the within 24 hours, the executive officer has to forward it to the deputy commissioner. In turn, the deputy commissioner has to dispose of the application within 60 days. Section 4 may kindly be seen. Subclause 2. May I read? Where a complaint under subsection 1 is received by the chief executive officer of the concerned local authority, he shall within 24 hours from the receipt of such complaint refer the same to, for the decision to. Insofar as this case is concerned, subclause 2 may be subclause 3 may be reference in case of town municipal council.
Yes.
Thereafter, who shall decide the question within 60 days after the receipt by him of the reference, and his final decision shall be final. But here the case is that 6/9/2024 the complaint was filed. The notice itself was ordered to be served on the concerned persons after 3 months, that is on 19/12/2024, and date was fixed to appear on 2/1/2025. That can be seen at page number annexure
2/1/25 ಏನಾಯ್ತು?
Lots may kindly see the order sheet itself I have produced. He is consistently adjourning the matter. Page annexure E, page number 41. Though he was required to dispose of the reference or the complaint within 60 days from the date of receipt of the complaint. It's almost 5 months now.
You have been absent on 2 occasions.
My lords?
You have been absent on 2 occasions.
One occasion he was not present. Lords may kindly see on 2/1/2025.
23/1 not present.
2/1/25 was the first date. No, I'm not. My submission is that the reference itself could have not the.
Yes, that we agree.
The intention is.
You also should cooperate.
Please, not. The intention.
You have not been present.
No, only once he was not present. Not.
Learned AGA accepts notice for. Your notice ಹೋಗ್ಬೇಕಲ್ಲಪ್ಪ.
I'm seeking only direction to the respondent number 1. I'm not seeking any relief against the other respondents.
TMC Gajendragarh ಯಾರು?
TMC Naregal. TMC Naregal.
ನೀವು ಹೆಸರು ಹೇಳಿದ್ರೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು.
No, I inquired, but I'm only seeking insofar as respondent number 1 is concerned, I'm seeking for
direction.
Until
we serve them, how can we issue a direction?
I'm filing a memo for dispensation insofar as
to respond number 2.
3 to 9.
Respond number 2 ಹೇಳಿ first.
I'll serve. I have.
ಅಲ್ಲಿಂದ ಇಲ್ಲ
ಯಾರು I inquired, but nobody is informed.
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. ಅವ್ರ ನೋಟಿಸ್ ಹೋದ್ರೆ ಎಲ್ಲರಿಗೂ ಹೋದ್ರೇನು ಆಯ್ತು ಏನಂತೆ.
Insofar as 3 to 9 is concerned, I may be permitted to.
You serve them also.
AGA very purpose of disposing the matter within stipulated period.
Correct, but ಅದಕ್ಕೆ we are giving you the option. ಯಾರು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿ ಅಂತ.
I inquired lots, but
ಯಾರು ಇಲ್ಲ ಅಂದ್ರೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು. AGA for respond number 1, issue notice to respond number 2 to 9, returnable by emergent notice, returnable by
I may be permitted to serve by hand also.
21st March.
Allah.
Counsel for the petitioner is also permitted to take out hand summons on the said respondents and move the court after service of summons.
My request would be, but the very purpose is that because
Service
November,
ಮಾಡಿ move ಮಾಡಿ.
I'll serve by hand, I may
Adi.
permitted. March shall be. The moment I serve, I will may be permitted to move it.
ಅದೇ ಹೇಳಿದ್ದು.
Please, please,
ಕೇಳಿಸ್ಕೊಂಡಿಲ್ಲ ನಾನು.
please, I'm sorry.
15,
Next matter also same. Insofar as other municipalities concerned.
15 same order as
Please.
14.
16, Santosh Rao.
Yes.
Petitioners are assailing the order passed on application under 39(1) and 2, my lord, which came to be confirmed in the appeal.
ನಿಮ್ ಮುಂಚೆನೂ ಹೇಳಿದೆ ಸರ್ಷರರೆ ಅಂತ ಹಾಕಂಗಿಲ್ಲ ಅಂತ. ಅವತ್ತು ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಇವಾಗ ಮತ್ತೆ ಸರ್ಷರರೆ ಹಾಕಿದಿರ.
Sorry.
GMCPC is not 226, it is 227. Set aside.
Sorry, my lord.
Yes, ಹೇಳಿ.
My lord, the present respondent herein filed the suit for partition, my lord.
Hmm.
Thereafter, the petitioners are the purchaser of the property from the one of the joint family owner.
Hmm.
In the partition suit, they did not array as a party to the suit. The petitioner themselves have what implicated in the suit. Suit came to be decreed with granting 1/10 share. Thereafter, the matter attained finality in RSA.
ಇಲ್ಲಿದಾರಪ್ಪ ಅಡುಗಪ್ಪ ಭೀಮಪ್ಪ ಬಸಪ್ಪ ಅನಕ್ಷರೇ ತಾನೇ ಡಿಗ್ರಿ.
Yes, my lord.
They are not there. ಅಡುಗಪ್ಪ ಭೀಮಪ್ಪ and ಬಸಪ್ಪ.
They have not been arrayed, my lord.
Impleted ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
Later on, we filed RA.
ಹಾ, okay.
RA.
Hmm.
RA came to be confirmed,
Hmm.
the judgment of the trial court,
Hmm.
which we assailed in the RSA.
Hmm.
During pendency of these proceedings, without arraying us as a party, they have concluded the FDP and execution also. When we came to know about the execution, we filed the writ petition before this honorable court. This honorable court observed that when we are not the party to the execution, how we are aggrieved. Thereafter, we filed the injunction suit.
What is the finding of the RA court as regards your appeal?
My lord, my appeal came to be dismissed, saying that we should work out our remedies in FDP.
ಎಲ್ಲಿದೆ ಅದು?
RSA judgment allide.
Page?
Please, my lord. 93, my lord, wherein.
ಇಲ್ಲಿ 93 ಅಲ್ಲಿ ಏನಿಲ್ಲ ಅಲ್ಲ? Case of dispute relating. Not made out a case. Workout in FDP ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
Please, my lord.
There is no such liberty reserved.
Admittedly, they have not made us as a party in FDP either in EP, my lord.
FDP ಅಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಲಿಲ್ವಾ?
ಮಾಡಿಲ್ಲ. EP ಅಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ.
Yes, madam.
All along, this old lady has fought the litigation.
Yes, you should
She's
make
not
them
able to
party.
get the possession of the property in spite of the decree of the court. They are interfering with the possession. Police complaint kotu, they are not.
You
ready to
filed
meet.
this execution in the year 19. By the year 19, the RSA judgment had been passed where there were parties.
My lord, there was a miscellaneous
And
second
they
appeal
were
also.
defendant number of 6 to 9, 7 to 9 ಅಂತ ಹೇಳಿದ್ದಾರೆ. So they were
I will
allowed
have
to
it
be
tomorrow, my lord. I'll just have 1 or 2 instructions, that's all. We can dispose of the matter.
dispose, make them
Aye,
party
ma'am.
and proceed.
Have it. Nenne copies from. It can be disposed.
ಒಬ್ರೇನಾ ನೀವು? At the request of counsel for the response, release tomorrow.
Please.
17, Anandar Pally.
For the petitioners, my lords. My lords, I takes directly my lord's attention, page 20, my lords.
Yes.
This is, my lords, an issue, my lords, form number 2,
Hmm.
where
Hmm.
only one specific grounds, my lords. Kindly see, my lords, at the middle,
Hmm.
at the last, my lords. ಪ್ರತಿ ಪಂಚಾಯತಿ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ ಗ್ರಾಮ ಪಂಚಾಯತಿಯಲ್ಲಿ ಹಲಗ ತಾಲೂಕು ಖಾನಾಪುರ ಇವರಿಗೆ ಈ ಪತ್ರಕ್ಕೆ ಲಗತ್ತಿಸಿದ ನೋಟಿಸ್ಗಳನ್ನು ಸಂಬಂಧಪಟ್ಟವರಿಗೆ ತಕ್ಷಣವೇ ಜಾರಿ ಮಾಡಿ ರುಜು ಪಡೆದುಕೊಂಡು 2 ದಿನಗಳ ಒಳಗಾಗಿ ಸದರಿ ವರದಿ ಸಿಕ್ಕದು ಅಂತ ಸದರಿ ಸಭೆಯ ದಿನದಂದು ವೈಯಕ್ತಿಕವಾಗಿ ಹಾಜರು ಇದ್ದು ಎಲ್ಲಾ ಕಾರ್ಯಕಲಾಪಗಳನ್ನು ಸರಿಯಾಗಿ ನಿರ್ವಹಿಸತಕ್ಕದ್ದು. The assistant commissioner, my lords, having no jurisdiction.
He needs assistance of the PDO.
No, he cannot alter, my lords, in the form. He cannot add or he cannot subtract anything in the form number 2.
He is only this is administrative direction. That ನಾಲ್ಕು ಪಿಯೋನ್ ಬೇಕು, PDO ಬೇಕು, ಇವ್ರು ಇರಬೇಕು, so that ಎಲ್ಲ ಕಾರ್ಯಕ್ರಮಗಳು ಸರಿಯಾಗಿ ಆಗಬೇಕು ಅಂತ.
He can make a separate order for that purpose. My lords, where, my lords, the law stipulated, my lords, that, my lords, the form number means the form number then. Where, my lords, either in the form number 1 or the form number 2.
If form 2 is given, all those details are available. This is only an administrative direction. He could have done it separately or he could have done it together.
When kindly say, my lords, that where, my lords, the definition, my lords, is specifically submitted as a form. If the definition does not prescribe in the rule, that the form means the prescribed form has standards separated, my lords, in the rules.
Yes.
Where, my lords, here, my lord, that he cannot alter in the administrative capacity, my lords, he cannot alter the form number 2 as such.
Yes. ಆಮೇಲೆ
where, my lords,
ಆಯ್ತು Mr. ಕೊಳ್ಳಿ.
Yes.
You have not taken care of them. All these matters we are telling you the same thing. If you had done your job properly, they would have supported you.
Yes.
You can't be continuing like this. You will be creating more bad blood.
No, not.
ನಿಮ್ ಅಗೇನ್ಸ್ಟ್ ಇರ್ತಾರೆ, ಇನ್ನ ಅಗೇನ್ಸ್ಟ್ ಆಗ್ತಾ ಹೋಗ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನಿಮ್ ಚಾನ್ಸೇ ಇಲ್ಲ.
Where, my lords,
Learned AG accepts notice for respond number 1 and 2. Gram Panchayat, Alaga, Khanapur. Belgavi. Sadiq Gudwala is directed to accept notice for respond number 3. Notice to respond number 4 to 10 is dispensed with the new of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. The petitioners are aggrieved by the notice in form number 2 issued in furtherance of sub-rule 2 of rule 3 of the rules of 94, fixing the date of meeting for considering the no confidence motion as 1/3/2025 at 12 noon in the office of the Gram Panchayat. The submission of Shri Anand Arkolli, learned counsel for the petitioner, is that the notice in form number 2 is not strictly in accordance with form number 2, inasmuch as there is an endorsement made at the end of the notice directing the Panchayat Development Officer to be present during the course of the meeting and to ensure that all the actions taken during the meeting are carried out without any hindrance. The submission of Shri Anand Arkolli is that no such endorsement could have been made or no such endorsement or instructions could have been issued in form number 2. By such instructions being issued, the very form number 2 has undergone a change and has been undergone an alteration which is not permissible. There cannot be any addition or deletion in form number 2. The addition which has been made would render the said notice under form number 2 non-est and violative of sub-rule 2 of rule 3 of the rules of 94. Ashtella?
Yes.
heard so and so. The notice in form number 2 at Annexure C is reproduced hereunder for easy reference, page 20. The perusal of the notice indicates that it is under form 2. The subject has been mentioned. So also the references which have been mentioned in relation to the earlier litigation and the notices which had been issued. The body of the notice details out the date on which the meeting is to be held, the time at which the meeting, date and time at which the meeting is to be held, and the location thereof. The same being signed by the Assistant Commissioner, the addressee is at the bottom, the addressee's name is at the bottom of the page. Till this stage, the entire notice is in accordance with form number 2. The grievance of the petitioner is in respect of the instructions which have been incorporated in said notice at the end of the aforesaid form 2. ಇದು ಆಫೀಸ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಅನ್ಸುತ್ತೆ, ಅಲ್ಲಿ ಮೇಲೆ ಸಹಿ ಇದೆ, ಸೆಕೆಂಡ್ ಅಲ್ಲಿ ಫುಲ್ ಸಿಗ್ನೇಚರ್ ಇದೆ. ಇದು ಎರಡನೇದು, ಇದು ಮೊದಲನೇದಲ್ಲ. ಇದು
ಸೆಕೆಂಡ್ ರೌಂಡ್ ಮೈ ಲಾರ್ಡ್ಸ್.
ಸೆಕೆಂಡ್ ರೌಂಡ್ ಅಲ್ಲ, ಫಸ್ಟ್ ನೋಟಿಸ್ ಇದೆ.
ಎಸ್
ಇದು ನಿಮ್ ಪಿಡಿಒ ಇಂದ ಇಸ್ಕೊಂಡು ಬಂದಿದ್ದೀರಾ?
ನೋ ನೋ. Where my lords, where Assistant Commissioner, it is a signature of Assistant Commissioner.
ಮೇಲೆ ಸಹಿ.
That is a, and the second
actual signature ಇದೆ.
Yes, that
so
is.
ಮೇಲೂ ಒಂದು ಸಿಗ್ನೇಚರ್ ಆಗಿ ಒಂದು ಆಗಿರ್ಬೇಕು.
ಇಲ್ಲ
ಇದು ಸಪರೇಟ್ ಆಗಿ ಒಂದು ಪಿಡಿಒ ಕೊಟ್ಟಿದ್ದಾರೆ.
No.
Anyway,
yes.
As regards the instruction which have been issued at the end of this thing, the instructions are to the PDO who is in charge of the panchayat to facilitate a proper meeting to be held, and that the activities are conducted without any hindrance. These instructions being in the administrative capacity of the Assistant Commissioner, directing the PDO to hold the to facilitate the conduct of the meeting in a proper manner, in my considered opinion, does not in any manner alter the notice in form number 2, where all the details which are required to be conveyed to the addressee have been so conveyed. The administrative instructions by the Assistant Commissioner could have been issued separately also. The fact that they are included in the notice in form number 2 would not in any manner take away the meaning and purport of form number 2, whose intention is to convey the details of the time, the date, time and location of the meeting to be held to consider the motion of no confidence moved by the elected representatives. The petitioner being provided with all the requisite details cannot have any complaint as regard the administrative direction issued by the Assistant Commissioner to the Panchayat Development Officer to facilitate the meeting. No grounds being made out, the petition stands dismissed.
18.
ಇದನ್ನೆಲ್ಲ ರಿಪೋರ್ಟ್ ಮಾಡುವಂತೀರಾ? ಎಲ್ಲ ಒಂದೊಂದು ಪಾಯಿಂಟ್ಗೂ ರಿಪೋರ್ಟ್ ಮಾಡೋದು ಏನಪ್ಪ ಇದು? ಇಲ್ಲ, ಕಲ್ಸೂರ್ ಮಟ್ಟ ಹೇಳಿ, ನೀವಲ್ಲ. ರಿಪೋರ್ಟ್ ಮಾಡಿ ಕಂಪೈಲೇಷನ್ ಮಾಡಬೇಕು ಅಂತ.
Tomorrow another matter, but very interesting.
ನಾಳೆ ನೋಡೋಣ.
Yes. Really,
if there is a case, we'll interfere.
18. Sharmila M. Patil.
In this, my lords, the lands of the respondent, my lords, was acquired for housing project, my lords. And the landowners, my lords, challenged the notifications by filing the writ petitions, my lords. When the writ petitions were pending, my lords,
judgment of 17.
A resolution was passed in the board, my
441
lords.
days delay.
441 days. My lords, when the matter was-
KHB na?
KHB.
KHB ಬಹಳ ಬ್ಯುಸಿ ಇರ್ತಾರೆ.
My lords,
ಮೊನ್ನೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಒಂದು UP ಒಂದು ಹೇಳಿದ್ರು, we admire the courage of the officer to have filed an appeal with 300 days delay ಅಂತ. So ನಿಮ್ courage ni ಇಷ್ಟ admire ಮಾಡ್ಬೇಕು 441 days. Yes.
My lords, and
ಅದು review.
my lords, the writ petition was filed, my lords, challenging the notifications, my lords, by the landowners. And in the meantime, my lords, the resolution was passed by the board, my lords, stating that if the landowners agree for 60-40 sharing ratio, my lords, the scheme would be, the layout would be found, my lords. But
Yes.
they didn't agree. And this honorable court, my lords, based on the resolution, my lords, disposed of the, allowed the writ petitions, my lords. And the similar, in the similar circumstances, my lords, the surrounding landowners also had preferred other writ petition, my lords. That petition also was allowed, my lords. And the board, my lords, filed writ appeal, my lords, challenging the order of the single judge, my lords.
Yes.
Those writ appeals were allowed, my lords. And the landowners preferred SLP before the Supreme Court, my lords. There, the Honorable Supreme Court has upheld the order of the High Court, my lords. I have filed the orders of the, at the last time.
Yes. What do you want to be reviewed in this?
Now, my lords, if the matters are restored, my lords, writ petition, there could be writ petitions, my lords. If they are restored, my lords, they would be heard on merits, my lords, along with the other writ petitions which are restored.
This order is on merits at page 10. Everything has been considered and writ petition is allowed, preliminary notification is quashed.
In the same, on the same circumstances, my lords, the surrounding landowners also had preferred the, and that order is also on merits only, my lords.
You can't
Their
ask for a
lordships-
review. Review has to be, 47 has to be complied. You can file an appeal if you want. Review ಹೆಂಗ್ ಬರುತ್ತೆ?
Because review, in those matters also, review was filed and they were disposed of.
ಅದರಲ್ಲಿ it was,
Appeal
matter
10
was remanded.
Pardon, my lord, 100266, my lords. In writ appeal number 100266.
Yes.
On the last date, my lords, I have submitted the.
Yes.
In that also, my lords, it is a surrounding landowner, my lords, wherein the writ appeal was allowed, my lords. The notifications which were quashed, my lords, were set aside and writ petitions restored on file, my lords.
Those matters were remanded to the single judge.
Single judge, my lords.
ಏನಾಯ್ತದು?
They are pending, my lords.
You are saying that was by concession.
No, my lords, the same resolution, same village.
That matter which went up before the writ appeal court in
My lords, I've got the order of that.
100266 of 2021, Your Worship.
My lords, that order in WP
Writ petition order
64471, I have got the order of.
writ petition order.
The
Because
same
the
notification.
finding recorded by the division bench is that the writ proceedings were disposed of recording concession made by learned counsel who appeared on behalf of the KHB.
The order,
ಇಲ್ಲಿ
my
ಏನ್
lords.
concession ಏನು ಕಾಣಿಸ್ತಾ ಇಲ್ಲ ಇಲ್ಲಿ.
ಏನಿಲ್ಲ, my
If it is
So
a
merits
wrong
ಅಲ್ಲಿ ಇದೆ.
concession, wrong concession ಇದ್ರೆ ಅಷ್ಟೇ ಇದೆ, otherwise no, it cannot be.
ಇಲ್ಲಿ ಕನ್ಸೆಷನ್ ಬಗ್ಗೆನೇ ಇಲ್ಲ. ನೀವು ಇಬ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದೀರಾ, it has been taken into consideration and the order has been passed
My
on
lords,
merits.
My lords, I have just passed over the order, my lords. It's the same village, same resolution, and the same set of facts, my lords. There also the landowners has challenged the 4-1 notification, my lords.
ಅದೇ ಪ್ಯಾರಾ 5 ಅಲ್ಲಿ your concession has been recorded. concession of the council for the housing board was recorded in para 5 and the orders were passed. This is not an order passed on concession. Concession ellide illi.
The same notification, my lords, same village and same notification.
ಅದಕ್ಕೆ 26 litigation irutte. Everything cannot
My
be
lords,
like that.
The order is passed based on 812 resolution, my lords, in both the cases.
Yes, madam, but this is both of you, the AGA had also argued, the council, who was the council?
Para 10 euros. AGA has made a submission.
ನೀವೇ ಇದ್ರಿ, ನೀವೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದೀರಾ, ಕನ್ಸೆಷನ್ ಇಲ್ಲಲ್ಲ.
In those matters also, my lords, in 64461 also argument were put forth, my lords, in those matters also.
ಎಲ್ಲಿದೆಯಮ್ಮ?
Matters were heard in those matters also, my lord.
He fairly submits that petition have not agreed, fairly submits that the board has not deposited compensation. Therefore, the board has no objection in allowing the writ petition.
It's the same in this matter also, my lords. Is the same.
ಎಲ್ಲಿದೆ? Show us where the concession is. ನೀವು same ಅಂದ್ರೆ ಆಗಲ್ಲ. It is not same. This won't apply.
My lords, para 6, my lords, at page 15, ink page 15 of the review petition, my lord.
Para 6 of the review petition.
Please, my lords,
Yes.
15, ink page 15. Para 6, my lords. I am permitted to read, my lords. Further, the learned advocate for the petitioner has filed copy of the resolution dated 8/12/16 passed by the board.
That is their argument. Where is your concession?
Please, my lords. 10, my lords.
Para 9.
9, my lords. The learned counsel appearing for the housing board submits that the board has filed its
Board is
detailed statement
respond
of
number
objections.
1. ಒಂದು ನಿಮಿಷ ನಾವೇ ಓದ್ಬಿಡ್ತೀವಿ.
Please.
ನೀವು ತೋರ್ಸಲ್ಲ ಅಂತ. So the petition may be allowed and so on. You are contended at para 9, that detailed statement of objection denying the case of the petitioner inter-alia contending that the acquisition proceeding are in accordance with law. Master has been produced, final notification has been produced. You argued the matter.
Please, my lords. Even in
It's
the,
not concession.
even in 644 also, my lord, writ petition, that there also the same
Madam,
argument was put forth, my lord.
Not only for that, we'll have to impose additional cost for this, for wasting time. Illi, therefore,
Para
para
12.
5 alli.
Para 12 also of this order, my lords, it's also
Madam,
not in
please come
dispute.
to para 5 of the order in 64471. The counsel for the board, therefore he submits, the board has no objection in allowing the writ petition. That is the concession. This is on merits. Merits and concession, bada difference is there.
And 12, my lords, in this para 12, it is also not in dispute that the housing board in its meeting.
That is on a consideration on merits by the court, not because you conceded. You made the court write 10-page order by arguing, which has been considered. Now you are saying concession. Third, petitioner housing board.
My lords, I may
Is before this
permitted,
court.
my lords, I may permitted to withdraw the review petition, file writ appeal, my lords, with liberty to file writ appeal.
You issue fresh notification. You can't go with the old notification of yav year idu.
14.
2010. Now they have withdrawn the amount also.
ಯಾರು?
KHP ಅವರು. That deposit by the, may just pass on this. They have sent a letter to the.
ಅಲ್ಲಿ
Those
ಕನ್ಸೆಷನ್
matters-
ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ ಇಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಏನು, ವಾಟ್ ಇಸ್ ದ ಇಂಟೆನ್ಷನ್ ಆಫ್ ಯುವರ್ KHB?
Because this review petition may kindly be connected with this.
No, we can't connect it.
Appeal, my lord. Today they are posted, my lords. The same
Withdrawal
writ
or dismissal?
Pardon, my lord?
ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ರೆ ಡಿಸ್ಮಿಸಲ್ ನಾವು ಆರ್ಡರ್ ಮಾಡ್ಬೇಕಾ ನೀವು ವಿಡ್ರಾ ಮಾಡ್ತೀರಾ?
But it may be connected with serial number 88, my lords. Same.
Petitioner is before this court seeking for the following reliefs. The only ground on which a review of the order dated 5th June 2017 in WP number 109564 of 2014 is sought for is on the ground that the said order has been passed on a concession made by the counsel for the KHB, and in this regard, reliance is placed on the judgment of the division bench of this court dated 26th May 2023 in WA number 100266 of 2021, whereunder the writ petition subject matter of that writ appeal, namely WP number 64471-64477 of 2012 and other connected matters were remanded to the single judge for fresh consideration. A perusal of the order dated 5th June 2017 in WP number 109564 of 2014 does not indicate that the said order has been passed on a concession made by the counsel for the housing board. In fact, the housing board has at para 9, the arguments addressed by the housing board has been recorded in para 9 of the aforesaid order, where the housing board had contested the claim of the petitioner. This contest made as rejected by this court by a reasoned order. Therefore, the said order is not one on concession requiring the application of the decision in WA number 100266 of 2021. No grounds being made out, the above petition stands dismissed on merits. IA 1 of 2018 filed for condemnation of delay of 4 and 41 days. He is allowed accepting the statement made therein, subject to payment of cost of rupees 10,000.
That's cost.
Aವಾಗ 5,000 ಹಾಕಿದ್ರೆ ಇವಾಗ 10,000 ಹಾಕಿದ್ರೆ
The
10,000
board, my lords.
payable to the
My lord, it's the
respondent
board, my
number,
lords.
payable together to respond number 1 to 4 at the rate of 2,500 rupees each. ಆಮೇಲೆ ನೀವು 40,000 ಅಂತ ಹೇಳ್ಬೇಡಿ.
My lords, cost ಬೇಡ, my lords.
19, Srivatsa Hegde.
ಸಂಗ್ರಾಮ್ ಯೋರಿಯರ್, ಶ್ರೀವತ್ಸ ಹೆಗ್ಡೆ ಇಬ್ರಲ್ಲ?
ಹೌದು.
ಎಸ್. ಯಾವ್ದು ತಗೊಳ್ಬೇಕು?
Lord, the first one is related to
They
the
are
rejection
taking
of my
what-
IA.
Which petition do you want us to take up? There are three
Both of them, they will go together, my lord.
Which papers do you want us to take up, Mr. Hegde?
No, the ones filed by Sangram.
ಸಂಗ್ರಾಮ್ ಅದು ಎರಡು ಹಾಕಿದ್ದಾರೆ.
ಎರಡು ಹಾಕಿದ್ದಾರೆ.
ಯಾವ್ದು ತಗೊಂಡು?
Because there is common order.
ಯಾವ್ದು ತಗೊಂಡ್ರೆ ಸೇಮ್ ಪೇಪರ್ಸ್.
ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿದ್ರೆ ಅದ್ ಹೇಳಿ. ಪೇಜ್ ನಂಬರ್ ಮ್ಯಾಚ್ ಆಗ್ಬೇಕಲ್ಲ.
859.
859.
859.
Yes.
Now, to put it in a nutshell,
This
my
is
lord,
filed by Sangram. So
Yes,
you'll have to argue.
yes.
Yes. Now, my lord, I am the petitioner in that older writ petition.
Now we are taken
I'm
859.
just narrating, that's all.
I will-
Oh,
this is
okay, I
right to
will, he
start.
will, yes.
That is why which petition? If you have a petition, you had the right to start.
Yes.
Yes.
My lord, this is a defendant's writ petition, my lord.
Hmm.
Plaintiff filed the suit seeking the relief of bare injunction, saying that the defendant should be restrained by an order of injunction from he performing or they performing the puja of the temple, my lord. And second is the relief that no one else should be appointed as trustees and they should be appointed as trustees, my lord. These are the two reliefs which have been claimed, my lord. My lord, the suit was filed in the month of June 2018, and on 28/5/2018, the very same plaintiffs, they file a miscellaneous application before the district court to appoint themselves as the pujaris of this temple, my lord.
3 and 7.
Yes, my lord. That is dated 28/5/2018. The cause of action for filing the present suit is also shown as 28/5/2018 and 6/6/2018. My lord, they say that on 28/5/2018, they were restrained from performing puja, and therefore they have filed this suit, and the same continued on 6/6/2018 also. And the cause of action has been shown, my lord, in para 11, page number 23, my lord.
What is challenged is the injunction order. Is it?
Injunction order, my lord.
Yes.
My lord, in para 10 of the plaint, which is found on page number 22, they say that what type of loss will cause to them has been pleaded in para number 10, my lord, page 22.
Yes.
The plaintiffs submit that they render spiritual services to Lord Kapleshwar and other deities around the temple, and they accept the offerings from the general public, and this has become the main source of income to the plaintiff. Other than this, the plaintiffs have no other source of income. Since the defendants are interfering with the services of the plaintiffs to deity, the income of plaintiff is adversely affected, causing loss and hardship to the plaintiff. My lord, the main grievance of the plaintiff is that if an injunction is not granted, it would affect their income, and they are performing puja with the only intention that they should get income from this puja, my lord.
Yes.
My lord, if the other recitals of the plaint are seen, they say that their father was the pujari, and he died in the year 2003.
Yes.
And they claim that it is a hereditary pujariship, and they have continued to be pujari, and they have made allegations against the defendants saying that they are trying to interfere with the day-to-day performance of puja, my lord. My lord, if the entire averments are looked into, they themselves plead that there is a trust which is registered under the provisions of Bombay Public Trust Act. They don't implead the defendant, the trust, or the other trustees of the said public trust as defendants to the present suit. They have filed this suit against these 5 defendants.
So the latest list of trustees is at page 18.
Yes, my lord.
Or they are not.
They are not made as a party. Trust is not made as a party. They choose these 5 persons against whom they want to file the suit, and they say that they are not concerned with the trust, and they claim that they are the devotees of the temple, and therefore they are trying to interfere with their puja, and they are seeking the relief of injunction against these persons, my lord. My respectful submission is, as far as the relief which has been claimed is relating to performing puja, they have not sought for the relief of declaration, saying that they are the hereditary pujaris or they are performing the puja. And with
who are you?
My lord, that is what I am the member of the 15 members committee which has been appointed by the district authorities to administer the day-to-day management of the temple. We are the members of that committee, my lord. The entire committee is also not made as a party to the proceedings.
Where is the order appointing you?
My lord,
No such order.
no, that I will produce, my lord, because in the other writ petition, in the other writ petition it was produced, which is disposed of by this honorable court on the. No, I will.
My lord, this is not pleaded either in the trial court or in the first appellate court. For the first time, it is being alleged that there is a committee.
No, my lord, it is pleaded. It has come in the from para number 60 of the impugned order may kindly be seen.
Where is the pleading?
Yes, ma'am.
Where is the pleading?
Yes. My lord, page number 27 is the written statement.
Hmm. It starts.
Para number 8, page number 32, my lord.
Yes.
The averments contained in para 8, 9 and 10 are false and baseless, and these defendants emphatically refute the same. It is absolutely so and so to allege that from 28/5/2018, these defendants are interfering in the services rendered by to the Kapileshwar temple, and they have hatched a plan to take entire control and administration of the said temple for their personal gains. It is how to pronounce, I am not able to allege that the plaintiffs tried to convince these defendants, and these defendants asserted that plaintiffs have no right to perform puja and other religious rituals in
You filed a suit for declaration.
No, my lord.
Denied the allegation. Said that you have filed a suit in 582 for declaration. Where are you claimed that you have been appointed by the deputy commissioner?
My lord,
And committee constituted. It's not pleaded anywhere.
no, my lord, these contentions can be looked into because in the miscellaneous appeal that was filed, in the miscellaneous appeal, those contentions were taken, and in the impugned order, page 60.
Where have you contended that? Torsi?
Yes, my lord.
In MA early there.
In MA, page number 142, my lord.
140?
142 of the present writ petition.
Yes.
My lord, directly if we come to para number 62 on 144, my lord, the defendants contended that BPT Act was repealed on 30/4/2003. The trust is not registered under any other act of government of Karnataka. Hence, plaintiffs are claiming to be the legal representative of deceased Kashinath, who was hereditary.
Show us where that appointment made. That's all.
Yes.
My
lord, as far as that letter is concerned, I have not produced it along with this writ petition, my lord.
Pleaded it. You have not produced it. You are only arguing it.
I will produce it before I complete my.
In a writ petition after suffering 2 orders. You produce it and let the suit be decided on merits.
My lord, my respectful submission is, it is the plaintiff who has to decide on his own strength, my lord. He cannot rely on the weaknesses of the defendants. It is for the plaintiff to show that they are the pujaris of the temple. They claim that they are the hereditary pujaris of the temple.
Yes.
My lord, they have not produced any records to show that they have been appointed as the pujaris of the temple or they are performing puja of the deity, my lord.
This is an order dated 7th August 2018.
Yes, my lord. That was challenged.
The injunction has been operating from 7th August 2018 till date.
My lord, that was stayed in miscellaneous appeal.
No. Conduct the trial and dispose.
My lord, my respectful submission is, on the basis of this order, he is now trying to claim that he is the pujari of the temple, my lord. At no point of time, because on day-to-day basis, we have a CCTV camera which has been fixed to record who is actually performing puja, my lord.
Evidence of trial.
My lord, now on the basis, because my respectful submission is, let the status quo order be passed. If he is really performing puja, let him continue performing puja, my lord. Here, on the basis of this order, now he is trying to claim that he is the pujari of the temple, my lord. That is what the court says, that these aspects cannot be decided in miscellaneous appeal, and it requires full-fledged trial, and therefore interim order that was granted by the trial court has been continued. My submission is, my lord, he has not produced even a single piece of paper to show that he was or they have been appointed as pujaris.
7 years ಅಲ್ಲಿ ಟ್ರಯಲ್ ಆಗಿ ಎಲ್ಲ ಮುಗಿದೋಗಿರೋದು. 2000, the suit is of the year 2018, injunction is on 7th August 2018, which continued confirmed by the MA court. ಇವಾಗ ಏನಿದೆ, pleadings are complete?
Pleadings are complete, my lord.
Evidence ಶುರು ಆಗಿದೆಯಾ?
ಆಗಿಲ್ಲ. Pleading, ಇನ್ನೂ ಎವಿಡೆನ್ಸ್ ಆಗಿಲ್ಲ.
When will you start evidence?
ಆಗಿಲ್ಲ.
Plaintiff's evidence is recorded.
Recorded. Cross-examination?
Posted for the cross-examination of the plaintiff.
In evidence ಎಷ್ಟು ದಿನ ಆಗತ್ತಪ್ಪ? 6 months evidence will get to, another 6 months the suit will get.
Yes.
Disposed. How can we disturb something of 2018?
My lord, my submission is the suit itself is not maintainable without seeking the relief of declaration.
All that are open to you. After 7 years, do you think we should change the status by making it status quo?
No, my lord, he is not at all performing puja, and if he really is performing puja, no one
You
can
continue performing puja if he is not performing. Injunction is of no use.
Yes.
We don't need to say those
Yes,
things, Alva. You understand.
No, my lord,
In the connected writ
This we
petition,
are dismissing.
yes, my lord. Now,
We'll come to that one next.
yes, yes.
Petitioner is before this court seeking for the following reliefs. Respondents had filed a suit. Respondent 1 and 2 had filed a suit in OS number 688 of 2018 seeking for the following reliefs, page 24. In the said suit, the petitioners, respondents had also filed the interlocutory application IA1 under Order 39, Rule 1 and 2, seeking for the following reliefs, page 37. The trial court, on considering the said application, while its order dated 7th August 2018, Ellie, where is that order? Allowed the same in terms of the following, page 90. Challenging said order, the petitioners had filed a miscellaneous appeal in MA number 70 of 2018 before the second additional senior civil judge and CJM Belgavi, who had by way of his order dated 7th August 2024.
and the other MA was preferred by the other defendants, my lord. So,
The 2 IAs being rejected.
2 IAs.
That will come to in the other petition.
no. Two miscellaneous appeals were preferred by different defendants, my lord.
Yes. Came to be dismissed. It is challenging same, the petitioner is before this court. It is also required to be mentioned here that the plaintiffs had filed 2 other interlocutory applications. In IA number 2, seeking for injunction restraining the defendants therein from forming any new trust illegally with regard to the Lord Kapileshwar Mahadev temple. And IA number 3, on the IA, for protection of the plaintiffs, for direction to the CPI Kade Bazar police station to give protection to the plaintiffs while conducting the daily pujas and religious rituals to Lord Kapileshwar Mahadev and other deities. Those 2 applications were rejected by the trial court by the aforesaid order, aforesaid alla, by a separate order, by separate orders dated 7th August 2018. And were challenged by the plaintiffs in miscellaneous appeal number 82 of 2018.
No, my lord. My lord,
ಅದ್ಯಾವ್ದದು?
order on I number 2 is not challenged. It has already attained finality, my lord.
3?
This is challenged in the writ petition before this honorable court in the of the year 2018, my lord.
So what is this miscellaneous appeal 82?
My lord, there were 5 defendants. 3 defendants preferred MA number 70 and other 2 defendants preferred MA number 82.
ಅಷ್ಟೇ.
ಅಷ್ಟೇ.
ಅಲ್ಲಿ ಮೇಲೆ defendant number 5 and 4 filed miscellaneous appeal number 70 of 2018 and defendant number 1, 2, 3 filed miscellaneous appeal number 82 of 2018, both of which appeals came to be dismissed by order dated 7th August 2024. The miscellaneous appeal court, after examining all the matters and the contentions, by a detailed order of 65 pages, had held that there was a prima facie case made out by the plaintiff and irreparable injury would be caused to the plaintiff if an order of injunction was not granted. The miscellaneous appeal court came to a prima facie finding that the plaintiffs, being the sons of Kashinath, was performing puja at the Lord Kapileshwar Mahadev temple. The plaintiffs were also entitled to perform the pujas and that the defendants could not interfere with the same. The order of injunction, it is challenging these orders of the trial court and the first appellate court that the defendant number 1, 2 and 3 are before this court. Are the 4 and 5 ada? No, no.
4 and 5. 4 and 5, the other writ petition.
919.
How?
There are 19.1 and 19.2 common order are before this court in WP 106859 and defendant number 4 and 5 are before this court in WP 106919 of 2024. The submission of Shri Sangram Kulkarni, learned counsel for the petitioners, is that the plaintiff has to stand on his own feet and ought to have established that the plaintiff has been performing puja. Mere suit for injunction was not maintainable. The plaintiffs had to seek for a declaration that they were the pujaris stroke archaks of Lord Kapileshwar Mahadev temple. Those relief not having been sought for, the question of an injunction, only a bare injunction being sought for, injunction ought not to have been granted to the plaintiffs. His further submission is that the plaintiffs are not performing the pujas and as such, the claim that they are performing pujas has been wrongly construed by the trial court and the first appellate court. Lastly, he submits that the defendants 1 to 5, who are the petitioners in both the above petitions, have been appointed by the deputy commissioner to administer the temple, and as such, they are not third parties or devotees as contended by the plaintiffs, but are persons interested in the administration of the temple.
Another point, my lord. Injunction can be granted only when there is no loss if they cannot be compensated.
Lastly, he submits that the plaintiffs themselves in para 21 having contended 10 of the page 21, para 10 of the petition of the plaint, having contended that the loss which is being caused to the petitioner is on account of the income by performing pujas, that income being measurable in terms of money, it cannot be said that an irreparable injury is being caused to the plaintiffs requiring an order of injunction. As such, any injury compensatable in terms of money, there is no requirement of an order of injunction to be passed by the trial court or the first appellate court. Heard so and so. The suit was filed in the year 2018, and the first order of injunction was passed on 7th August 2018, which has continued to be enforced till today. On inquiry as to what is the status of the suit, Shri Srivatsa Hegde, learned counsel for the respondent who are the plaintiff, respondent 1 and 2, who are the plaintiffs before the trial court, submit that evidence has been led by the plaintiffs and the matter is posted for cross-examination. That being the status of the suit, I am of the considered opinion that it would be required for all the issues to be thrashed out during the trial having already commenced. Be that as it may, the contention of Sri Sangram Kulkarni would also have to be addressed. Inasmuch as the contention that the defendants are part of the committee, administrative committee appointed by the deputy commissioner, there is neither any pleading in the plaint nor any document which has been produced before the trial court, the first appellate court, or this court. Hence, that contention cannot be taken up before this court for the first time. If at all the defendants are appointed by the deputy commissioner, it is for the defendants to produce the said documents before the trial court, which shall be considered by the trial court on merits. Insofar as the question of the injury being compensatable in terms of money, the allegations made, a reading of the entire plaint indicates that it is a right to perform the pujas which has been agitated by the plaintiffs. A reference being made that a loss is being caused to them on account of loss of income by not performing the puja is only one of the grievances of the plaintiff. That is not the sole grievance. As such, the right claimed is a right to perform the pujas, and the incidental thereof being a right of earning money by performing the pujas. I am of the considered opinion that the same would not be a injury which can be compensatable in terms of money, and as such, the order of the trial court and the first appellate court in this regard are sustained. As regards the contention of Shri Kulkarni that the suit for bare injunction is not maintainable, a suit for declaration had to be filed, I am in the considered opinion that there is no title to any property or the like which is claimed by the plaintiff. The plaintiffs claim that they have been performing pujas and have only sought for injunction, restraining interference with the puja. The said claim would be applicable, would have to be established during the course of trial that the plaintiffs have been performing puja and there is obstruction by the defendants. The contention of Shri Kulkarni that the plaintiffs are not performing pujas would also have to be established. Not performing pujas and the pujas are being performed by persons appointed by defendants.
By the trust
could also be established by the defendants in the said suit during the course of trial, and at this stage, the said contention cannot be accepted. More so as indicated above, the order of injunction being in operation from 7th August 2018, I am of the opinion that the same cannot be disturbed after nearly 7 years. After the same being in operation for nearly 7 years. Both the above, no grounds being made out, both the above writ petitions stand dismissed. One more temple that we can't go to now. Yes, 19.
Lord, this is directed against my Lord rejection of my application seeking police protection after having won an interim order of injunction The defendants insisted that they are not going to allow me to perform pujas. Therefore, I made a request, my lord, that police protection be extended for enforcement of that injunction order. The trial court was of the opinion, my lord, there cannot be an omnibus protection in that form, and therefore rejected my application, saying for throughout the period of suit, there can't be police protection provided.
Yes.
Now that could have been, my lord, modified or otherwise, my lord, he insists that he is going to, now he claims that he has a right to interfere in the, now after having secured an order of injunction.
Again, the same thing, 7 years, there is no order. Now police protection.
Allah, for
cannot be
7
ordered.
years I have suffered, my lord, because all these years, now I am selling.
Finish the trial fast. ಅದರಲ್ಲಿ ಇನ್ನೊಂದು ಹಾಕೊಳ್ಳಿ. The submission of Srivatsa Hegde, the counsel for the plaintiffs in the suit, appearing for the plaintiffs in the suit, and the submission of Sri Sangram Kulkarni, the counsel for the defendants in the said suit, appearing for the defendants in the said suit, that they will cooperate with the trial court for expeditious disposal of the suit and would not take any unnecessary adjournments, is placed on record. The trial court is directed to consider to dispose of the suit as expeditiously as possible, taking into consideration the prevalent workload of the said court.
My grievance is, my lord, this order of injunction should not remain an illusion for me, because I am driven to selling coconuts and incense sticks outside the precincts of the temple.
You are performing puja or not performing puja?
He is preventing me daily, my lord. That is why.
If the injunction is not 39(2)(a.
Allah, I have been performing until I had to seek intervention of the civil court, my lord. But he insists that he has a right to prevent me from performing puja.
Mr. Hegde has rightly observed by the trial court, they can't park a police van outside the temple.
I don't need, my lord, every day. Let him undertake that he will not do it, my lord.
Every day you will go. He is stopping. You will go in the morning,
Now,
afternoon, evening.
My lord, this syndicate is headed by a corporator. I am a lesser mortal. I am just a pujari.
You establish your rights there.
But there is an order of injunction that, my lord, that should not be frustrated, is what my.
In 7 years, now police protection cannot be granted.
Omnibus protection beda. At least when I complain, let the police rein in these elements.
That's what we said. You'll go morning, afternoon, evening, doctor prescription.
When I complain, my lord, now I will perform puja. Like if I complain, my lord, let the police act. That's all. I don't want a total protection.
You are not performing puja, and your request for the injunction is.
Illa, it is in the sense that I have never been performing puja and theory. That is not the case. If he prevents, I can't. That is also a fact, my lord.
My lord, there is
If they gang up and come and throw me out of the temple precincts, how can I perform puja? Now, my only grievance is, let me protest against this high-handedness. That's all.
Have you filed any complaint?
I tried to, my lord. If I file a formal complaint, let it be entertained, my lord.
That will be entertained.
No,
the police will do their work in the regular course. ಇದುವರೆಗೂ ನೀವು ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ಸ್ were given, my lord, but they were not entertained. ಇಲ್ಲ, ರಿಜಿಸ್ಟರ್ ಮಾಡೋದಿಲ್ಲ.
ಯಾಕೆ ಆನ್ಲೈನ್ ಕಂಪ್ಲೇಂಟ್ ಆಗತ್ತೆ ಇವಾಗ?
In those days, ಈಗ ಮಾಡಬಹುದು. Now that's
those days 7 years ago.
Now, my lord, that is the only thing I request, that may be extended, that courtesy by police.
Not going to. If you file a complaint, we'll direct the police to take
Yes.
action. Petitioner is before this court. Adralli common order at the world. The facts in WP 108250. This petition arises out of the rejection of the application file. This petition has been filed by the plaintiffs in the aforesaid suit and arises out of the rejection of IA number 3 filed for police protection by the plaintiffs. The submission of Sri Srivatsa Hegde learned counsel for the petitioners stroke plaintiffs is that though an injunction order has been passed in favor of the plaintiffs, the respondents are preventing the plaintiffs from performing the pujas, rendering the injunction order illusory in nature, and as such, the plaintiffs, the plaintiffs are required to be provided with police protection to implement the order of injunction which has been passed. On inquiry with the learned counsel for the plaintiffs as to whether any complaint has been filed with the jurisdictional police as regards the alleged interference, he submits that though an attempt was made, the complaint was not accepted. That being so, there being nothing on record to indicate any complaint having been filed, there cannot be a direction which could be issued to the police to provide any assistance. If at all the petitioners, plaintiffs were to file any complaint with the jurisdictional police authorities, the jurisdictional police authorities would be duty bound to register necessary FIR and proceed with the matter upon proper investigation. With the above observation, the petition stands disposed.
My lord, in 19.1 and 19.2, my lord, notice to other respondents may kindly be dispensed with, my lord, because he has filed power for.
ಅದರಲ್ಲಿ ಇನ್ಯಾರಿದ್ದಾರೆ?
ಅದರಲ್ಲಿ ಹೆಂಗಾಗಿದೆ? Defendant number 4 and 5.
Daily order ಅಲ್ಲಿ notice to respondent 3 to 5 is dispensed with. They being the co-defendants of the plaintiff, of the petitioners.
P. Patil.
Lord, Senior Counsel Ravi B. Naik sir is online. Lord.
Yes, Mr. Naik.
Yes. For the petitioners in this case, please, Manoj.
Yes.
Well, the case pertains to an extent of 6 acres and 24 huntas in CTS number 103/A/1, please.
Just a moment, Mr. Naik.
My lord, they have filed additional documents now by IA. Lord, we would like to go through it and make our submissions. Probably we have not filed our statement of objection. I will see that statement of objection is filed. Lot of discrepancies I have found, my lord.
Okay.
They are all judgments produced, please, Manoj. They are not documents, they are judgments of various courts. Documents ಅಂತ memo ಬರ್ದಿದ್ದಾರೆ, but they are all judgments, your lordship may kindly peruse. All of them are judgments, please, Manoj. Passed between the same party.
Interstate between the parties.
Interstate between the parties.
Relied as precedents.
Please, Manoj.
Interstate between parties.
Interstate. They'll have to get instruction as to what happened in this. If we are relying on citation as precedents, that is a different thing.
I leave it to the court, please, Manoj. Some short date may be given, and the issue involved is very short, please, Manoj. I'll be in a position to convince your lordship.
Passed by this honorable court.
That is one thing that we don't have a short date.
There are orders of this honorable court passed in respect of the very same property. I would like to bring it to your lordship that.
In IA 1 of 2025, I mean, produced to place on record certain judgments passed interstate between the parties. The AGA seeks for a short accommodation to go through the same, obtain instructions, and file a statement of objection.
Please.
ಎಷ್ಟು ದಿನ ಬೇಕು?
Your lordship may give me 2 weeks time, my lord.
Seeks for and is granted 2 weeks time.
Please.
Nimdo?
I have filed my objection.
Objections, if any, to be filed on or before 14th March.
Please.
On 21st March.
Oblige.
Yes, please, Manoj.
21. Basavaraj.
During the pendency of the above matter, the petition number?
Petition number 2, my lord.
2 expired on?
On 6/2/2022, my lord.
Hence, IA 1, 2, and 3 of 2025 have been filed on?
10th February 2025.
Accepting the reasons stated in support of IA 1 of 2025, the delay of 1099 days is condoned, subject to payment of cost of?
My lords.
1,000 rupees to the advocate's clerk, so and so. By accepting the reasons stated in support of IA 2 of 25, IA 3 of 25, the abatement in respect of petition number 2 is set aside. By allowing IA 2 of 25, the person named therein are brought on record as petition number 2A to A and B. Counsel for the petitioner to carry out necessary amendment and file amended cost act. 3 application ಏನಕ್ಕೆ ಹಾಕ್ತೀರಾ? ಒಂದು ಹಾಕಿ.
Please,
Paper waste ಮಾಡಬೇಡಿ.
please. I prepared a brief synopsis in the matter, not the question, the
Instructions ಬಂದಿದ್ಯಾ?
matter pertains to not the.
Next week, your lordship. You can take a next week, your lordship.
Next week ಎಲ್ಲ ಇಲ್ಲ. ಇವತ್ತಿದೆಯಾ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್?
No,
Not the land of the
Kannur, you
petition.
have instructions today or? Certiorari quashing the final notification 6-1. Objections ಹಾಕಿಲ್ಲ?
So the
next week, your lordship.
And AGA seeks for and is granted 2 weeks' time to file objections to the petition. Objections usually by 14th, released on 21st.
my lord, in the
22.
next week, my lord, next week 27.
ಇಲ್ಲ, it won't reach. There are too many matters.
I'll take chance, my lord. The matter is very.
Everybody is taking chances.
It is in short, my lord. The land of the petition was taken without there being an acquisition proceedings.
Let him file his objections. It's a certiorari for quashing a acquisition notification,
Please,
which is pending from 2021.
please, my lord.
Let him get instructions.
22, GA Gachirmat.
Lord, on
As directed.
2 days time I will
have,
give, Lord.
Lords, furnished the physical copies,
Monday,
Lords,
Lord.
pertaining to this.
for
They
NCSM.
were supposed to submit the report, my Lords.
Lord, we have uploaded, my lord, all the details, my lord, as per your lordship's direction, my lord, through portal. Now, my lord, I will submit my report on Monday, my lord, if your lordships permit me.
Portal enable ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದೆ.
ಮಾಡಿದಾರಾ?
Lords, I have to verify, Lords.
ಮಾಡಿದೆ.
Now, my Lords, they have furnished one copy, my Lords, which is incomplete what he says.
ಅಲ್ಲಲ್ಲ. It's a different, my lord. I said that is why, my lord,
Portal check ಮಾಡಿ ಎಲ್ಲ ಡೀಟೇಲ್ಸ್ ಇದೆಯಾ ನೋಡಿ.
I'll verify.
So that everything is there in that format.
Yes.
ಅದಾದ್ರೆ ಮುಗೀತು.
ಇಲ್ಲ ಮಾಡಿದೆ. ಇಲ್ಲಿದೆ.
ಹಾಗಿದ್ರೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಇರ್ಬೇಕಲ್ಲ ಮಿಸ್ಟರ್ ಅಂಗಡಿ, ಎವ್ರಿಥಿಂಗ್.
ಅಲ್ಲ.
Everything is
I will file it in
reflected.
detail, my lord. That is why, my lord. This is only for the sake of perusal, my lord, of this honorable court. I will file it through. ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಮಂಡೇ ಏನಕ್ಕೆ ಬೇಕು ನಿಮ್ಗೆ?
Lord, I will submit this report through proper channel.
What about them?
Students, my Lords, first year of the examination.
My lord,
they have
my lord, we have received
supplementary
their fees.
examination they have
We have received their fees, my lord. Yes, my lord, that we have done it.
Yes.
Let them be permitted to take up the ensuing examinations, my Lords.
ಯಾವಾಗ
subject to
examination?
3rd of March.
Please,
It commences from 3rd of March.
please,
He
my lord.
wants Monday. We'll dispose of the matter only on that day.
Lords, in second matter, my Lord, so since my Lord was pleased to connect this matter, and my Lord said that it is a common order for both the petitions. The second petition pertains to the academic session 2022-23. My Lord, since there is no specific order for taking, my Lords, for permitting us to pay the examination fees, the university, my Lords, is not permitting us, my Lords, for paying the examination
University,
fees.
my lord, I will not appear for the university.
So they have to permit us to pay the examination fees.
Where is Mr. Bankar? He was here.
Because same order.
On
my
that
Lords,
day,
will
my lord, your
ensue
lordship has specifically directed because these two.
both the matters.
Please, my lord.
For both the matters, my Lord was pleased to say it is a common order.
ಹೌದು.
But they are not permitting us, my Lords, by saying that there is no specific order.
ಬರೀ ಅವಿನಾಶ್ ಅಂಗಡಿಗೆ ಅವಿನಾಶ್ ಬನ್ಕರ್ ಗಲ್ಲ ಅಂತ ಹೇಳಿ. Where is he? We'll have it on Monday.
Please.
ಅವ್ರು ಬಂದಾಗ ಹೇಳೋಣ ಅವ್ರಿಗೂ.
2:30.
Monday, my Lords, would be the last day for payment of examination fees. By the time I will pay, my Lords. Please, whatever.
They will open the portal. They will have to undergo that additional work. Learned counsel for the petitioner in 22.1 submit that the fees. Learned counsel for the petitioner submits that though the fees paid by the petitioner in WP 105326 of 2021 has been accepted, the fees in WP 101452 of 23 has not been accepted by the university. The university was required to accept the examination fee in both the matters. As such, the university is directed to accept the same immediately.
At 2:30.
The Avinash Angdi, learned counsel for NCISM, seeks for 2 days' time
Please.
to file his report as regard compliance with the earlier direction and the current status
Please.
of the
Features.
compliances made by the petitioner.
Please.
Released on 24th at 2:30 PM.
Please.
Great.
Please.
23, Arvind Kulkarni.
That's IPF. My lords, application for implementing has been filed, my lords. My lords, the petitioners are the resident of the same village, my lords. My lords, from last more than 100 years, my lords, the villagers of the Halk Sugal, they are using the petitioner's land as a graveyard as well as the burial ground, my lords. This being the fact, my lords, the Tahsildar passed the order, my lords, being agreed by that order, the petitioner has challenged that order and obtained the stay order, my lords. Since from that,
It is a private land
it's a private land, my lords.
used for burial.
Yes, my lords.
From when?
From last more than 100 years.
Yeah, 100
Last more than 100 years, my lords. Now, they are performing last rituals on the road, my lords, that's adjacent to that land.
Where is the burial ground?
No, that is adjacent to, that is an agriculture land.
Other picture ಅಲ್ಲಿ.
ಇಲ್ಲ, that is agriculture land, my lords.
Without acquisition, without taking the possession.
Tombstones ಇರಬೇಕು burial ಆಗಿದ್ರೆ.
ಅಲ್ಲಿ ವಿಲೇಜ್ ಅಲ್ಲೆಲ್ಲ ಹಿಂಗೆ ಇರುತ್ತೆ. ಅದನ್ನ ವಿಲೇಜ್ ಅದ
ಕಲ್ಲೇನ ಹಾಕಲ್ವಾ?
ಅಲ್ಲಿ ಇಡಂಗಿಲ್ಲ.
Let's may have submit. Plus the petitioner is the owner to an extent of 8 acres 20 guntas. They wanted to use 2 acres out of 8 acres 20 guntas for treating it as a burial ground. Plus the respondents interest between themselves. There were several communications that land has to be acquired. Plus may kindly see the annexure A. That is the first document, communication between the respondents. May I read? ಸಂಬಂಧಿಸಿದಂತೆ ಹಾಳುಕುಸುಗಲ್ ಗ್ರಾಮದ ಸೋಯನ್ಸೋ ಜಮೀನು ರುದ್ರಭೂಮಿ ಸಲುವಾಗಿ ಕಾಯ್ದಿರಿಸುವ ಕುರಿತಂತೆ ಉಲ್ಲೇಖ 1ರ ಅರ್ಜಿ ಸ್ವೀಕೃತವಾಗಿದ್ದು ಇರುತ್ತದೆ. ದಿಸ್ ಈಸ್ ಇನ್ ದ ಇಯರ್ 2017. ಅದರನ್ವಯ 2ರ ಅನ್ವಯ ವರದಿ ಪಡೆಯಲಾಗಿ ಹಿಂದೂ ಜನಾಂಗದ ರುದ್ರಭೂಮಿ ಸಲುವಾಗಿ ಕ್ಷೇತ್ರವನ್ನು ಜಮೀನು ಮಾಲೀಕರು ಒಪ್ಪಿಗೆ ಪತ್ರ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಅವರು ಪ್ರತಿ ಎಕರೆಗೆ 25 ಲಕ್ಷ ರೂಪಾಯಿ ಖರೀದಿ ನೀಡಲು ಒಪ್ಪಿಗೆ ಪತ್ರ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಕಾರಣ ಸದರಿ ಜಮೀನು ರುದ್ರಭೂಮಿ ಖರೀದಿಸಲು ಯೋಗ್ಯವಾಗಿದ್ದು ಇರುತ್ತದೆ. ಸದರಿ ವಿಷಯವನ್ನು ಮಾನ್ಯರು ಮುಂದಿನ ಅವಗಾನಿಗೆ ಗೌರವಪೂರ್ವಕವಾಗಿ ಸ್ವಯಂಲಾಗಿದೆ. This was the first communication between the Tahsildar and the Assistant Commissioner. Thus, thereafter, the Assistant Commissioner himself directed the Tahsildar to secure other informations from the different departments. That has also been secured by the Tahsildar, and it was submitted on annexure G, page number 22. All those information which was required by the Assistant Commissioner has been furnished to them. This went on up to 17/11/2017. Thereafter, suddenly, in the year 2023, without there being any acquisition, without there being any notice, directly an impugned order came to be passed, directing that in column number 11, it has to be shown as a burial ground. My request is, even as on today, I am ready to give 2 acres of land.
In that your lordship, the burial ground is being used for more than 30 to 40 years. So your lordship, they enter the name, your lordship, column number 11.
Acquire ಮಾಡಿ ದುಡ್ಡು ಕೊಡಿ ತಗೊಳ್ಳಿ.
Furthermore, my lords,
you need a burial ground, dignity to the dead is also required, but you have to acquire.
So issue notice to the consent of the, after acquisition, or your lordship with the consent of the petitioner.
Please, I am ready to give.
He's not opposing. We don't need to tell Mr. Kulkarni anything. ನಿಮ್ಗೆ ಹೇಳ್ಬೇಕಷ್ಟೇ. ಇಲ್ಲಾರು ಒಪ್ಕೋಬೇಕು ಅಂತ ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕಾಗಿತ್ತು, ಅವರು ಒಪ್ಪಿದ್ದಾರೆ. That is not a issue at all. 40 years use ಮಾಡಿದ್ದು, okay, no problem. We don't need to get into it because he is agreeable. IA-1 of 25 has been filed by the villagers to seek to come on record, accepting this contentions, statements made in the affidavit in support thereof. IA-1 of 25 is allowed. The person named therein are brought on record as respondent number 5 to respondent number 12. Counsel for the petition carry out necessary amendment, file amended cause title. In the main order, the petitioner is before this court seeking for the following reliefs. The contention of the petitioner is that the petitioner is the owner of the land in survey number 48/1 of Alakusugul village, Nalgun Taluk, measuring 8 acres, 20 guntas. In the year 2017, 16-17, the petitioners were approached by the concerned authorities seeking for consent to acquire and or purchase 2 acres of said land, which land was proposed to be designated for a graveyard and cremation.
Please.
Crematorium, graveyard, and for conducting cremation of the dead persons in the said village. The petitioner had agreed to sell his property, to sell 2 acres of his aforesaid property at a cost of rupees 25,00,000,000. Thereafter, no action was taken. Shockingly, in the year
17.
2023, an entry was directed to be made by the Tahsildar in the revenue records relating to in the RTC relating to the aforesaid property in column number 11, indicating that the land is being used as a graveyard stroke graveyard. It is challenging saying the petitioner is before this court. A perusal of learned counsel for respondent number 5 to 12, who have been subsequently impleaded, submits that the aforesaid land has been used for purpose of carrying out cremation for several years, and as such, the interest of the villagers are being unduly affected by the petitioner not permitting the usage of the land for the said purpose.
In fact, they have filed an application along with that, page number 7, a document produced by the impleading applicants. That is the order passed by the deputy commissioner. They were given some other land, but they are not agreeable for that.
Even you are agreeable for sale.
It is not that there was no
need to get into
please.
those.
That is
If you are
6
agreeable.
kilometers away from that village.
No, that's it.
He is agreeable. The requirement of a graveyard and a place for cremation is not in dispute, since the dead would have to be given their final farewell with dignity. The petitioner essentially is not disputing the usage of 2 acres of his land for the purpose of graveyard and cremation, but only contention of the petitioner is that the same cannot be so used without acquisition and compensation being paid to the petitioner. If that be so, it is for the respondents, official respondents, to complete the process commenced by them in the year 2016-17 in terms of annexure A to G of the petition. Without completing the said process, the entry cannot be directed to be made by the Tahsildar in column number 11 of the RTC of the petitioner of the RTC of the land belonging to the petitioner, that the land is being used for the purpose of a graveyard. Without acquisition, the petitioner cannot be forced to make available his land free of cost for the purpose of, even for a public purpose of a graveyard and or for cremation purposes. In that view of the matter, I pass the following order. Writ petition is allowed. A certiorari is issued. The order dated 8/3/2023, passed by the Tahsildar at annexure H, is quashed. Liberty is reserved to the official respondents to acquire the said land of the petitioner in terms of the right to fair compensation so and so act and or by private negotiation in terms of the applicable law.
Sir, until all the process completes, let them permit.
Without acquisition.
There is no land, there is no alternate land at all.
Annexure page 7 may kindly be seen.
ಅಲ್ಲ ಅಂತ ಈಗ the practical
2 months.
2 months or go.
Annexure
They're
7,
doing- We'll
page,
record a statement that they are going to do in 2 months. So if it is used, there is no issue. The submission of learned AGA that the entire process will be completed within 2 months is placed on record. In that view of the matter, the petitioner is requested to make available the said land proposed to be now acquired for the purpose of graveyard stroke cremation.
please.
ಅದು ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ you can't put it back, ಅದು ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ.
ಅಲ್ಲ
In fact, there is page 7 may kindly be seen of their own application. They have been given the alternative land till then.
alternate ಅಂದ್ರು ಇನ್ನೊಂದು ವಿಲೇಜ್ ಪಾಸ್ ಆಗಬೇಕಂದ್ರೆ they are not allowing us to go that side.
Not allowing.
Yes, yes.
Within 2 months.
The entire process be completed by
2 months.
Please.
24,
Completed within 2 months and payment made by them.
Great.
ಆಮೇಲೆ ಅಕ್ವಿಸಿಷನ್ ಮಾಡಿದ್ವಿ, ಇನ್ನು ಅವಾರ್ಡ್ ಮಾಡಕ್ಕೆ ಒಂದು 10 ವರ್ಷ ಮಾಡೋದು. ಪೇಮೆಂಟ್ ಟು ಮೇಡ್ ಮಾಡಿ.
Great.
24, Chetan Mannoli.
Lords, in this matter, 2 sets of impleading applications were filed, my lords. One by proposed respondent 7 to 12, that is IA number 1 to 6, my lords. And another IA number 7 by respondents number 13 to 16, which was disposed of on the last occasion on the submission of the petitioner that they would not press the petition insofar as the lands of respondents 13 to 16 were concerned. In the respect of that, my lords, I filed IA for amendment to exclude those 4 lands, my
What
lords.
about these impleading applicants?
In-
7 to 12, my lord has directed me to produce the document pertaining to how the names of the applicants have entered, my lord. I have filed the application before the revenue authority. They have not supplied. I required 15 days time, my lord.
So amendment we'll allow now.
Please.
IA 1/25 has been filed for amendment of the writ petition in pursuance of the submission made by the counsel for the petitioner that the petitioner would not agitate the right as regards certain of the persons, as regards certain of the lands. In that view of the matter, IA 1/25 is allowed counsel for the petitioner to carry out necessary amendment and file amended petition. Then counsel for the proposed respondent number 7 to 12 seeks for and is granted 3 weeks time to produce any document evidencing, to produce the documents as indicated earlier. Released on 21st, 24th March.
Please, ma'am.
Interim order may kindly be.
Interim order earlier granted is extended.
Ob-
25, Kottresh Bali.
Lords, being aggrieved by unauthorized chicken shop set up by the respondent number 2 here.
Unauthorized?
My lords.
Aggrieved by the unauthorized?
Unauthorized chicken shop set up by the respondent number 2 hearing. My lords.
Uh,
We have given the representation to respondent number 1, that is CMC Mudod. Their inaction has caused us to file this petition seeking the mandamus by this honorable court for consideration of our representation, my lords.
Set up by whom?
Set up by respondent number 2, my lords.
Respondent number 2 is.
Respondent number 2. That is basically an unauthorized chicken shop, my lords.
Subsequently, he has been got impleaded.
Subsequently, he has been impleaded.
He was not there.
Initially, he was not there.
So you sought to get an order without him? Yes. Unauthorized or authorized?
Unauthorized. My lord, on 5/7, the representation was given by the petitioner. It is an admitted fact. But prior to that, on 22/6/2222 only, an injunction has been given against the respondent, as the suit has been filed by the petitioner before the civil court in OS number 102/2020.
Respondent number 2.
Yes. Respondent number 2 has filed the injunction suit. And immediately after appearance, the respondent has filed the written statement as well as the objections to IA.
7 rule 11 Aki. Case is not maintainable when you are exercising your statutory powers.
So now the suit is for kept for evidence.
Lord, the injunction is sought
Injunction is
not
against.
to evict without due process.
And even
ಅದೇ ಹೇಳ್ತಾ ಇರೋದು. Due process. You have to follow due process. Suit is not made to, number one judgment is 7 rule 11
Objections have-
dismissment.
My lord, written statement and other things have already been filed by the CMC.
Mr. Kulkarni,
Please.
in all these things, when you are exercising statutory powers, civil suit is not maintainable. It's only for civil rights.
That has been taken up in the written statement. We have taken up the contention in the written statement.
7 rule 11 Akid,
Yeah, the-
not maintainable, no cause of action. Reject the plaint. ನೀವು ಆ ಸೂಟ್ ತೋರ್ಸ್ಕೊಂಡ್ಬಿಟ್ಟು ಇದು ಆಕ್ಷನ್ ತಗೊಳಲ್ಲ ಅಂತ ನಿಮ್ಮ ಆಫೀಸರ್ಸ್ ಶ್ರೀಯರ್ಷ್.
And they claims that they are the neighbors, my lord. They claims that they are the neighbors.
If you are authorized, if you have a license, you can always do it. If you are not authorized and licensed, you can't do it.
And that shop is causing heavy nuisance, my lords, to the petitioners.
If it is authorized, if it causes nuisance also, it doesn't matter. The question of authorized. You may not like him or he may not like you. That is different. We are not, it's to be done by law.
I shall instruct the trial court advocate to move the
And
application.
he is on a rental basis, my lord.
ಯಾರು ಅವ್ರು ರೆಂಟ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ?
Second respondent. It belongs, it's a private property, my lord. In whom, my lord, I have set up a chicken shop.
Have you taken license for a chicken shop?
But,
They haven't,
License, food license?
I will accept in your, because
they
today
haven't taken, my lords.
today
May
they
I
have
kindly refer
provided
to,
these OS documents, my lord.
may I kindly refer to annexure H, my lords. There it is clearly mentioned by the document of,
Petitioner is before this court seeking for the following reliefs. Grievance of the petitioner is that the respondent number 2 is running an unauthorized chicken shop without obtaining any license from the petitioner, from respondent number 1. And respondent number 1, despite repeated complaints have been given, has not taken any action. The R.K. Kulkarni, learned counsel for respondent number 1, submit that a suit has been filed by respondent number 2 against respondent number 1 in OS number
102 bar 2022, my lord.
102
Bar 2022.
bar 2022.
On the file of the principal civil judge and JMSC
For the
Mudhol.
principal civil judge and JMFC Mudhol, where an order of injunction has been passed. And as such, respondent number 1 is unable to take any action against respondent number 2. His submission is that written statement has been filed in the said suit, and application and order
Immediately.
rule 11 of order 7 would be filed for rejection of the plaint and for vacating of the interim order, and thereafter action would be taken. Placing his submission on record, the petition stands disposed.
Please.
And the application for license is pending since 2021.
No advice.
Please.
obligement.
ಏನ್ ಮಾಡ್ಬೇಕು ನಿಮ್ಗೆ ಗೊತ್ತು. ಪೆಂಡಿಂಗ್ ಐ ಸ್ಟ್ಯಾಂಡ್ಸ್ ಡಿಸ್ಪೋಸ್ಡ್.
26.
ಪೆಂಡಿಂಗ್ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು?
Please.
Prakash Usmani.
Recalling, my lord, dismissed for non-prosecution.
Why was it dismissed?
Non-prosecution, compliance of office objections, my lord, it was listed, my lord. Time was granted.
Pending consideration of IA 1 of 24, the petitioner is permitted to comply with the office objection, which non-compliance was the cause for the dismissal of the petition. Released on 24th March.
Please.
27. PG Mogali.
But I pay for petition or the order of AC and DC are challenged. The father of the petitioner was the owner of the land in question. The partition suit was filed in OS number 1 of 2007. That partition suit ended in a compromise granting equal share to all. 4 years thereafter, the third respondent started to interfere with the possession, contending that our father executed a sale deed in respect of entire land. On that basis, he tried to interfere with the possession. Therefore, another suit was filed, OS number 87 of 2011, seeking declaration of title and for injunction. But in that suit, the third respondent contended that the father executed a sale deed in his favor, therefore he claimed title. The trial court found that there are no documents to show that sale consideration was passed on to the vendor. Therefore, title didn't pass to the third respondent. So far as injunction is concerned, trial court held that the plaintiff are in possession. Since there is no interference is not proved, injunction is not granted. As is that, RFA was filed by the third respondent. In the RFA also, this honorable court held that so far as injunction is concerned, the plaintiff continues in possession Therefore, brought the injunction cannot be granted. So far title is concerned, this honorable court held that since there is a sale deed, whether consideration is passed or not, there is a sale deed. Therefore, the title passes to the third respondent. Therefore, brought this honorable court held and further gave liberty to the petitioners to file a suit for recovery of sale consideration amount. Page 23 is the observation made by this honorable court in the RFA, my lord.
Totally, it was Vasant, son of Maneshwar Sanu.
And that is the third respondent, my lord.
Third respondent, okay, Ali Dagogi. Fourth is Basaraj.
Fourth is
Basaraj,
brother of the petitioners.
the defendant.
Yes, madam.
So he is your brother.
Yes, madam. Yes.
ಅವ್ರನ್ನ ಯಾಕೆ ಡಿಫೆಂಡೆಂಟ್ ಮಾಡಿದ್ದೀರಾ ಅದರಲ್ಲಿ? ಇಲ್ಲಿ ಯಾಕೆ ಅವ್ರನ್ನ ರೆಸ್ಪಾಂಡ್ ಮಾಡಿದ್ದೀರಾ?
Purchaser. Third respondent is purchaser.
Vasant is a purchaser.
Basaraj should have been also been made a
Petitioner.
He has filed another suit, my lords, in respect of.
I will submit.
Please.
But,
Yes.
This honorable court also held that the plaintiff petitioners are in possession of the property as on today. So far title is concerned, but since there is sale deed, the title passes to the third respondent. Therefore, not so far title is concerned, so the judgment decree passed by title code is modified to the extent of title, held that the third respondent is the owner. And further observed that this honorable court also observed that there is no document to show that the sale consideration amount passed on to the vendors. And page 23, may I read one portion, page 23, in the middle. The order passed by this honorable court.
Page
23, my lord. RFA order, my lord. But in the middle, even assuming that the first defendant, in the middle of my lord, even assuming that my lord got it, even assuming that the first defendant made payment of the balance amount, his evidence is not believable for the reason that he didn't think of obtaining any document from the second defendant for having made payment. No prudent man will make payment in lakhs without obtaining document. Therefore, there is no proof of payment for payment of balance sale consideration amount. According to the trial court, the transactions are tainted with fraud and mischief. The trial court
this judgment has been passed. RFA ali.
Yes.
RFA filed by appellant defendant.
Third respondent here in Baroda.
Vasant, purchaser,
yes,
is allowed.
Yes. Allowed to, in part, Baroda. So far, title is concerned.
For decreeing the suit partly, declaring title of the plaintiffs.
Plaintiff, but no
respect of the suit property is set aside.
Yes.
So you were the plaintiffs.
I was the plaintiff, yes.
It is set aside.
Set aside.
And suit is dismissed as regard declaration of title.
Title is concerned.
So your title illa, declaration illa.
Yes. So for possession is concerned, this honorable court confirmed the finding of the trial court. Trial court held that plaintiffs are in possession. They are not dispossessed. Para 32, page 32, page 40. This honorable court confirmed the trial.
33 ali finding irado.
Yes, ma'am. From 32, with regard to possession, discussion is made. Page 40, page 30, para 32, with regard to possession.
Plaintiffs were in possession.
As regards possession, the trial court is of the opinion that the plaintiff are in possession. That is petitioners, the first defendant asserts to have taken possession of the suit property pursuant to sale deed. In fact, DW3 also says that the second defendant handed over possession to the first defendant. The trial court's finding is that according to the evidence of DW3, the plaintiffs are in possession. We do not find any such admission by DW3. So and so argued that Exhibit P9 itself indicates that possession was handed over to the first respondent. On perusal of Exhibit P9
is with them, with you.
With me, my lord. Now, on the basis of this judgment decree, he approaches the revenue authorities, and revenue authorities deletes our name and enters the name of the third respondent without notice to us.
Ownership is there.
Beg your
Ownership is there. That
yes. So far, entry of his name in column 9 is concerned, no objection. So per column number 12 is concerned, column number 12 is concerned, and cultivators column, our name has to be continued. That is the only limited our contention. Firstly, about this order is passed, the mutation is effective without notice to us. Though it is on pursuant to the order passed, but there is no direction to enter his name in the RFA. However, but his name
No
entered.
direction required, column
No,
9.
no, no,
there is direction.
true, but I agree,
You
madam.
can only have a grievance as regards
I,
column
I,
12.
I agree, madam. I agree, madam. But without notice to us, mutation affected one thing, bro.
12 ಅಲ್ಲೂ ಆಗಿದೆಯಾ?
This honorable court held in a report decision that even the entry,
Where is the RTC?
page 52, my lord. Page 52, annex C1, my lord. In the cultivators column, our name is not deleted, my lord. We have no objection for entering his name in the ownership column. Only to that extent, my lord.
Yes.
Milords.
And one more thing, my lord. My lord, he filed a suit for permanent injunction subsequently, my lord. In that, A was filed seeking temporary injunction. That application has been rejected, holding that he is not in possession. But I produced page 63, annex F, my lord.
Yes.
Page
And
82.
MA also was dismissed.
And MA was filed, MA also dismissed. All this goes to show that he is not in possession. This honorable court and the trial court concurrently held that the petitioner is in possession. And his application for injunction is rejected, confirmed in the MA. MA order is also produced, annex G, page 83, my lord.
Yes.
And
I'm very glad, my lords, my brother refers to that MA order. May I request my lords to take page 97 of that MA order, my lords? Page 97, paragraph number 24. The plaintiff produced order copies, order passed on I number so and so, filed by the present defendants in OS so and so, so and so, so and so, which, my lords, is aware while filing of this writ petition also. And those order copies have not been produced by the petitioners herein. Along with the memo of production, my lords, I have filed those order copies along with the plain copies. The first petitioner's children have filed a suit in OS 69, against which, my lords, please, my lords. Application seeking injunction is dismissed, confirmed in MA 31 of 21. Second petitioner's family again has filed another suit in OS 67, which is confirmed in MA 32, injunction application. And interestingly, my lords posed a question. My lords posed a question. Basavaraj, why is he not made as a petitioner? Why is he a respondent? Yes. Basavaraj has filed a suit, my lords, in OS 72, which is coming forth at page number 111 along with my memo for production. Injunction.
111.
Please, my lords. OS 144, my lords. 434. 434.
111 is Kumar Jeevan.
Umaji,
72.
sons of Basavaraj. This
versus
Basavaraj suit is, my lords, page 144, my lords. Page 144, my apologies. Page 144.
Yes.
Wherein again the same application is rejected, his application is rejected, and MA, that is confirmed in MA, miscellaneous appeal. My lords, on one pretext or the other, the fruits of the decree, my lords, what has happened here is, if
injunction not to only, not injunction, not to only it. That appeal is rejected.
But the RFA court came to a conclusion that they are in possession.
no, my lords, I'm sorry. I beg to differ in this point. The learned, this honorable court, my lords, in RFA has specifically held, my lords, one paragraph which I may be permitted to read.
32 is against you.
Before that, my lords, paragraph number 23, my lords, page 33. The plaintiffs may have stated the sale deed is bad as it came into existence during pendency of the suit. It is true, but the facts disclose that they too were very much aware of the entire transaction and they did not bring it to the notice of the court, suppressing the entire transaction. If the plaintiffs and second defendant is their father, my lords, and the second defendant entered into compromise between themselves, it is nothing but fraud played on the court. Collusion between them is very much apparent.
Yes.
My lords, what happens is, if I may take my lords to the prelude of this litigation, A suit for partition is filed between sons and father. That
Where
suit,
is the finding that you are in possession, Mr. Kinney?
my lords, possession, my humble submission is, my lords, possession goes with title. Once the appellate court, my lords, holds that,
Come to para 32.
as regards possession, the trial court is of the opinion that the plaintiffs were in possession.
Hmm.
The first defendant asserts to have taken possession of the suit property pursuant to the sale deed. In fact, DW3, my lords, is the, also says that the second defendant.
We do not find any such admission by DW3.
Yes.
Indicates that possession was handed over to the first defendant. What we understand is that probably came into existence, the first defendant applied for everything.
Please. So and so indicates that possession was handed over to the first defendant on perusal of exhibit P9. What we understand is that probably after D2 came into existence, the first defendant applied for effective mutation of the revenue records to his name, and the same was challenged by the plaintiffs by filing an appeal to the assistant commissioner. The order of the Tahsildar came to be stayed, and therefore the revenue records as they stood before the execution of the sale deed continued. It is pertinent to note that R of R still continues in the name of second defendant. Of course, there is a recital in the sale deed that possession has been handed over, but this recital alone cannot be considered for holding possession of the suit property to be with the first defendant. Nothing prevented.
Other line.
But my lords, yes, to that extent,
This court has come to a conclusion that you are
That
not
I
in
am not-
possession and they are in possession, confirming the trial court. Now you'll have to file a suit for possession.
my lords, my title has been confirmed by this honorable court. Possession, my lords, I have not proved any positive evidence before the trial court or this court is the holding. So it doesn't mean that even they are in possession, my lords. My humble submission is that even there.
The contention has been rejected by this court. That
Because
possession follows title has been rejected.
Possession follows title.
Your options are what are available was to check. Now the finding is there.
But my lords, as far as the
Column
orders,
number 9 you can come, column number 12 you can't until you take possession in a manner known to law.
please, my lords, that is what is subject to the litigation before the learned trial court is what the deputy commissioner holds. The impugned order herein, what it says is subject to the result of those suit. Mutation should be
That cannot be done. You cannot do indirectly what you cannot do directly. So,
my lord,
petitioner is before this court seeking for the following reliefs. The contention, the grievance of the petitioner is that the petitioner is being in possession of the land in survey number 74/2A measuring 7 acres, 7.30 acres of Devagiri, Yellapur village of Averi Taluka. Respond number.
my apologies, my lord.
3. Yes.
Not to interfere, my lords, my apologies. In page number 180, the order copy.
180 of your documents. Yes.
Basavaraj. This is arising out of the miscellaneous appeal, my lords. 02 of 22, wherein Basavaraj, the respondent number 4 herein, had come in appeal, wherein it is also discussed 180 my lords, para 32. The plaintiff claiming suit property on the basis of collusive compromise decree obtained in so and so, the Honorable High Court of Karnataka held at para 19, the act of the plaintiff intended to defraud the defendant. Such an act is not sustainable in law. The defendant contended in his written statement that plaintiff in collusion with his sons and daughters with an intention to harass and defraud the defendants to grab the property. The defendant has every right to protect his property and to recover the possession of the suit property, whoever is in possession purchased property. The plaintiff filing one by one suit against the defendant purchaser instead of handing over the possession of the suit property, such an act is not protected under law.
Handing over possession is even worse. The confirmation that they are in possession. You are wasting time. Work suit for possession act. You have title confirmed by this court. Advise your client properly and get the relief. by second respondent. Yenappa. Taluka. Respondent number 2 has directed the entry of the name of respondent number 3 in both column number 9 and 12. Shri P.G. Mowgli submit that the entry of the name of respondent number 3 could be made in column number 9 as being the owner, but insofar as column number 12 is concerned, the petitioners being in possession, their name could not have been deleted, let alone without notice having been issued to them. In this regard, he relies upon the decision of the division bench of this court in RFA number 4101 of 2013, more particularly para 32 thereof, to contend that this court had come to a conclusion that the petitioners, that respondent number 3 was not in possession, and confirmed the finding of the trial court that the petitioners were in possession. As such, without obtaining possession of the property in a manner known to law, the question of entry of the name of respondent number 3 in column number 12, which relates to cultivator right stroke possessory right, could not have been made. Shri Kini N.S., Learned Counsel appearing for respondent number 3, would submit that the petitioner, that respondent number 3 being the owner, and that ownership having been declared in RFA number 4, the very same judgment in RFA number 4101 of 2013, possession follows title, and as such, the respondent number 3 is to be held to be in possession of the property, and the entry made of the name of respondent number 3 in column number 12 is proper and correct, does not require any interference. Having heard so and so peruse papers, the suit in OS number 1 of 2007 had been filed for declaration of title and share of the plaintiffs, that is the petitioners herein. In the said suit, the respondent number
1 of 7 was the partition, my lords.
Partition, 87 of 2011.
sorry, 87.
87 of 2011.
4101 is arising out of your suit.
87 of 2011.
87 of 2011. my lord.
The background, my lords.
Page 14 my lord, in the RFA order is mentioned. my lord. Page 14 my lord, the last but one para.
1 of 7 was filed inter-se between the
earlier litigation.
Partition.
earlier litigation for partition.
OS number 87 of 2011 was filed before the additional senior judge Haveri, seeking for declaration of title and permanent injunction by the petitioners herein against respondent number 3. The said suit having been decreed in totality, an appeal came to be filed by respondent number 3 in RFA 4101 of 2013. When the said decree of the trial court was set aside and the suit was dismissed insofar as declaration of title, by holding that defendant number 1 was a purchaser of the property, and further holding that the sale deed executed by the plaintiffs in favor of the defendant was valid.
Father of the
D2
plaintiffs.
to D1.
Father of the plaintiffs. my lord.
Father of the plaintiff in favor of defendant was valid. While dealing with the said matter at para 32, this court, dealing with the aspect of possession, took into consideration that trial court had come to a conclusion that the plaintiffs were in possession, and this aspect was examined, and this court held that a recital in the sale deed that possession was handed over alone could not be considered for holding the possession of the property to be with the first defendant therein, that is third respondent herein. And as such, came to a conclusion that the plaintiffs were in possession, confirming the judgment of the trial court. A suit in OS number 434 of 2021 having been filed by respondent number 4 herein against respondent number 3. In the said suit, an application for injunction had been filed, which came to be rejected. Challenging same, the fourth respondent had filed an appeal in MA number 02 of 2022 before the principal senior civil judge at Haveri. In the said suit, also there is a finding at para 32, 32 ne para 32, that the plaintiff therein having sold the property was required to hand over the possession of the suit property. Thus again categorically establishing that the plaintiff was in possession, that is respondent number 4. Plaintiff, that is respondent number 4, was in possession. There being finding of this court that the petitioners are in possession on an application filed by respondent number 3 for entry of his name in column number 9 and 12 has been allowed. Could not have been allowed, inasmuch as what has been confirmed by this court in RFA number 4101 of 2013 is the title of respondent number 3 and not the possession. In fact, this court having come to a conclusion that respondent number 3 is not in possession. In that view of the matter, I pass the following order. Writ petition is partly allowed. A certiorari is issued quashing a portion of the order dated 14/12/2023 in so and so, passed by respondent number 1 at Annexure E, insofar as the entry of the name of respondent number 3 in column number 12 is concerned. Respondent number 2 is directed to cause the entry of the name of the petitioner in column number 12 and continue the name of respondent number 3 in column number 9. The said entry to be made within a period of 3 weeks from the date of receipt of a copy of this order. Liberty is reserved to the respondent number 3 to file appropriate proceedings for possession. I have one.
28, Jagdish Patil.
Petitioner.
Here for respondent number 5.
Stay idea.
Stay there. Purchasers.
Just on 15th April, interim order earlier granted is extended till next day. Until those decisions judgment is rendered in the constitutional validity, it cannot be considered.
29,
Tomorrow, next week, my lord.
Next week ಅಲ್ಲಪ್ಪ ಅದು ಜಡ್ಜ್ಮೆಂಟ್ ಬರಬೇಕು ಅದನ್ನ ಹಿಯರಿಂಗ್ ನಡೀತಾ ಇದೆ.
29, Lingaraj Maradi.
In the last date, my lord,
Yes.
my lord has directed to produce the document of the petitioner property. Requesting some more time, my lord.
Counsel for the petitioner seeks one is granted 3 more weeks time to produce certain documents. Released on 24th March.
Please.
30, V. Vidya. I kindly to pass on.
Paso.
31, Srivatsa Hegde.
Yes, my lord, I was to secure details as to how the petitioner was impleaded in the original suit. My lord, I would need a day's time, if it could be day's time.
Once time ಕೊಡ್ತೀವಿ, days time ಕೊಡಲ್ಲ.
Of the
ನಾಳೆ
my instructions themselves got implemented in the suit. And my lord, the similar application seeking a share was filed in RA also. In RA, applications were rejected. Against that, they did not file any appeal. In execution, again.
In execution, I filed a section 47 application, my lord, and I also
Again
filed
ಇದೆಲ್ಲ
applications.
ನೀವು orally ಹೇಳಿದಾಗಲ್ಲ, we'll have to see those.
I have filed RA copy judgment along with my statement of objection.
RA copy ಇದೆಯಾ? So adರಲ್ಲಿ there must be a
Yes,
recital as to what
similar
is happening.
applications were filed.
Page?
Page number 86, annexure R6. Page number 123, Your Lordship. Please. Page 98, sorry, ma'am. Page 98. Page 98. Para 4. The counsel for respondent number 12, that is the present petitioner, filed IA so and so, praying the legitimate share of the respondent 12, Srimati Tanuja, wife of Prahlad Nayak, be awarded in the suit properties Gram Panchayat so and so, which are subject matters of the preliminary decree in OS number so and so, and FDP number so and so, disposed of by third court, which is the subject matter of this appeal. Then come to operative portion of the order, page number 123. I number 12 filed by respondent number 12 under 151 CPC is hereby rejected. Similar relief was spread in RA and now also invoking section 47, page 123, Your Lordship, operative portion of the order. This application came to be rejected. That order has become final.
Yes. My Lord, on last occasion, I tried to explain.
If she has got independent rights, let her file a suit, my Lord.
The property is divided in 3 parts, my Lord.
This EP 78 arises out of the very same proceedings.
Same matter
Yes.
went
The
up to.
earlier application which had been filed has been rejected.
Yes, my Lord.
Mate?
My predicament is, my Lord, I am part of the suit proceedings. He is my maternal uncle, the plaintiff. Nevertheless, I was not awarded a share. The relationship is admitted inter se.
Yes, but there is an order against you, Mr. Srivastava. You have not challenged it. It's attained finality.
In SLP
They're not
was,
determining your rights now. It's already been determined there.
I made an application, my Lord, under section 47, saying that my right also be determined.
That has been rejected. Your application in IA 12, which you had filed in RA 303, which is the precursor to this execution proceedings, be awarded the suit properties bearing so and so, which are subject matter of the preliminary was disposed of by so and so.
Yes, I have mentioned in my petition also that my application came to be
Your
rejected.
claim which you had made earlier, having been rejected, can you again come back in EP and file it? Is it not re-agitation, res judicata in the same proceedings?
Maybe, my Lord, but then my request is,
Maybe andre
my request is, my Lord, I made 2 more applications saying that in that 1/3 I get 1/9. Either the plaintiff let him buy my share or I will buy his share, because it measures.
all those things you can talk outside here.
Because
Outside
it measures.
not here after IA 12 has been rejected.
It measures 10 by 100 or 110, my Lord. Now, if I am driven to file another suit, it's not unreasonable of me asking, my Lord. It is unreasonable of him asking like this.
because of these proceedings, I am unable to get the fruit of decree. I could not get anything. Matter went up to SLP. Thereafter,
ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂತೀರಾ ಏನ
ಅಲ್ಲ,
ಇಂಟ್ರೆಸ್ಟ್ ಇದೆ
ಅವ್ರು-
ಏನೋ ದುಡ್ಡು ಕೊಟ್ಟು
the once it is held that she is not entitled for any.
No, it's not held like that.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಹೇಳಿದೆ.
No, it was never agitated antanತೀರಿ, but how can it be held? There is
That
no.
if that order was challenged, my Lord, rejection of her application, then it was different.
In the very first instance, my Lord, even my mother's name was dropped from the genealogy.
Yes, but this is attained finality, Mr. Hegde.
It has, my Lord.
Certain finality.
Yes, all that I want is, my lord, the end of this fiasco and for 1/9 in the 1/6, 1/3, if I have to initiate suit proceedings, my lord,
Let it go. Why do you want it? You don't want
my
let it
request
go.
is give a chance for justice also on Thursday.
Not
Instead of
contrary
only
to the orders.
technicalities.
The petitioner is before this court seeking for the following reliefs. The petitioner had filed 5 applications in execution petition number 78 of 2019, which came to be dismissed, while the impugned order dated 25th April 2024. The application which were filed were IA number 5 under Order 21 Rule 97, IA number 6 under Section 47 of the CPC, IA number 7 under 151 of the CPC, seeking permission for the petitioner to lead evidence to determine her rights, IA number 8 under Order 13 Rule 10 for calling for the records in OS number 282, and IA number 9 IA number 9 under Section 151 for the court to decree for a direction to the decree holder to purchase her 1/9 share, and IA number 10 directing the decree holder to sell his 1/6 share in the suit property in the alternative to the relief sought for in IA number 9. All the said applications having been rejected, the petitioners are before this court seeking for the aforesaid relief. The contention of Srivatsa Hegde, the counsel appearing for the petitioner, is that the petitioner has a right in the property, she also belonging to the family. Her rights were required to be determined, and as such, those applications had to be allowed, at least initially the application under IA 5 and IA 6, and subsequently the other application could have been considered. In view of the dismissal of IA 5 and 6, application in IA 7 to 10 having been rejected as a consequence thereof, the petitioner's rights are adversely affected, and as such, he submits that if IA 5 and 6 are allowed, the other applications could be considered later on. Shri Dinesh Kulkarni, learned counsel for the respondents, would submit that once earlier, the petitioner had filed IA number 12 in RA number 303 of 2019 for awardal of the suit properties, which are the subject matter of the preliminary decree in OS number 282 of 1998 and FTP 42 of 2013. In the said application, there was a claim made by the petitioner that there is an inquiry required to be held as regards the undivided share of her mother, which thereafter fell to her share. This application was considered in the said RA number 303 and rejected, and as such, he submits that after the application, a similar application filed, though under Section 151, in said RA number 303 of 2019, another application could not have been filed in the execution petition, and the same is an abuse of the process of court. Heard so and so peruse papers. A perusal of the judgment in RA number 303 of 2019 indicates that indeed an application was filed by the petitioner, who was respondent number 12 therein, seeking for allotment of the very same share as sought for in IA number 8 by summoning the records of the proceedings in OS number 282 of 1998, which is what was sought for in IA number 12 in RA 303 of 2019. Even in the said proceedings, the petitioner had sought for awardal of a portion of the suit scheduled properties, claiming a right under her mother, which is what has been sought for in IA number 12, in IA number 4, 5 and 6 filed in these proceedings, filed in EP number 78 of 2019. The earlier application filed for similar relief by the petitioner having been rejected in RA number 303 of 2019 by the reasoned judgment dated 28 November 2023, the same having attained finality on account of the petitioner not having challenged the same. The question of the petitioner filing the IA number 5 to 10 seeking for similar reliefs by filing multiple applications in the execution proceedings is, in my considered opinion, as rightly contended by Sri Dinesh Kulkarni, a complete abuse of the process of court. The petitioner has sought to again re-agitate the claim made in RA number 303 by filing the very same applications and has brought the entire proceeding to a standstill. In that view of the matter, firstly, no grounds being made out, the petition stands dismissed. The applications have been filed as an abuse of the process of court. Cost of rupees.
Then they are not.
Cost of rupees 10,000 is imposed on the petitioner. The said cost to be paid to the advocate clerks, so and so. Nimu kodala.
Lordship's kind permission. Serial number 126.
126.
Lordship, last time a government advocate directed to get this instruction regarding deposit of amount, this award amount. It's Monday.
Monday.
Yes.
126 Tuesday.
Yes.
But 34.
In the orders list.
34, my lord. But appear for the respondent.
Yes.
It is required to be heard. It may be called in the first week of March, my lord. There is an interim order in his favor.
34 at the request of counsel for respond number 2.
Yes.
Released on 24th March, interim order earlier granted is extended till next day.
56, my lord, service is awaited, my lord.
56.
Service with respect to respond 1 and 2 is awaited, my lords. I appear for petitioner, my lords. May I request?
56 awaiting service on respond number 2 and 3. Released on 24th March.
Please, my
interim
lords.
order idea?
Yes, please, your lords.
Interim order earlier granted is extended till next day.
Please.
46.
Counsel for the petition submit the needful has been done. Registry is directed to verify if process fee is paid. Issue notice to respond number 17 returnable by 7th April. Interim order earlier granted is extended till next day.
Serial number 48, my lordship. Kindly week's time, my lordship.
Counsel for the petitioner seeks for and is granted
Interim.
3 weeks time to file necessary application to bring the legal representative of deceased respond number 23 on record, as also to make payment of process fee and furnish copies in respect to unserved respondent. If
Interim.
needful is not done by 21st, released on 25th for dismissal.
64.
Interim order may be.
Interim order earlier granted extended.
64, my lord. 2 weeks time to take steps in respect of deceased respondent.
Counsel for the petitioner seeks for and is granted 3 weeks time to file necessary application to bring the legal representative of deceased respondent on record, released on 25th March.
And serial number 66, my lord, the respondent died on 25/5/2021. Need to take steps, my lord.
Same 66, 3 weeks.
Serial number 36, my lordship. The petitioner, it was directed the petitioner to file affidavit. He seek a small accommodation. Affidavit file ಮಾಡಬೇಕು next week.
ಯಾರು ಫೈಲ್ ಮಾಡಬೇಕಾ? AGA?
ಇಲ್ಲ, ನಮಗೂ petitionerಗೂ ಡೈರೆಕ್ಟ್ ಮಾಡಿತ್ತು.
At the request of counsel for the petitioner, released on an urgency anilwala.
Can see the next week.
Released on 21st March.
Please.
Serial number 111.
Interim order will be extended.
Interim order. 111.
Yes, next week. Interim order. Interim order. Next week.
ಹೇಳಿದಿರ ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ ಕಿನಿ
ಕಿನಿ ಅವ್ರಿಗೆ ಹೇಳ್ತೇನೆ ಅವ್ರಿಗೆ ಹೇಳ್ತೇನೆ
ಹೇಳ್ತಿರಲ್ಲ then we won't.
33, my lords. I appear for respondent.
Yes.
I need to secure instructions, weeks accommodation. My lords.
Interim order ಇದೆಯಾ?
Yes, my lord. Interim order may kindly weeks.
Counsel for respond number 2 seeks for and is granted 3 weeks time to obtain instruction making submission. Released on 24th, interim order earlier granted is extended till next.
Please.
My lords, I am for respond number 6.
Serial number? 2. Aswaraj.
Yes, my lords. Senior is out of station, my lords. Kindly taken on Monday, my lords.
Have you informed the petitioner?
Yes, my lords. I inform KM Partition, my lords.
Interim order idea?
Yes, my lords.
At the request of You are for respond number
6, my lord.
6, released on 24th March. Interim order earlier granted is extended till next date.
ಏನಂದ್ರೆ ನೀವು ಪ್ರಶ್ನೆ ಎಲ್ಲಿಕೊಂಡಿದ್ದೀರಾ?
ಹೌದಾ? 25, 3. ಹೌದು, serial number. Seven.
ಏನ್ ಸಬ್ಮಿಷನ್
ಯಾವ್ದದು? 25, 4 ಕೊಟ್ರು ನೋಡಿ. 25, 3 ಅಂತ ಕೊಟ್ರಲ್ಲ, 4 ಯಾವ್ದು ಕೊಡ್ಲೇ ಇಲ್ಲ. 48 ಆಗಿಂದ ರಿಲೀಸ್ ಟೈಮ್ 25 ಎಲ್ಲ 25, 3. 66 ಆಗಿಂದ ನೋಡ್ರಿ 3 ವೀಕ್ಸ್ ಅಂತ ಹೇಳಿದ್ರೆ 66. 3 ವೀಕ್ಸ್ 25, 3. ಆಮೇಲೆ 64 36 ಐತಿ. 126 34 56 46 48 66 36 30 ಎಲ್ಲ ಮೂರೇ ಮಾರ್ಕ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದು ಯಾವ್ದಂತ ಗೊತ್ತಿಲ್ಲ. ಏಪ್ರಿಲ್ ಕೊಟ್ಟಿದ್ದು ಒಂದೇ ಒಂದು. ಪ್ರೊಸೆಸ್ ಕಟ್ಟಿದ್ದಾರೆ, ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿ 46. ಯಾವ್ದು ನೋಡ್ರಿ ಓಕೆ ಇಲ್ಲ ಮಿಸ್ ಆಗಿದೆ. ಇದು ಗುಡ್ಡ ಬೇಡ ಕೊಡ್ತೀರಿ ಸರ್? ಒಂದೇ ನಿಮಿಷ. 64. ಅಷ್ಟೇ ಕೊಟ್ಟರು. ಹೇಳಿ.
59 ಬಿ ಗ್ರೂಪ್ ನಾಗ ಸರ್ 59 ಓಂಕಾರ ದೇಸಾಯಿ.
ಓಂಕಾರ ದೇಸಾಯಿ ಪೂರ್ತಿ ಇಲ್ಲ, ಓಂಕಾರ ಲಕ್ಷ್ಮಣ್ ದೇಸಾಯಿ ಅಂತಿದೆ. ಅದ
ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಕಾಲ್ ಬೈ ಜಜ್ಮೆಂಟ್ ಇದೆ ಯಾವಾಗ
ಏನಂತ
ಅದು ಐಡೆಂಟಿಕಲ್ ಮ್ಯಾಟರ್ ನಾಗ ಅಲೌ ಮಾಡಿ ಸರ್ ಮ್ಯಾಂಡಮಸ್ ಇದೆ
ಸರ್ 35
30 ಪಾಸ್ ಮಾಡಿದೆ.
ಮತ್ತೆ ಇನ್ನೊಂದು 35 ಮ್ಯಾಟರ್ಸ್ ಇದೆ ಸರ್.
ಈಗ ಮಧ್ಯಾಹ್ನ ಹೋಗ್ತಾ
ಅದು ಲಿಸ್ಟ್ ಕೊಡ್ತೀನಿ.
ಇಲ್ಲ, ಬೆಂಗಳೂರು ಕಲಬುರ್ಗಿ ಮುಗಿಸಿ 2:30 ಇಲ್ಲಿ ಮುಗಿಸಿ ಆಮೇಲೆ ನಿಮ್ ಕೈ
ಇಲ್ಲ
ಸಿಗುತ್ತೆ.
ಸಿಕ್ಕಿದ್ರೆ ಅದರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ಬೇಕು.
35 ಮ್ಯಾಟರ್ಸ್ ಏನಿದೆ ಸರ್ ಫೈಲ್ ಮಾಡಿ ಅದು ಕಲೆಕ್ಟ್ ಮಾಡಿ
ಓಕೆ
ಸ್ವಲ್ಪ
Dharwad bench matter, 230 matter, 128, Jagdish Patil.
This last time directed to get the records, Your Lordship. 2 weeks time, no, Your Lordship. 2 weeks time, I granted.
Inna bandilwa.
It.
What order sheet?
This is where the land tribunal has converted form number 7 into form number 1. That is that.
And AGS seeks fund is granted 2 more weeks' time to secure the records. If records are not secured by 18th March, the Assistant Commissioner would be required to be present before this court in person on 24th March.
129, Rajshekhar Burji. Rajshekhar Burji.
Settlement talks. Paso. ಇಲ್ಲ.
130, Mallikarjun Swamy, B. Raman.
Yes.
I have gone through the records.
Yes.
Now, what they want to now contend is, though no reasons are assigned in the impugned order for rejecting my application for conversion, they want to substitute that by saying that there is no approach to my property. Hence, application is rejected.
Approach road ilwa.
Sutla property is namde irodu. There is a hospital constructed. Now only to overcome your lordship's direction, because there was no reason assigned in the impugned endorsement. Now since your lordship
If
said
they are surrounded by their own land, they have access.
Because as per the Buddha, Your Lordship endorsement on 17 to 2025, there is no excess road, Your Lordship, to the land, Your Lordship.
Is that land surrounded by land of the petitioner?
I can show, I produced a master plan and in fact, behind this property, there is my another land. Adakke conversion kottidare in 2016. Now, milled.
Reconsider and master.
Reconsider like malified. Reconsider and theory problem ಆಗಿರೋದಿಲ್ಲ. This appears to be for other reasons. ಅಷ್ಟೇ. ಕನ್ವರ್ಷನ್ ಕೊಡಕ್ಕೆ ಇವಾಗ 30 days ಅಷ್ಟೇ ಇರೋದು. ಅದಕ್ಕೆ ಒಂದೊಂದು ವರ್ಷ ಇಲ್ಲಿ ಒದ್ದಾಡ್ಕೊಂಡಿರ್ಬೇಕು.
Because in the impugned order, Your Lordship, they have stated it is only rejected, they have given the endorsement. But after the records are received, Your Lordship, there is no excess road on Thursday.
That is only an improvement. If I can bring to lordship's notice, the document which was furnished to me, it was on the ground that report was not submitted by Tahsildar.
Anyway, that we have directed, that we will take care of.
Yes.
The petitioner is before this court seeking for the following reliefs. The petitioner is stated to be involved in the field of education and is the owner of the land in RS number 255/5, measuring 15 guntas, and RS number 255/6, measuring 10 guntas, situated at Angol, Belgavi. The petitioner.
In 255/1, 9 guntas.
255 also purchased another extent of land in RS number 255/1, measuring 9 guntas. All these properties are shown in the master plan prepared by the Development Authority as residential, I mean demarcated in yellow color. The lands being agriculture in nature, the petitioner made an application for conversion from agriculture to non-agricultural, yen purpose?
Educational purpose.
Education purposes. The said application I mean made an online, by way of online application at annexure, wide annexure H
H1 and H2.
series, the petitioner came to know of the endorsement that the application filed by the petitioners in respect of the aforesaid 3 lands has been rejected. It is in that background, the no reasons have been assigned in the said endorsement. The learned AGA was called upon to secure the records and make a submission as to the reasons why the applications have been rejected. Learned AGA, upon securing the records, today submits that the conversion has been rejected on account of the lands as regards which conversion was sought for having no access. Learned counsel for the petitioner submit that the aforesaid lands are surrounded by the lands of the petitioner, and as such, the lands on conversion will become part of the larger complex of the petitioner, where the petitioner has already established a hospital. And as such, there is no need of a separate access
Yes.
to the said lands.
Despite the coordinate bench has held, not having approached it is not a ground to reject the conversion.
In terms of the amended section 95, more particularly subsection 2 of section 95, when there is when the land has been shown for a particular purpose in the master plan, it is required for the deputy commissioner to grant conversion in consonance with the reservation made in the master plan. In the present matter, as can be clearly seen, the lands in the aforesaid survey numbers have been demarcated for residential purposes, which is colored in yellow, and therefore there was a requirement for the deputy commissioner to consider the same and pass necessary orders in accordance thereto. Insofar as no access being available, as submitted by learned counsel for the petitioner, the lands being surrounded by the lands of the petitioner, the question of a separate access would not arise. As such, that reasoning is ex facie flawed and is as such rejected. In that view of the matter, I pass the following order. Writ petition is allowed, a mandamus is issued, a certiorari is issued, so and so at H1, H2, H1, H2 are quashed. The respondent number 2 is directed to consider the said application in accordance with the law, more particularly subsection 2 of section 95, and issue the necessary conversion certificate within 30 days from the date of receipt of a copy of this order. The first respondent is directed to inform all the officers coming under his jurisdiction to upload the reasons for rejection of any application made in an online manner in the online application itself, if necessary by attaching the reasoned order.
Yes.
So that any applicant would be aware of the rejection as also the reasons for rejection, which could be taken up before the particular court if challenged.
Please.
131, Santosh Rao.
Raut,
Santosh Rao.
Day before yesterday, my lord, I have been directed to produce the resolution copy, my lord. That, my lord, giving NOC to the liquor shop by the Gram Panchayat.
there are 7 people.
Please. The petitioner herein are the, my lord,
The petitioner is before this court seeking for the following reliefs. The contention of the petitioner is that the petitioners being elected members of the Gram Panchayat Torangatti, despite their objection, respondent number 7, Assistant Excise Commissioner, has issued permission to put up a liquor shop in the village limits of the said Gram Panchayat. In that background, the Sri Shivraj Remat, Learned Counsel, appearing for respond number 2, 5 and 6, submit that the said permission and license has been issued by respond number 7 in furtherance of the resolution passed by the Gram Panchayat, in which the petitioner had opposed resolution, but the resolution was carried by majority. As such, he submits that the petition does not make out any grounds and is required to be dismissed. Heard peruse papers. A perusal of the resolution of the Gram Panchayat dated 23/10/2024 clearly and categorically indicates that the
Page number 9, my lord.
has approved the grant of has approved and provided is no objection for the use of the land for non-residential purposes and for establishment of a liquor shop, with the no objection being provided to the MSIL. Subsequently, license has been issued by respond number 7. In that view of the matter, I am of the considered opinion that there are no grounds made out in the above petition. The above petition is an abuse of the process of court by the petitioners who are elected representatives agitating a issue before this court after the resolution has been passed by the Gram Panchayat. As such, the petition is disposed by imposing cost of rupees 10,000 payable to the advocate's clerk so and so.
132, Prashant Osmani.
Appeal for the respondent. That's a
Yes,
petitioner is a corporation.
Really, there are.
He is held up in quota number 2, my lords. Last occasion, your lordship directed, my lords, petitioner counsel to, my lords, what is his stand before the, my lords,
MVC.
MUC?
Also.
Please.
Yes, 130.
In the last occasion, lords, I was directed to, lords, furnish the stand taken by the corporation, the MVC. We have said that our driver has not committed any, but that, my lords, is based.
Followed the applicable rules, drove in the left-hand side of the road.
That, my lords, that version is taken because we believe the version of, my lords, the driver. Only thereafter, my lords, inquiry, domestic inquiry.
MVC alena.
MVC, my lords, we have paid the, he was held to be, a charge sheet was against him. So, my lords, in MVC, we paid the compensation because we have a self-insurance fund. We have paid the compensation to the lords, kin of the.
Paid, not
paid.
filed an appeal.
Appeal filed and.
You wasted the time of the court.
In criminal case, my lords, he has been acquitted on the ground that there are no eyewitnesses. That lack of evidence, he has been acquitted in the criminal case.
So this also will go. You have taken up that stand, created so much of trouble for so many people.
My lords, that stand is taken because, my lords, the version of the driver will be believed at the time of filing objections in the MVC.
Did you file the objection?
It's objections, my lords, on 22/8/2013. Lords, that objections is filed 22/8/2013.
22/8/2013.
Objections been the.
When did you initiate proceedings against the?
Lords, against.
24/1/2014.
Please. That is, my lords, after we get a report.
When did you file the appeal in MFA?
MFA appeal, my lords. MVC was disposed of on 26/2014. 26/2014. Thereafter, my lords, the exact date of MFA, my lords, is not
MFA number.
Adu illa, but I am instructed that MFA was filed and.
26/2014.
Please.
It was disposed.
Please.
You initiated proceedings on 24/1/2014.
Please.
Did you go before the MVC court and say, sorry, we'll pay? No.
On quantum, my lords, there it is with the.
You did not do that. Then you chose to file an appeal.
On quantum. On quantum, my lords, we have filed an appeal. We have, my lords, because thereafter, since he's.
Take him back.
But the
In
only,
future, be clear whether you want to defend the MVC or take action against the person. If you are taking the action against the person, you can't defend in the MVC. If you are defending the MVC, you can't take action.
my lords, we will be taking two contrary stands and that.
Can't do both.
But initially, my lords, when objections are filed, the difficulty, the practical difficulty that we are facing is,
So initially objections are there.
thereafter we have to correct our stand. That is not.
Correct yourself.
That, my lords,
ಅದು ಕರೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಅದು ಒಂದು ತಪ್ಪು ಮಾಡಿದೀವಿ ಅಂತ ಅದರಿಂದ 20 ತಪ್ಪು ಮಾಡಿದ್ರೆ
it's, in what happens, my lords, in these fatal accident cases, we have to conduct, my lords, an inquiry to ascertain.
Conducted. Nobody said no.
Because there will be past history of the driver and lots of other
You
things.
do everything expeditiously and take a stand.
We definitely cannot take contrary stand.
That is up to you. You want to prosecute the driver, prosecute him. That's your stand.
Please.
But if you are prosecuting the driver, you cannot take a difference in the MVC saying my driver is the best driver in the world. That you can't do.
We cannot take contrary stand.
That's all. So now that you have done that, you take him because you have certified him to be the best driver in the world. Third, petitioner is before this court seeking for the following leaves.
No, he has, my lords, attained the age of superannuation.
He is retired.
Retired.
He's retired. He's retired. My lords,
In the year 2016 itself.
We'll dismiss this. You have to comply with the labor court's order.
labor courts also.
The respondent was appointed as driver in the petitioner corporation. It is continued that on 24/3/2013, when the respondent was on duty as a driver in bus bearing KA 42 F113 flying between Belgavi to Hubballi at about 13:30 hours near old DSP office, the respondent caused an accident due to his rash and negligent driving, which resulted in the death of a rider of a motorcycle. It is in that background that on a criminal case being registered, disciplinary proceedings were taken up against the respondent. Show cause notice having been issued, respondents submitted a reply to the articles of charge. The reply not being satisfactory and acceptable, an inquiry officer was appointed who submitted a report against the respondent. A second show cause notice having been issued, the response not being acceptable, the disciplinary authority passed an order of dismissal of the respondent from service. Challenging the same, the respondent had filed proceedings before the labor court in number
Reference number 13 of 2018.
Reference number 13 of 2018, which came to be allowed. Is challenging said order, the petitioner is before this court. On an earlier occasion, when the matter was taken up, an inquiry was made with the counsel for the petitioner as to whether any motor vehicle claim case had been filed by the family of the deceased motorcycle rider. If so, what was the stand taken by the Road Transport Corporation in the said matter? Today, Shri Prashant Osmani, learned counsel for the Road Transport Corporation, on instruction fairly submits that a motor vehicle claim case was indeed filed, where the Road Transport Corporation had taken a stand that the driver was respondent driver was riding in a proper manner. Respondent driver was driving in a proper manner, and the fault was that of the rider of the motorcycle. The said contention was not accepted by the MVC court, and the award came to be passed on 26/2014, which was challenged by the Road Transport Corporation only on the aspect of quantum before this court, which appeal came to be dismissed, and thereafter the petitioner has made payment of the due amounts to the family, to the claimants in those proceedings. Whenever any accident occurs, in pursuance of which the corporation were to initiate disciplinary proceeding against the driver, the corporation cannot take a different stand in a claim proceedings filed in MVC matters. The corporation being a government entity and a state under the constitution is required to be a model litigant. A model litigant cannot take two contradictory stands. On the one hand, contending that the driver is driving in a proper manner, virtually certifying the driver's conduct and driving abilities, and on the other hand, initiate proceedings against said driver for rash and negligent driving and contending that there is a misconduct. In the present case, it is always the stand that is to be taken by the corporation has to be uniform. It is always open to the corporation to to prosecute a driver for rash and negligent driving, but at the same time, the corporation would have to act fairly and in a motor vehicle claim petition, not contend that there was no fault on part of the driver. Of course, they said proceedings could be contested on the quantum aspect of the compensation, but not as regards the liability and or a liability aspect by contending that the liability is of the other vehicle. Liability is of the driver stroke rider of the other vehicle. In the present matter, a stand having been taken before the MVC court that the driver was driving properly, and this stand not having been changed even after disciplinary proceedings had been initiated against the driver on 24/1/2014, the proceedings before the MVC court having come to a conclusion on 26/2014, I am the considered opinion that the contradictory stand taken by the Road Transport Corporation is not sustainable and is in fact mala fide. In that view of the matter, the Road Transport Corporation, having succeeded in delaying the awardal of compensation before the MVC court and filing an appeal before this court in a miscellaneous first appeal, and at the same time prosecuting the driver for negligent driving, cannot be sustained. As such, I pass the following order. Writ petition is dismissed. The order dated 25/9/2019, passed in reference number 13 of 2018 at Annexure A, is confirmed. Time granted by the Labour Court. ಎಷ್ಟು ಕೊಟ್ಟಿರೋ time?
Time is not framed.
Is extended by a period of 30 days from today for compliance by the petitioner Road Transport Corporation.
133, Sunanda P. Patil.
And for the petitioner, my lord,
Yes,
challenge the order passed for Annexure D, my lord. That is the suit for partition and separate possession was filed by the petitioner plaintiff in respect of the agricultural lands as well as the partnership firms and the fixed deposits kept in the banks, your lordship. So, fixed deposits kept in the bank and the societies, your lordship,
Yes.
and liquor business, everything, your lordship. And the plaintiff, I have given the genealogy in page number 21, your lordship. Plaintiff is the legally wedded wife of the propositors, Adivyappa, your lordship. And there is no divorce between the plaintiff and her husband, propositors, during his lifetime, your lordship. And the defendant number 5, that is the respondent number 5, is the second wife of the propositors. And defendant 1 to 4 are the sons and the daughter of second wife of the propositors, your lordship. And this defendant number 3 has taken all the FD receipts from the custody of this plaintiff, and he has filed complaints before the consumer court, your lordship. And not only on his behalf, but on behalf of his wife and his mother, that is defendant number 5, and his one Gopal, your lordship, in complaint number 469 to 473, your lordship.
Yes.
And I have produced those documents before this honorable court along with the memo, your lordship. And I have filed an application at I number 1, annexure B, your lordship, not restraining the defendant number 3 from alienating the suit properties as well as withdrawing the amount kept in the society. And this defendant number 3 has appeared and filed his objections, your lordship. And on 18/4/2024, the trial court has passed an order restraining the defendant number 3 from receiving the amount as well as restraining him from alienating the suit properties, your lordship.
Yes.
And afterwards, after filing the objections, the trial court has modified the order, that is annexure D, that is
Page 37.
please, your lordship.
Yes.
And he was
Indemnity
permitted to withdraw the amount as
Indemnity
the
bond.
same is standing in the name of defendant number 3, your lordship.
Yes.
Your lordship, I have produced a document to show that all the FD kept in the banks, that is the societies, are the joint family income. Yeah, and it is,
In whose name does it stand?
I will quote that to your lordship. Your lordship may kindly see the
Whether
page
it
number,
is joint family or not will be determined during the trial.
page number 70, your lordship.
70.
70, memo dated 12/12/2024, your lordship.
Hmm.
Page number 70. I have produced those annexures, my lord. That is
Yes.
page number 70. The amount is standing in the name of Deepak Adivappa Ambli, who has deposited, your lordship. That is the propositors, Adivappa Rudrappa Ambli. Signature is Adivappa. He is the depositor and he is the nominee for the said amounts, your lordship. All the
He has
five,
chosen to deposit in the name of third defendant.
your lordship, I will submit
It is
that
choice,
also.
it is his money.
Page number 34, your lordship. The objections which was filed by the bank, the City Cooperative Credit Society Limited, Belgaum. That is respondent number 1 is the chairman and respondent number 2 is the branch manager of that society, your lordship. Page number 37, your lordship.
Yes.
Para number 9.
Hmm.
Para number 9. It is respectfully submitted that the Adivappa Rudrappa Ambli has invested amount with the opponent society in the name of complainant Gopal Bhimappa Desai under the scheme of fixed deposit under so and so, which are mentioned at serial number 1 to 13 and para number 2 and complaint. And para number 10, your lordship, it is submitted that all the FDRs have been deposited by the Adivappa Rudrappa Ambli by submitting application. In all FDs, the Adivappa Rudrappa Ambli is a nominee. During depositing said amount and said depositor, said Sri Adivappa Rudrappa Ambli specifically passed the instruction that all the said FD accounts should be operated by the nominee of said FDRs. The application for FD under AC account number 319832 enclosed under annexure A, the application for FD and everything, my lord, all the or application under AC enclosed annexure F, your lordship. And page number 65, your lordship. For 65 pertaining to the defendant number 3, your lordship. The chief examination of the bank manager, that is branch manager of cooperative society, your lordship. And para number 7 is important, your lordship. Para number 7, page number 66. I state that all FDRs deposited by Adivappa Rudrappa Ambli by submitting application. In all FDs, the Adivappa Rudrappa Ambli is a nominee. During depositing said amount, said depositor, said Sri Adivappa Rudrappa Ambli specifically passes the instructions that all the said FD accounts should be operated by the nominee of said FDRs. The application for FD under account number 30462 3050.
Same repetition.
Pardon?
The same repetition of the objection.
It is true. And it is pertaining to Deepak Adivappa Ambli, that complaint filed by the Deepak Ambli, your lordship. So as per the bank, all the deposits, I have produced all the deposits, and the propositors is the depositor as well as the nominee for the said deposits, your lordship. And all the, it is not disputed that this
It is not disputed that is the name of defendant number 3.
No, my lord. What is happened? It is not disputed that the defendant number 3 has not denied that all the amount is deposited by the defendant propositors.
There are 2 wives. You have to establish that you are the first wife entitled.
It is not disputed by the defendants, your lordship. It is not disputed. They have not taken any contention. They have not denied it in their objections.
The suit is filed by the first wife, my lord.
First wife.
First wife.
Lords, 3 and 5 are the second wife, son and my lords. The
Divorce ಆಗಿದೆಯಾ first wife?
ಇಲ್ಲ ಡಿವೋರ್ಸ್ ಆಯ್ತು.
There is no any divorce.
Divorce ಆಗಿಲ್ಲ ಅಂದ್ರೆ second wife ಹೆಂಗ್
It's
ಬರುತ್ತಪ್ಪ?
not
ಅಲ್ಲ,
legal
that-
also.
That I'll verify, my lord.
Only self-acquired property, not joint family property.
Please, my lord.
So if joint family property ಅಂದ್ರೆ ನಿಮ್ಗಿಲ್ಲ.
ಇಲ್ಲ, my lord, I'll, in respect of that, I'll verify, but here not, sir, for a moment, plaint for a moment, my lord.
You will have to tell us if there's a divorce or not, that's all.
That,
Once you admit that she is the first wife.
I'll verify. my lord.
If the challenge is there, now that you admitted that petitioner is the first wife, plaintiff is the first wife,
Both are legal. I'll verify, my lord.
Supreme Court has held that you will be entitled only in the self-acquired property, not the joint family property.
It is self-acquired property in so far as plaint is concerned, my lord. In a plaint alle, my lord, they have a page, my lord, 14, my lord, page.
Joint family and
Alla joint alla,
Joint
my lord.
family.
Page
Page
14.
14, my lord.
Yes.
The ಬೆಳಗಾವಿ ಜಿಲ್ಲಾ ಕೇಳಕ ಭಾಗದಲ್ಲಿ ದಿ ಸಿಟಿ ಕೋಆಪರೇಟಿವ್ ಕ್ರೆಡಿಟ್ ಸೊಸೈಟಿ ಲಿಮಿಟೆಡ್ ಶಾಖೆ ಬೆಳಗಾವಿ ಮತ್ತು ಧಾರವಾಡ ಇವರಲ್ಲಿ ಮೂಲ ಪುರುಷ ಅಡಿಯಪ್ಪ ಈತನು ತನ್ನ ವ್ಯವಹಾರದಿಂದ ಬಂದಂತ ಲಾಭದ ಹಣ ಒಬ್ಬರ ಹೆಸರಿನಲ್ಲಿ ಇಡದೆ ತನ್ನ ಮಕ್ಕಳು ಹೀಗೆ ಹಿತೈಷಿಗಳ ಹೆಸರಿನಲ್ಲಿ ಇಟ್ಟಂತ ಎಲ್ಲ ಮುದ್ದತಿ ಠೇವಣಿಗಳು 50 ಲಕ್ಷ ಹಣ ಮತ್ತು ಅದರ ಮೇಲಿನ
That's because of the joint family property in the
my lord, he is the, my lord, president of the cooperative bank and he is the partner of the bar and, my lord, restaurant of the Prakash, my lord. Out of that, my lord, he has deposited in
That
the, my
will
lord,
all have to be established during trial.
It has
yes,
to be
my lord.
established.
Alla, in respect of wife is, my lord, and my lord, page number 13,
You
my
will
lord,
have to only
paragraph
tell
2.
us if there's a divorce or not, otherwise you can't withdraw.
No, I'll verify that, my lord.
Counsel for the respondent seeks for and is granted 2 days time
Tomorrow, my
to
lord.
obtain instruction,
Tomorrow-
make a submission as to
Tomorrow
whether
it is
there was
posted for orders that complaint is.
whether there was a divorce between the plaintiff and
The
Shri
propositors.
Adivappa
Rudrappa Amli.
Rudrappa Amli. Relist tomorrow.
Please.
6 for a day's time.
2:30.
2:30.
Please.
One 34.
My lord, I appear for the respondents. My lord, I appear for the petitioner in this matter.
Yes, ಏನಾಯ್ತು?
On the last hearing ಅಲ್ಲಿ ತಾವು my lord was pleased to direct both parties to find out a possibility of settlement.
Yes.
And I had also submitted to my lord that in a phased manner, I am willing to take back the workmen, whoever are were working in the mining division.
Yes.
Now I gave the list of 68 workmen with the date of joining, age, designation, etc. to my friend. I shared it with him and said, to begin with, I had said that it will be in a phased manner. So I offered 10 workers to work in the mining plus 2 excavator operators, totally 12. There is a small mistake from my end because I should have filed that list of 68 workers. My lord, out of that 68 workers, 13 workers are 59 or 60 years of age. ಅವ್ರನ್ನ ಬಿಟ್ಟುಬಿಡೋಣ. In ಉಳಿದವರಲ್ಲಿ what is left out is only about 55.
Yes.
Now out of 55, I said to begin with, I will provide employment to 12. Maybe it may go up to 15 also, which I am now submitting on permission approval from my client. I said I will provide work if you are willing to come, drilling work, excavation operation. Now it is now up to my friend to say what he has to say.
What about the balance 40?
ಅದು in a phased manner. My lord, ಏನಾಗಿದೆ mining
1 ತಿಂಗಳ,
activity.
2 ತಿಂಗಳ, 6 ತಿಂಗಳ, ಏನ್ phase ಏನು?
Fact is, my lord, my friend might also be aware, the lease of this property comes to an end in 2025, December 25. Notwithstanding,
Fate accompli, December 25 ಆಗೋಯ್ತು, I won't take them ಅಂತ ಹೇಳ್ಬಿಟ್ರೆ ನೀವು?
no, I'm sorry, that is not what I meant. To begin with, 12 ಜನ 15 ಜನ ಬಂದ್ರೆ, I will work out the stage at which I will be able to take back the workmen based on the orders, probably maximum month or two. Maximum of a month or two.
Very difficult for Mr. Chidanandaya to tell 15 of his clients will be done, 40 will not be done without telling them and what time and what manner. ಆಮೇಲೆ ಅವರಲ್ಲಿ ಜಗಳ ಆಡುತ್ತೆ. So you will have to
I will go by my lord's direction. I will give writing commitment as to when the others will be provided employment. And
So
in
then,
consultation with my client, our memo sign ಮಾಡಿ ಹಾಕ್ಸ್ಬಿಡ್ತೀನಿ ನಾನು.
ಯಾವಾಗ ಆಗ್ತೀರಾ?
ನನಗೆ
May I just,
27th or 27th or 28th, my lord.
Yes, Mr. Dananda.
My learned friend has sent an email communication to me saying that 10 drilling workers will be taken, 2 excavator operator will be taken. We are none of us, we are the drilling operators, we are only the excavators. Actually, what is the offer made by him is only to give employment to 2 people. I asked
Foundation
Mr. Anand
weak ಇದೆ
very-
Mr. Anand.
ಇಲ್ಲ, ಕ್ವಾರಿಯಲ್ಲಿ
I asked him
25 ಜನ ಕ್ವಾರಿಯಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಿದ್ದಾರೆ ಸ್ವಾಮಿ.
I asked him a specific question. What about the arrears of the wages? My learned friend categorically said, not 1 rupee will be paid. So
Not at
therefore,
this
my lord,
stage.
he is taking the court for a right. As petitioners are taking this honorable court for a right, my lord. On the one hand, they promise, my lord, saying that they will take back this worker, and secondly, they say, my lord, that they will not pay 1 rupee to them, my lord. These workers, they have borrowed the money from various persons and they are living with the borrowed money. Therefore, my lord, only as a last resort, they have gone to the payment of his authority, requesting payment of his authority to pass an order. The sole ground, my lord, is urged by him is that I am required to go to the labor court or industry tribunal. Payment of wages authority is not there. My lord, therefore, I request my lords, my lord, to decide this matter because they will never take it, my lord. This is because they are very clear the way in which I really felt offended after seeing his email. He sent saying that 12 people will be taken, of which 10 people are drilling workers. They never worked as drillers, only offering to employment to 2 people. Now your lordships will kindly see both the district judge and regional labor commissioner, they have given consistent core reasons stating that
Then they will have it on
Yes.
25th. Either it gets settled or you argue the matter.
he is not going to settle the matter. That's what is my.
You don't have to say that, please.
ಕೊಡೋಣ ಅವ್ರಿಗೆ. 25th
you don't
ಅವ್ರಿಗೆ
have to say
ಮಾಡ್ಲಿಲ್ಲ
that.
ಅಂದ್ರೆ, 25th ಅಲ್ಲಿ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ then we'll take it up.
May I, my lord, kindly have it on 27th, my lord?
Not 27th, 25th or today.
Today, let my learned friend argue the matter, my lord. He has argued this matter number of times. I will in 5 minutes, I will reply, my lord. I will only show the prayer made by me before the regional labor commissioner.
25th
whether-
at 2:30.
Yes.
Interim order may be extended, my lord.
Interim order is extended till next date.
Please,
Obliged, my lord.
please, ma'am.
35, Vittal Tili.
Lord, I represent the respondent in this case. After hearing some time on the other day, my lord, this honorable court opined me to file affidavit stating not to claim equity, my lord. I have filed, my lord.
You filed. Where is Mr. Thili?
Vittal Tili.
Password.
Please.
136, HR Deshpande. Shuraj Belakki.
For the petitioner, my lords, last time he wanted to clarify regarding the information obtained from the JDR number 2. Regarding date of preliminary notification and date of disposition.
So I verified. That is the communication by our.
At the most you can say 15 days. ಅದನ್ನು ಯಾಕೆ ಸೇವ್ ಮಾಡ್ತೀವಿ?
But other aspects, my lord, proper. Only they are challenging only that date of possession. ಅಷ್ಟೇ.
Third.
Around 9 months difference.
August ಅಲ್ಲಿ 1st August 30th August ನೀನ್ ತಗೊಂಡ್ರೆ 15th August ಅಂತ ಅಷ್ಟೇ ಹೇಳ್ಬೋದು, ಇನ್ನೇನು ಹೇಳಕ್ಕಾಗಲ್ಲ. Petitioner is before this court seeking for the following reliefs. The petitioner's father was the owner of the land in RS number 21/5 of Avarkod village, Atni Taluka. The first respondent acquired the said lands a reference was made, as regards the compensation, a reference was made in LAC number 54 of 2005, where an award was passed on 23/2006, enhancing the compensation paid. The compensation amount being deposited was directed to be released in favor of the petitioner's father. Since the remaining amounts were not paid, the petitioner sought for a warrant to be issued for recovery of the amounts, which was so issued. Challenging the same, the respondent filed the writ petition WP number 60353 of 2010, which came to be disposed by this court by order dated 10/6/2011, directing, reserving liberty to respond number 2 to file the calculation memo. The petitioner's father and respond number 2 to file their respective calculation memos. The said calculation memos having filed, the additional senior civil judge Athani by order dated 24/1/2013 determined the balance amount payable. The petitioner is before this court contending that while determining such balance amount, the court has not taken into consideration the date of disposition and awarded interest thereon. The submission of Sri H.R. Deshpande, learned counsel appearing for the petitioner, is that the respond number, yar letter adu?
Respond number 2, my lords.
Respond number 2, in a reply issued to a RTI query by the petitioner dated 31/12/2011, has categorically indicated that the preliminary notification had been issued on 1/4/2004. The work had commenced in August 2004, and as such, it is from the month of August 2004 that the interest is required to be paid. It is in that background that the respondent was called upon to obtain instruction, make a submission as to whether that letter has been indeed issued in a reply to RT query. Today, Shivaraj C. Belaki, counsel submits that the letter has been so issued and the contents thereof are correct. If that be so, the contention of the petitioner is required to be allowed, directing the awardal of interest from 15th August.
From 1/4, my lords.
1/8.
1/8.
Or 1/8, my lords. 1/8.
ನೀವು 1/8 ಅಂತೀರಾ?
Yes.
1/4 is the
15/8.
1/4 is the preliminary notification, my lords.
from date
And
of
date of disposition is from in the month of August
So
2004.
we'll take a median, this one,
Yes,
say 15th.
or 15. Yes.
15th word as 14th August. 15th August ಕೆಲಸ ಮಾಡಂಗಿಲ್ಲ. 14/8/2020, 14/8/2004.
4, my lord.
As such, I pass the following order. Writ petition is allowed.
Lord, it may be observed rest of the contention, my lord.
Writ petition is allowed. A certiorari is issued. Allah, you will have to remand for that calculation.
Yes, fresh calculation ಆಗುತ್ತೆ.
ಬೇರೆದು that is confirmed. There was a, my lord,
A certiorari
exaggerated
is issued.
calculations.
The order dated 24/1/2013 is remitted back. ಅದನ್ನು set aside ಮಾಡಕ್ಕಾಗಲ್ಲ.
For redoing the fresh memo.
The matter is remanded to the additional senior civil judge in JMFC Athni for redoing the calculation in terms of the above observation.
Yes.
There being no other grievance of the petitioner as regards the other amounts which have been awarded and or not awarded.
Obliged, my lords.
137, KL Patil.
To be taken on.
Hmm?
To be taken on
Tuesday, my lord.
It's all further hearing.
The further in withdraw ಮಾಡ್ಕೊಂತೇನೆ ಅದು. With signature of the parties, I'll withdraw the writ petition.
Withdraw ಮಾಡ್ತೀರಾ? That counsel for the petitioner request for the matter to be taken up on 25th February to enable him to file a withdrawal memo signed by the parties. We list on 25th.
138, Raj, Valdoli.
This is that education matter. If your lordships would recall, my lords, I was.
Kalsur Matilva. Kalsur Mat was arguing this.
I prefer respond number 1.
Instruction ಬಂದಿದ್ಯಾ?
Day after Monday.
40 years.
Please. Your lordships are directed me
ಇನ್ನೇನು
to
ಅವ್ರದ್ದೇನು
second.
ಕೇಳೋದಿಲ್ಲ ಹೇಳಿ.
Please.
Dismiss.
Please.
The
Previous
petitioner is-
occasion, my lords, your lordships are directed me to secure instructions if I am ready to file an affidavit to, my lords, bear the expenses. But order me.
The petitioner is before this court seeking for the following reliefs. The petitioner aggrieved by the order dated 8/6/2022 passed by the Additional District and Session Judge Belgavi sitting at Chikkodi in EAT number 11 of 2008. By virtue of the said order, the EAT had allowed the appeal filed by respondent number 1 with cost of rupees 5,000, set aside the order dated 31/3/2008 passed by the respondent number by the petitioner directing dismissing the respondent number 1 and directing the respondents to directing the petitioner to reinstate the respondent number 1 into service to the post of assistant teacher on the stipulated scale provided under grant-in-aid code with all monetary and other benefits and back wages. The submission of Shri Shivraj Badoli, learned counsel for the petitioner, is that the Education Appellate Tribunal did not take into consideration that the first respondent, having crossed the age limit of 40 years, was not eligible for being appointed under the grant-in-aid scheme. And as such, the question of the EAT directing the petitioner to reinstate respondent number 1 was improper. It is on the basis of the said submission that the learned AGA was called upon to obtain instruction, make a submission as to whether there was any embargo under the grant-in-aid scheme for continuation of a teacher already employed being continued as a teacher on a grant-in-aid being on the school being admitted to grant-in-aid if the teacher had crossed 40 years of age. Shri V.S. Kalsurmat, learned AGA, upon instructions submitted that there is no such embargo on the continuation. However, there is an embargo on a school admitted to grant-in-aid recruiting a teacher who is more than 40 years of age after the school is admitted to grant-in-aid. The said submission made by the learned AGA is fair, reasonable and logical, inasmuch as merely because a school is admitted to grant-in-aid would not mean that a teacher already working in that school prior to the admission to grant-in-aid will have to be removed from service just because he has crossed 40 years.
And the other, there were other,
Being, and the school being admitted to grant-in-aid.
there were other grounds for his removal also, which we are not able to prove.
In that view of the matter, the only ground which has been raised in the present matter, in the present petition relating to the age is not sustainable. The petitioner could not have dismissed a employee teacher working with the educational institution just on the above ground. As such, there being no infirmity in the order passed by the EAT, the petition stands dismissed. the time granted by the EAT is extended by a period of 30 days. ಎಷ್ಟು time ಕೊಟ್ಟಿದ್ದಾರೆ? Uh, 30 days time is granted. Petitioner to comply.
2 months.
ಏನಕ್ಕಪ್ಪ 2 months?
My lords, back wages I have to
ಅದಕ್ಕೆ
pay.
ಕೆಲಸ ತಗೊಳ್ಳಿ. If you reinstate him, you will get some work done. Otherwise, for that 1 month also, you'll pay free.
Please.
He is not superannuated.
About 2 months. Not yet.
Not it. So at least let him work and earn the money.
Please.
You want to give free?
No. No, it's not like
30 days or 60 days, sir?
45 days at least. My lords.
45 days time is granted to the petitioner to comply
Please.
with the order of the EAT.
One more submission. My lords. Since my lords, the grounds of dismissal is not only 40 years. There was on account of his
Not agitating that. Your main contention is this only.
that was agitated before the tribunal. But here, my lords, the main. Please.
Execution petition is also filed. Respondent number 1 has also filed execution petition before the trial court.
45 days or
Please,
please. They will come and show 45 days ಕೊಟ್ಟಿದ್ದಾರೆ.
please.
Obligements.
Past over matters. Number 4, Siddhappa Sajjan.
ಇಲ್ಲ. ಇಲ್ಲ, pass dismissal ಆಗ್ಬೇಕಿಲ್ಲ.
My lords, this case I appear for petitioner. My lords.
ನಾಳೆ review. Yes, 4.
4, my lords, I may be permitted to appear on behalf of the petitioner counsel, my lords. My lords, this is this is a case where, my lords, we had filed a suit for, my lords, declaration
Yes.
to.
ಒಂದ್ ನಿಮಿಷ.
In this, your lordship, it is a government forest land, your lordship, cannot be granted. And your lordship, my.
Instructions ಬಂದಿದ್ಯಾ? Yes. Yes, Mr. Rajshekar.
My lords, may kindly turn to, my lords, the order, judgment and decree passed by the civil court, my lords, which is available at page 24 for a moment. Operative portion is at, my lords, page number 39, 62, my lords. Plaintiffs
Page
filed.
number 30. Page number?
Page 24 starts from page 24. Suit of the plaintiff, the operative portion of the judgment is at page 62.
Yes.
Suit of the plaintiff is hereby decreed. The plaintiffs are in joint actual possession, so and so continuously, and accordingly, my lords, they are declared as, my lords, in possession and enjoyment of the property. The suit was, my lords, for adverse possession. They have preferred appeal, my lords. In appeal, the judgment and decree passed by the trial court came to be set aside, which is available at page 73. Then they have preferred RSA, my lords. We have preferred RSA. My lords have passed the judgment, my lords, which is available at page number, my lords, 91. Thereafter, in RSA came to be allowed. And, my lords, kindly see the order, my lords, which is available at page 105.
Yes.
The judgment of the first appellate court in so and so is set aside. The judgment and decree dated so and so passed in OS number so and so is restored. Subsequently, my lords, they filed review petition, my lords. So that review order I have not produced. My lords have dismissed that review petition as well.
Yes.
Thereafter, my lords, I made a representation to the authorities saying that you effect mutation since this court has already confirmed my ownership insofar as the property by virtue of adverse possession. They have not considered my case, and as such, my lords, I approached this honorable court by filing writ petition, my lords, which is available at page 127. The operative portion of the order is at page 129, my lords.
Yes.
And paragraph number 4, my lords. The learned AG would submit that if reasonable time is granted, the representation dated so and so shall be considered, and the issue would be taken to its logical conclusion. Thereafter,
Yes.
my lords, the outer limit is granted and directed to consider my case. My lords, after suffering a decree, my lords, at the hands of this honorable court as well as, my lords, which is confirmed by this honorable court. Now they have issued an endorsement at Annexure A, saying that, my lords, this is a forest land. We cannot effect mutation in respect of this property.
Where is the endorsement?
Endorsement is at page 23, my lords.
23.
Page 23, Annexure A.
Yes.
So, Your Lordship, it is a forest land, Your Lordship, cannot be granted. My learner, in the record of rights, Your Lordship, in column number 12, it is entered. But in column number body cannot be given, Your Lordship, on the ground, it is a forest land. Some procedure is there, Your Lordship, the Tahsildar has informed that it is a forest land, it cannot be granted. Even though Your Lordship decree it,
You have to comply. If your procedure can't comply with the judgment of this court, then what do we do?
because Your Lordship, in the judgment,
You
Your
have to
Lordship,
initiate suo motu contempt
no, it
on
is
the basis of your submission that you can't comply.
not complied, Your Lordship, it is only on the ground that is forest land, it cannot be.
There's a judgment.
Yes.
Unless it is set aside, you're not challenged it.
Yes, earlier in RA, Your Lordship, it was set aside. In RSA, Your Lordship has confirmed the judgment in OS. Your Lordship.
RSA judgment is still there.
Yes, yes.
And filed review also, my lords, dismissed.
Within certain time, Your Lordship may direct the respondent to come. Because some procedure is there, Your Lordship, immediately
Whatever
they cannot
procedure you
do.
have to follow.
Yes. 2 months time is granted, Your Lordship.
The petitioner is before this court. Sale number 4. The petitioner is before this court seeking for the following reliefs. The petitioner is before this court aggrieved by the endorsement
Luxury.
dated 18/3/24 issued by respondent number
Respond number 4, Your Lordship.
4 at annexure A, stating that the entry of the name of the respondent cannot be made the aspect of this aspect has been considered in personal suit in OS number 29 of 2012 filed by the petitioners. The said suit having been decreed, a challenge having been made in RA number 10 of 2018 came to be allowed and decree set aside. Subsequently, by way of the judgment dated 11th August 2020 in RSA number 100295 of 2019, the decree passed by the trial court was restored, declaring the plaintiffs to be the petitioners to be the petitioner and his family members to be the owners of the property. Once a declaration has been, a review petition filed in relation thereto also came to be dismissed. This said judgment having attained finality, it was but required for the respondent number 4 to comply with the said judgment and do the needful by entering the name of the petitioner and the other family members. The same not having been done, the endorsement at annexure A could not be issued, contrary to the judgment passed by this court, which has attained finality. In that view of the matter, I pass the following order. Writ petition is allowed, a certiorari is issued, endorsement dated so and so at annexure A is quashed, a mandamus is issued directing the 4th respondent.
Not only 2 to 4, direct the respondent 2 to 4, because Your Lordship, in the annexure A,
Respondent 2 to 4 to act on the judgment and decree passed in OS number 29 of 2012 as confirmed in RSA number 100295 of 2019 as per the directions issued by this court dated 18/8/2023 in WP number 104/999 of 23 within a period of 30 days from the date of receipt of a copy of the 60 days from the date of receipt of a copy of this order.
Grateful.
30 K. Raghavendra, V. Vidya. 30
None appears. Relist on 24th March. Interim order earlier granted is extended till next day.
$129 Rajshekhar Burji. $230 mood matter. 1 Sanjay Channan.
This is a no conference motion against the Adhyaksha, my lord. The ground is that, my lord, page number 14, the notice is issued by the, not by the AC, my lord. That is left side, there is a signature, issued notice, and it is not issued by the AC. As per the rule 3, my lord, the
Notice is annexure D, page 16.
yes, in the there's a form number 1, my lord. He has to note by the issued notice here, my lord. There's a corner. It is not by the AC. And the form number 1 is not. They have not mentioned the rule 3, my lord, on the top. It is only form number 1, my lord, they have mentioned.
It does not say, your lordship.
And my lord, the ground is, my lord, the notice.
Cost impose dismiss ಮಾಡಬೇಕಿದು.
No, my lord, the notice is not issued by the AC, my lord. This
notice is issued by the AC. See annexure D, page 16.
This is the president, my lord. This is the president, my lord. In the no confirmation moved by the members, my lord. That is annexure for C for page number 14, my lord.
Members have to submit it to the assistant commissioner, not the notice to be issued by the assistant commissioner.
The note put by the AC is the issue notice.
ಅಷ್ಟೇ. Learned AGA accepts notice for respond number 1 and 2. Notice to respond number 3 to 27 is dispensed with in view of the proposed order to be passed. The petitioner is before this court seeking for the following reliefs. The petitioner is before this court aggrieved by the notice dated 28/1/25 issued by the second respondent assistant commissioner fixing the date for consideration of the no confidence motion against the petitioner on 21st February 2025 at 11 a.m. The submission made by learned counsel for the petitioner is that the requisition in form number 1 dated 27/1/25 is not in terms of the format, and secondly that who has signed it ಅಂತ ಹೇಳಿದ್ರು,
that case worker ಅಂತ ಹೇಳಿದಾರೆ, but
that the endorsement found on annexure C issue notice is that of the case worker and not of the assistant commissioner, and as such he submits that the assistant commissioner has not issued the notice. The notice annexure C is the requisition in terms of form 1. The notice is at annexure D annexure D dated 28/1/2015. A perusal of the said notice indicates that the same is in terms of form 2 of subrule 2 of rule 3 of the rules of 1994 and has been signed by the assistant commissioner, therefore issued by the assistant commissioner. The endorsement on annexure C as regard is immaterial so long as the notice has been issued by the assistant commissioner. No grounds being made out, petition stands dismissed. Imposing cost of 1 lakh is dismissed.
2 GI Gachinmat.
Avinash, Eli.
Avinash Pankar.
Avinash and Avinash. Where is your twin?
Angry.
Huh? Change. Huh?
But since it was a new pattern, the colleges, they conducted the orientation programs for the lecturers, and then little late, they started.
Oh.
So therefore, the earlier little more observation
Will not apply.
Compulsively, and I have not taken the benefit of the interim order. So I have moved that kind of also to the words. But the students that they are facing the difficulty was the students found was the difficulty that has been faced now by the students. Since it was a new pattern, the lecturers were given the orientation program for the lecturers of the new pattern. And the lecturers in turn started the syllabus with a later point.
So college problem, university problem, NCISM problem. Yar problem ಇದು.
ಅಂದ್ರೆ ಆ ಹೊಸ syllabus ಗೆ they did not get adjusted notes immediately because new patterns notes to electives have been added.
In time period ಕೊಡ್ಲಿಲ್ವಾ?
Sorry.
Time period for change in the syllabus.
Time period ಕೊಡ್ಲಿಲ್ಲ. They started it. That is the reason the notes students are facing the difficulty. First petition the notes I should confess. My lord was pleased to observe that the notes NCM has to explain it and tell it. That cannot be required.
Where is NCISM?
Shangdi.
But the fact is that change in the syllabus has happened.
Yes, change has happened.
Time ಕೊಡಬೇಕು.
But
Time ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ how will they?
that effect ನನಗೂ ಅದು ಮಾಹಿತಿ ಇಲ್ಲ. I had to check your instructions.
You are also responsible.
True, but
Our primary, secondary ನೀವು. Third college. Yes, Mr. Angadi.
ನೋಡಿದೆ.
Mr. Gurudev is saying that the change in syllabus was notified earlier, but the time was not granted to the college and the teachers took some time.
Please.
And the classes actually started after nearly 6 months.
ನೀವು ಪ್ಯಾಟರ್ನಿಗೆ ಓರಿಯಂಟೇಷನ್ ನಡೆದೈತೆ.
You time ಕೊಟ್ಟಿಲ್ವಾ?
ನೀವು
To notify the syllabus at least 6 months in advance.
I will inquire, my lord. Just now I have received the copy.
Shri Avinash Angadi accepts notice for respond number 1, 2, 3. Shri Avinash Bankar accepts notice for respond number 4 and 5. Counsel for the petitioner is permitted to take out hand summons to respond number 6 to 10. The respondents are directed to accept the examination fee to be paid on behalf of the petitioners to enable them to take up the examination commencing from 3/3/2025. The said acceptance of the examination fee and the petitioners taking up the examination will be subject to the result of the writ petition.
Earlier order also needs.
Other-
That is not this writ petition number 101075 of 2024.
Serial number 4.
Shri Gurudev Gachinmat, serial number 4. Shri Gurudev Gachinmat, learned counsel for the petitioner, submits that the change in the syllabus was not midterm, but has been affected by the NCISM at the beginning of the year itself. However, the lecturers of the college took some time to get accustomed to the new syllabus and start their classes. And as such, the petitioners, the petitioner students were put at a disadvantage. His submission is accepted. The observation, the recordal made in para 5 of the order date 13/2/2025 is permitted to be withdrawn. The submission made at para 5 of the order date 13/2/2025 by Shri Gurudev Gachinmat is permitted to be withdrawn. However, taking into consideration that the classes commenced much subsequently, the respondents are directed to correct the same order.
3. HM Dharwad.
And delivery order. Yes.
But the annexed is a notice issued by the certain officer because that 15/2/2025. Date of meeting is 21/2/2025. Without issuing like 7 days prior notice.
ಕೊಟ್ಟಿಲ್ವಾ? ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ವಿ? ಅವ್ರ ಹತ್ರ ಇಲ್ಲ.
ಮಾರ್ನಿಂಗ್ ಕೊಡು ಅಂತ ಹೇಳ್ತದೆ.
ಒಂದು ಕಾಪಿ ಇಲ್ಲಿ ಕೊಟ್ಬಿಡಿ, ಒಂದು ಅಲ್ಲಿ ಅವ್ರ ಆಫೀಸಿಗೆ ಕೊಡಿ, ಇಲ್ಲಾಂದ್ರೆ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಲ್ಲ. ಇಲ್ಲ 7 days ಇಲ್ಲ.
ಇಲ್ಲ 21/2 ಅಂತ ಇದೆ ಅಷ್ಟೇ.
15/2/21 6 days from the date of service of notice.
7 days ಆಗುತ್ತೆ.
So it should have taken into consideration that. ಒಂದಿನ ಸೇವ್ ಮಾಡಕ್ ಹೋಗಿ
ಕ್ಲಿಯರ್ 7 days ನೋಟಿಸ್ ಇರ್ಬೇಕಂತ ಇರ್ತದೆ.
ಒಂದಿನ ಸೇವ್ ಮಾಡಕ್ ಹೋಗಿ ಅವ್ರಿಗೆ 8 ದಿನ ಕೊಟ್ರಿ, ಅವರು ಲಾಸ್ಟ್ ಡೇ ಬರ್ತಾರೆ. ಇನ್ನ 7 ದಿನ ಐ ಕ್ಯಾನ್ ಕಂಟಿನ್ಯೂ ಆಸ್ ದಿ petitioner is before this court seeking for the following leaves. The grievance of the petitioner for holding the election to the post of Kodia, the Rule 13, Sub-Rule 13 of Rule 3. This election galla. You cease to exist. 52. The grievance of the petitioner is that the meeting of the Gram Panchayat for holding the election to the post of the president of the Panchayat has been issued on 15/2/2025, fixing the date to be date of the meeting to be 21/2/2025, and therefore he is not in accordance with subsection 3 of section 52 of the Karnataka Gram Swaraj and Panchayat Raj Act 1993, the said provision requiring 7 clear days notice to be provided. In the present case, the notice is dated 15/2/25 and the meeting is proposed to be held on 21/2/25, which ex facie is violative of subsection 3 of section 52. In that view of the matter, I pass the following order. Writ petition is allowed. A certiorari is issued, so and so dated 15/2/25 at annexure A is quashed. ಅಲ್ಲಪ್ಪ ಇದು PDO ಯಾರು? Liberty is reserved for issuance of a fresh notice in compliance with subsection 3 of section 52. Learned AGA accepts notice for respondent number 1, 2, 3, 4 and 5 ಯಾರು? Shivraj Mirremat for 4 and 5.
Arvind D. Kulkarni.
Same. Shri Avinash Bandkar for respondent number 1, Avinash Angadi for respondent number 3, notice to respondent number 2 and summons permitted, same order as serial number 1. Serial number 1 alla, serial number 2. In the meanwhile, office objection to be complied with and delivery ordered.
6. Srivatsa Hegde.
Construction company will enter into an agreement, concessional agreement with the second respondent. And this was approved by the fourth respondent. The city of Belgaum is one of the 6 cities chosen for the smart city projects. A special purpose vehicle that is the second respondent was created for this purpose.
Yes.
Now, after signing the concessional agreement, I have also furnished as performance guarantee rupees 80 lakhs of bank guarantee. Nevertheless, now the corporation also transfers land with map and boundaries for construction of this multi-utility facility center. And then recently, the mayor writes a letter to the Commissioner of Corporation saying that construction of this art gallery or the MUFC would diminish the importance of the another building which is adjoining, and therefore the project will be halted.
Where is that letter?
And it's again
Page number 11.
page 11.
Sports City Complex and Art Gallery compare ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
I'm sorry, Mills.
ಬೆಳಗಾವಿ ಸ್ಪೋರ್ಟ್ಸ್ ಸಿಟಿ ಕಾಂಪ್ಲೆಕ್ಸ್.
ಇಲ್ಲ ಸ್ಮಾರ್ಟ್ ಸಿಟಿ ಕಾಂಪ್ಲೆಕ್ಸ್ ಗಳು.
ಸ್ಮಾರ್ಟ್ ಸಿಟಿ.
ಸ್ಮಾರ್ಟ್ ಸಿಟಿ.
ಏನ್ ವಾಟ್ ಆರ್ ಯು ಡೂಯಿಂಗ್ ದೇರ್?
ಅಲ್ಲ ಅಲ್ಲಿ Mills, what has happened is there is a Basava art gallery with regard to Mills Basavanna. He's Mills that building's glory will be
ಎಲ್ಲ ಇಷ್ಟು ವರ್ಷ ಕೆಲಸ ಮಾಡ್ಬಿಟ್ಟು ಇವಾಗ ಸಡನ್ ಆಗಿ ಇದೊಂದು.
ಇಲ್ಲ, this is Mills 14/7/2023.
Page 38.
Page
38.
Yes.
This is December 2024. The second respondent still is writing to the municipal corporation to make its stand clear so that we can allow the continuation of implementation of the project.
So corporation is taking this stand.
I'm sorry, Mills.
Corporation is taking this stand.
What's that?
And AGA accepts notice for respond number 1. Shri Chetan Monoli for 3. 2 Garo.
Kapil Walvekar.
Shri Kapil Walvekar for respond number 2. 4 ge.
4 QIDFC.
KUIDFC.
I'll inquire and I'll give. I don't.
Issue notice to respond number 4 returnable by 24th March. Counsel for the petitioner is also permitted take out summons on the serve the summons on the standing counsel for respond number 4 if any. Respond number 3, he is restrained from interfering with the implementation of the project of the petitioner in terms of annexure D1 till the next date of hearing.
May I make one submission? Instead of granting interim order, it may be taken up on Monday or Tuesday. I'll inquire what exactly problem is so that let's.
At the request of Shri Chetan Monoli, released on Tuesday. In preliminary hearing.
Please.
List 1, 32, HM Dharwad.
In this case,
interim order
my small submission. In this case, in a connected matter, I have produced the entire village map. ಅದು ಸ್ವಲ್ಪ ಇಲ್ಲಿ ಜಂಬೂ ಜೆರಾಕ್ಸ್ ಮಾಡಿಸಿ ಅದರ್ ಸೈಡ್ ಎಲ್ಲ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಬೇಕು. So I need weeks accommodation.
Counsel for respondent for petitioner in WP 104698 of 24 seeks for and is granted 2 weeks time to comply with the office objection. Released on 24th March.
Please.
35, Venkatesh Kharvi.
Kharvi. None appears for the petitioner, though the counsel for the impleading applicant is present. Released on 24th March.
Please. 36 Arjun, 37. Gauri Shankar Mott. Gauri Shankar Mott.
Issue notice on IA, yeah, 3 and 4 coding. Private parties. And AG accepts notice for respond number 1 and 2, issue notice on IA 1 of 25, returnable by 28th March.
38. Chetan Limbikai.
Petitioner is Homeopathic College. On the last date of occasion, I have produced documents and directed first respondent to verify the document and make his submission. Page number 31 is the deficiency.
They have filed a submission along with some documents.
What is there, copy?
Illa, il kottilla.
Counsel for respond number 1, 2 and 4 is filed. Those objections are in?
No, no.
Allala,
Regarding submission, my lord.
Page number 31 is the deficiency pointed out by the respond number 1.
You did not satisfy for the year 21-22.
Please, minutes.
Page 2 earlier though, the 6 items are there.
Please, minutes. Please.
If you're not satisfied it during that year,
No, we have
subsequently
satisfied.
you're satisfied.
No, millets. We have satisfied. Millets, may I just, millets, I just refresh my lord's memory.
They have again
Initially,
examined your
millets.
document. We permitted
Millets.
you to give them the documents.
Please, millets.
They have again examined the documents and have stated that these are the deficiencies.
No, millets. That's why, millets, one submission, millets. First, initially, millets, on 29/11/2021, first denial order was passed by the millets, first respondent. That was called in question by the present petitioner in WP number, millets. 100828 of 2022.
Yes.
This honorable court, millets, has quashed the said millets denial order and millets directed millets the present petitioner to furnish additional documents.
Yes.
And thereafter, millets, we have submitted all the additional documents, whatever they have the deficiency pointed out by the millets respond number 1.
Yes.
Despite of the millets, in second time also millets, they have denied. Again, pointed out the millets deficiency as page number 31. And thereafter, millets, this honorable court has granted interim order in the month of April. And meantime, let's say permitted the petitioner college to admit the students. By virtue of the interim order, I got the petitioner college got admitted 22 students. And thereafter, the petition, there is their admission is also approved by the third respondent university. In the meantime, they have the students of the petitioner college have appeared in the examination. Out of 22 students, 8 students have failed in some subjects. They have appeared in August 2024 for re-examination as a repeaters. Their examination is withheld by the third respondent university. After in the meantime, on in the month of January 2024, 20th 20th 4 2020. Annexure F, page number 38. This honorable court has disposed of the writ petition. Disposed of the writ petition
saying that, my lords, para number, my lords, 6.
Page number?
Page number 38.
30.
38, 38. Para number 6, my lords. Petition, my lords.
Yes.
Para number 6, my lords. A perusal of the impugned order does not indicate that for such reasons the appellate authority has refused permission. In my view, therefore, it would be appropriate to direct the appellate authority to reconsider the request of the petitioner for grant of permission as ordered by this court in WP number so and so. Such consideration should be undertaken and completed within a period of 2 months from the date of receipt of copy of this order. The commission shall also take note into consideration that for the subsequent year, that is of 2022-23, the commission itself has granted permission to the college to undertake admission, which thereby signifies that they had satisfied all the conditions prescribed under the rules and regulations. Accordingly, writ petition is disposed of.
You are required to satisfy for
21-22,
Mr. Chairman.
please. And thereafter, my
For
lords,
22-23.
and thereafter, my lords, the petition.
After is not relevant because the Supreme Court has held otherwise.
That's why, my lords, my respectful submission is I have complied all the, my lords.
In the year 22-23, not for
No,
21,
my lords, 21-22 itself, my lords.
ಎಲ್ಲಿ ಅದೇ ಇಲ್ಲ ಅಂತ
ಅಲ್ಲ,
ಹೇಳ್ತಾ
I have submitted entire documents.
That is not in compliance ಅಂತ Mr. Kandvi ಬರೆದಿದ್ದಾರಲ್ಲ ಇಲ್ಲಿ.
I have produced.
There are 8 ಅಲ್ಲಿ clear ಆಗಿ there are 12 items.
May I make a submission?
ನಿಮ್ಗೆ ಅದಕ್ಕೆ ಇನ್ನೂ ಒಂದ್ಸತಿ ಕೊಟ್ರೆ
No, my lords,
ಅದನ್ನು ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಡಲ್ಲ.
ಇಲ್ಲ, ಅದನ್ನು ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ. Even in my compilation.
ನೀವು ಓದಿದ್ದೀರೇನಪ್ಪ ಅವ್ರ ಸಬ್ಮಿಷನ್?
ಇಲ್ಲ, ಓದಿಲ್ಲ, ಇವಾಗ ಜಸ್ಟ್.
ಅದಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್. ಓದಿ
ಪ್ಲೀಸ್. May I make a submission, my lord? My lord, the compilation which I have given contains documents of 21-22. Lordship kindly peruse page number 31. We have observed 6 deficiencies, 31 of our order, subsequent to the direction of this honorable court.
Yes.
6 observations. Page 31, may I?
Page 31
Of the writ petition.
Petition.
Yes, ma'am.
Yes.
Overall observation. College has provided 29 full-time teachers documents, but only 15 full-time teachers considered.
That is at page 2 of your submission.
For that, my lord,
substantiated by para 8.
yes. Now in this compilation, my lord, I have given the documents. What are the deficiencies existing as on 2021? These are the documents, only relevant because they have submitted voluminous documents. Only relevant I have produced. The first, my lordship kindly peruse page 6 regarding para 3 ಅಲ್ಲಿ, page 3 ಅಲ್ಲಿ paragraph 8 ಅಲ್ಲಿ I have said regarding each of the 12 teaching staff observations. Earlier affidavit ಅಲ್ಲಿ as far as first lecturer ಅಂತ ಕೊಟ್ಟಿದ್ರು, then associate professor, like that.
From your list also, item number 12 is the only one which could be relevant.
Yes.
Item number 1 to 11 are clerical errors.
Yes, ma'am. ಅದಕ್ಕೆ next year we have given.
It's not that something was required to be done and they had not done Allah.
Yes.
They had done it, but there was a clerical
mistake were there. That's why, my lord, we clarified, and subsequent year we have given. Yes.
That was only a clerical.
Yes.
Nothing substantial.
Only
12 substantial one is 12.
12 ಅದು 10 years ಆಗಿರಲಿಲ್ಲ, but next year ಗೆ 10 ಆಯ್ತು.
That is the only substantial.
Yes, ma'am.
The others are not at all substantial.
That's why that is the only observation we have made, and subsequent year we have given. In this order, my lord, we have mentioned.
You have given. Honorable Supreme Court says.
Yes, ma'am.
That if it had not been satisfied in that year.
Yes, ma'am.
Then it should not be given and ಹೇಳಿದ್ದಾರೆ.
Yes, ma'am.
But here it was satisfied.
Yes.
Only the information was not given
not
properly to you.
in a proper format. And subsequent year, subsequent order, we have said that in previous years, there is no provision for us to regularize on.
Because of that judgment.
That
But
is
if
our-
it is only a clerical issue, why should that come in the way, Mr. Kanvi?
ಅಲ್ಲ, ಅದಕ್ಕೆ next year ಕೊಟ್ಟಿದ್ದೇವೆ, and they have rectified it later in a later stage. That's why next year we have regularized. I mean, permission is given, but that year there is no provision for us to regularize.
So we can direct you to do it. Petitioner is before this court. They can note really.
Even one sub. ಅಲ್ಲ ಆದ್ರೂ ಕೂಡ even otherwise also my lords, the regulation says if the deficiency.
ನೋಡ್ಬಿಟ್ಟು ಏನು ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಕಾಗಿತ್ತು. ಅದು ಬಿಟ್ಟು ಏನೇನೋ ಹೇಳ್ಕೊಂಡಿದ್ದೀನಿ.
Sorry.
Petitioner is before this court seeking for the following reliefs. The petitioner is aggrieved by the endorsement dated 4/6/24 and 31/2025 at annexure A and B respectively, by virtue of which the respondent, by referring to the decision of the Honorable Apex Court in Medical Council of India versus Vedanta Institute of Academic Excellence Private Limited in Civil Appeal number 5805 of 2018, held that a college cannot be given a second chance to rectify their defects. They have to be in compliance with all the requirements as on the date on which the recognition is granted. And on that basis, it is contended that there being 6 deficiencies, more particularly as 6 deficiencies for the year 21-22, the application of the petitioner could not be considered for the year 21-22. Subsequently, in the year 2022-23, the deficiencies have been satisfied by the petitioner. Recognition has been given for that year. A perusal of the deficiencies which have been pointed out, more particularly in para 8 of the submissions filed today, would indicate that those deficiencies were as regards the mentioning of the post of lecturers, the date of joining,
Age proof.
and age proof. It is not that these persons were not appointed for the year 21-22. It is only that certain of the information required to be given in a particular format and in a particular manner had not been provided by the petitioner college. Thus, I am of the considered opinion that the decision of the Honorable Apex Court in Vedanta Institute's case would not be applicable to the present matter, since that was a case where the Vedanta Institute had not complied with all the requirements and the compliance was made subsequently. In the present case, the petitioner college being in compliance, but only the information not being provided in a particular manner cannot be said to attract the decision in Vedanta Institute's case. In that view of the matter, I pass the following order. Writ petition is allowed, a certiorari is issued, annexure A, certiorari annexure B. The mandamus is issued directing respondent number 3 to consider the information furnished subsequently in the proper format and to grant approval of the students admitted
Yes.
by the petitioner college and all incidents thereto, including the announcement of their results for the examination taken up subsequently. IA1 is allowed.
Please, orders matter 39, PM Shilwan.
My lords, I request for short accommodation, my lords, to take steps with respect to R8 and R6. My lords.
Counsel for the petitioner seeks for and is granted 3 weeks' time to file necessary application to bring the legal representative of deceased respondents. Relist on 26th March.
Please.
Lords, also I have paid the cost in this matter, my lords. That may also be taken on report, my lord.
Counsel for ನೀವು ಯಾರಿಗೆ
T6, my lords. Sangram School Kani, my lord.
submit that costs have been paid, registry to verify.
40, CS Nilopan,
And for respondents.
6 and 10A.
My lord,
Counsel for the
within
petitioner
week,
seeks bond is granted. Pending ಅಂತಿದೆ.
for bringing it.
10 is pending. Counsel for the petitioner seeks for and is granted 3 weeks' time to file necessary application, bring the legal of the deceased, respond number 6 and 10A. We list on 26th March.
41, Ganesh Raipagi,
Writ appeal is listed tomorrow, my lord. Batch matters.
ನಿಮ್ಗೆ ಒಂದು ತಿಂಗಳು ಅಡ್ಜರ್ನ್ ಮಾಡ್ತೀವಿ ಅಂದ್ರೆ ಇಲ್ಲ ಒಂದೊಂದು ವಾರ ಅಂತೀರಾ.
ಇಲ್ಲ ನಾಳೆ ಇದೆ, ನಾಳೆ ಲಾಸ್ಟ್ ಟೈಮ್
It is submitted that the writ appeal is listed tomorrow. Relist on 26th March.
42, Dinesh Kulkarni,
Counsel for the deceased impleading this.
When has expired? Short accommodation board take the steps against.
For the petitioner seeks for 3 weeks' time to file necessary application to bring the legal of the deceased, respond number 11 on record. Relist on 27th March.
Please.
28th March.
43, Bode Nagaraj,
I am for Lord, the petitioner was participated in the auction.
So Lakshmikant Reddy. Yes.
Lord, the petitioner was participated in the auction, my lord, on 28/2015. It was conducted by the respondent number 2 for the site, my lord, 8 plus 5 plus 8 into 12 are situated at Raghavendra Colony, Ballari. Lord, the petitioner was being the highest bidder. Her bid was accepted. And on the same date, my lord, sale consideration amount of rupees 9,10,000, your lord. On the same day, 2,27,500 plus 5,000 was deposited. Lord, 25% of the bid amount was deposited. Thereafter, my lord,
We'll have to hear the other side. How they know.
matter is covered by the judgment of.
Petitioner is present. None appears for respond number 2.
Okay, our last time also, my lord, has.
Last time also.
Yes, sir.
Illa. Last time NIM request on 16/12/24.
Yes, sir.
To enable representation on part of respond number 2, relist on 24th March. If none were to be present for respond number 2, on that date, matter would be taken up for consideration.
Please.
On the basis of submission made by the counsel for the petitioner.
Please.
44, NL Bhatpurki,
Report. Mr. Bangi.
Tunjay Tata Bangi,
Was here, his colleagues are there. Last occasion, lords.
Inter-say exchange of land.
There is no possibility of such.
Yakappa.
According to petitioners, my lords, they have made its cultivable land and others, and one side land is not. That is because of river simpage is there, and there the adjacent land is fully rocky area. That's the problem.
No counsel for the land counsel for the petitioner submits that inter-se exchange of land cannot be made due to the said lands not being equal in all respects. His submission is placed on record. None appears for the respondent. Relist on fifth March.
45, NR Pelur,
An application for recalling the order dated Malad.
In non-compliance.
Non-compliance. I have complied with the objections, Malad.
The above petition has been dismissed
29/8/24.
on 29
8.
8/2024. due to non-compliance of office objection. Hence, IA 1 and 2 have been filed for condemnation of delay and for recalling the order. Pending consideration, the petitioner was permitted to comply with the office objection, which has now been complied as per the office report put up. In that view of the matter, IA 1 of 24 is allowed delay of, ಎಷ್ಟು ಇದೆ delay?
Month.
61 days is condoned by allowing IA 2 of 24. The order dated 29/8/24 is recalled. The petition is restored to file. And AGA accepts notice for respond number 1 to 3, issue notice to respond number 4 to 13, returnable by 9th April.
Please.
46 urgent, 47, Dinesh Kulkarni.
Defendant in writ petition. Injunction order is operating. Entire construction is stopped.
ಏನೋ proposal ಏನೋ ಕೊಟ್ಟಿದ್ದಾರೆ. Last
I
time.
filed affidavit indicating that dispute is regarding southern portion. Entire construction is now stopped. I am ready to, my lord, not to claim, my lord, any equity if, my lord, suit is decided. I am
Only thing
permitted to
I
go.
request last time is, my lord, not to put up the windows in that disputed.
Please. Without putting windows, I will complete. my lord.
And joint memo ಹಾಕಿ will dispose it off in that. ನಿಮ್ ಕೌಂಟರ್ ಪಾರ್ಟ್ ಬಿಡಲ್ಲ ಸೈನ್ ಮಾಡಕ್ಕೆ.
ಇಲ್ಲ ಆ ಸಬ್ಮಿಷನ್ ಕೊಟ್ಟಂಗ ಆಯ್ತು. ವಾಟ್ ಇಸ್
Petitioner is before this court seeking for the following reliefs. The respondent filed a suit in OS number 36 of 2022. But ನಿಮ್ಮ submission record ಮಾಡಬಹುದಾ ಅದು?
ಬೇಡ ಸರ್.
ಹೆಂಗಪ್ಪ ಅದು ಆರ್ಡರ್ ಮಾಡೋದು? ವಿಂಡೋಸ್ ಹಾಕ್ಬೇಡ, ಅವ್ರದ್ದೇನೋ ಈಕ್ವಿಟಿ ಆಯ್ತು. Okay.
Yes.
Filed a suit in OS number 36 of 2022 for declaration, mandatory injunction, consequential relief. As regards the construction being put up by the defendants therein, who are the petitioners herein, alleging that the petitioner is putting up construction without leaving setback, and that windows and doors are being put up facing the property of the plaintiff. The trial court, while its order dated 9/3/2022, allowed the interlocutory application IA number 1 filed in the said suit injuncting the defendants from going on with the construction. An appeal filed by the defendants in MA number 5 of 2022 came to be dismissed on 4/2/2023 by the Principal Senior Civil Judge and CJM Gadag. It is challenging said order that the petitioner is before this court. The building bylaws ilva idakke?
Building bylaws.
Shri Dinesh Kulkarni, learned counsel for the petitioner, would submit that the petitioner is putting up construction in accordance with law, and if permitted to put up the construction, he would not claim any equity, and if any order is passed against the petitioner, he would not claim any equities. The main grievance of the plaintiff appears to be the windows which are being put up facing the property of the plaintiff. In that view of the matter, I pass the following order. Writ petition is allowed. The order dated 9/3/2022 in OS number 36 of 22, passed by the 4th Additional Civil Judge and JMFC Gadag, is modified by permitting the petitioner to put up construction, subject to the petitioner not claiming any equities, and subject to the petitioner not putting up any windows or doors facing the property of the plaintiff.
48 urgent, 49, HM Dharwad. HM Dharwad.
This, my lord,
Last
writ
occasion, your
petition-
lordship, my lord, after hearing some time, direct the, my lord, government to, my lord, the survey the land, whether acquired by the government or not, filed a report, but report not yet filed, my lord, by the government.
But this writ petition has been filed seeking a direct mandamus, directing the deputy commissioner to consider and pass an order by initiating acquisition proceeding. Now the deputy commissioner himself has passed an order. Now this writ petition itself does not serve for
Order
consider.
ಮಾಡಿದ್ದಾರೆ.
There is
Please,
second
memo
prayer.
along with memo I have produced.
There is
the
second
copy
prayer,
of
my
the-
lord. In so far interim order is concerned, filed an appeal before the, my lord, deputy commissioner.
ಏನ್ ಮೆಮೊ ಏನಾಕಿ ನೋಡೋಣ ಇರ್ರಿ. ನೀವ್ ಯಾವಾಗ ಹಾಕಿದ್ರಿ ಮಿಸ್ಟರ್ ಮಂಡ್ಗಾನಿ? ಕಾಪಿ ಆಫ್ ದಿ ಆರ್ಡರ್ ಪಾಸ್ ಬೈ ಏನ್ ಹೇಳ್ತಾರೆ ಡೆಪ್ಟಿ ಕಮಿಷನರ್?
Deputy Commissioner has narrated in detail that earlier suit for a declaration and also injunction came to be dismissed. As against the RA was filed, that is also dismissed. RSA dismissed. Subsequently, again injunction suit was filed. That came to be dismissed. And RSA, which was filed, RA, after disposal of the RA, they filed a RSA. That was came to be withdrawn. Now, after defeating in all,
You have to challenge this.
That is, my lord, in so far interim order is concerned. During pendency of the earlier writ petition before this honorable court.
Yes,
the, my
now
lord,
there is issued an endorsement. Once the endorsement is issued, we cannot issue a
in
mandamus.
so far second prayer is concerned, my writ is, my lord, that is second prayer. First prayer is, my lord, considered annexure P.
ಅದು ಹೋಯ್ತು.
Annexure P is, my lord, the filed before the deputy commissioner regarding compensation.
ಅಲ್ಲಪ್ಪ ನಿಮ್ ರೈಟೇ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ
Allah, that
ಕಾಂಪನ್ಸೇಷನ್
is all, my lord, the subsequently, my lord, the deputy commissioner direct the assistant commissioner to hold an inquiry. Then, my lord, in turn, my lord, the object,
12/12/24.
my lord, the submit a report by the Tahsildar.
Your representation is 6/8/24.
Please, for a moment, kindly see, my lord, the annexure G. My lord, the
Page.
page, my lord, the page 34. Last one, page 35, my lord, for a moment, kindly see. That is the report submitted by the Tahsildar on 11/6/2021. Page 35.
Darigaon is the older one.
Allala.
12/24 ಅಲ್ಲಿ is a finding of the deputy commissioner. That in the suit that you have filed, you are not succeeded, you are not the owner anta is a finding.
Allah, adu, in so far, my lord, the interim order is concerned. Interim, the filed an action application before the deputy commissioner under section 25.
ಅದಿರೋವರೆಗೂ
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕು. But second prayer, my lord, amend the writ
ಏನು?
petition. I will amend the writ petition.
Q ಏನು? Q page number? What is the status of this appeal filed by them?
please.
Status of this appeal, Mr. Kannur. Annexure Q, page 54.
Regarding that, your lordship, I am.
Counsel for the petitioner seeks for and is granted a week's time to file an application for amendment.
Please.
Challenge, seeking to challenge the endorsement dated 12/12/24, produced by the respond number,
Deputy Commissioner, second respondent.
issued by Deputy Commissioner, produced by respond number 7 in the memo dated 4/2/2025. That AGA seeks for and is granted a week's time to obtain instruction and make his submission as regard the status of the appeal in annexure Q.
Now appeal itself has been disposed of under section 25. It was before the deputy commissioner. Now the
Annexure Q
order
is a,
has
my lord, the disposed by the deputy commissioner regarding interim order. Annexure P is my representation pending before the deputy commissioner.
Interim order.
Interim order.
We list all. March 21.
One more submission, your lordship. Last occasion, your lordship direct the government to survey the land, submit report before it's survey report. my lord, not
Meanwhile,
yet.
survey report to be filed.
Please.
That's one submission.
Yes.
Let's serial number 38 ಅಲ್ಲಿ. Let's last date for examination for fill up the examination form on 13/2 ಇತ್ತು. ಅದು last date ತಾವು 13/2 of this month. ತಾವು ಅದು
Serial number?
38 minutes.
Serial number 38, Purnima. The time period for payment of the examination fee having expired is extended by a period of 4 days from today, permitting the petitioner college to make payment of the same by 25th February. If such payment is made by then,
Payment, fill up the examination form of the students. Some of the students have failed, my lords. Their results are withheld. Now the third respondent university is, my lords, not allowed them to, my lord, fill up the examination form. I have informed him.
Procedure ಏನು?
Procedure, my lords, they have issued a notification on 2/1/2025. Last date is fixed on, my lords, 13/2/2025. By virtue of, my lords, denial order passed by the
ಯಾವತ್ತು, when is the examination?
examination ಇನ್ನು ಇದು ಮಾಡಿಲ್ಲ, but last date for fill up the examination form on 13/2.
Petitioner is permitted, the respondent university,
Third respondent university.
third respondent university is directed to accept the application for
Fill up the examination. Fill up the examination form.
exam. First ನಿಮ್ಗೆ ಇನ್ನ ಅವರು accept ಮಾಡ್ಬೇಕಲ್ಲಪ್ಪ ಸ್ಟೂಡೆಂಟ್ಸ್ ನ.
They accept the forms.
ಒಂದ್ಸತಿ accept ಮಾಡಿದ್ರೆ you can upload it on the online portal.
ಹೌದು.
First ಅವರು they have to grant admission to your accept the admission of the students.
ಹೌದು.
Respondent number 3 is directed to formally accept the admission of the students of the petitioner college and has also opened the portal on 25th February to enable the petitioner to file such forms and applications as necessary to enable those students to take up the examination, including payment of fees,
Please.
if so required.
Serial number 59, my lord.
ಏನಪ್ಪ ಮೆನ್ಷನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? Tomorrow also it won't reach.
the subsequent question.
60 Monday, no.
Serial number 59, my lord.
ಏನಾಯ್ತು ಸೆಟಲ್ಮೆಂಟ್? ಸೆಟಲ್ಮೆಂಟ್ ಏನಾಯ್ತು? ನಿಮ್ದು ಸೆಟಲ್ಮೆಂಟ್? So when to list it? ನಿಮ್ದು ಯಾವ ಸೇಲ್ ನಂಬರ್? 129 relist on next week ಅದ್ರ ಮಾರ್ಚ್. 129 relist on 27th for reporting settlement. 135 relist on 25th at 2:30 p.m. Just a moment, please.
Serial number 88. These two matters to be connected.
88 connect with so and so and relist on 26th March.
Serial number 61, my lords, there is some urgency. Delivery warrant is issued.
Delivery warrant.
Yes. Tomorrow, my lords. Preliminary hearing.
61 relist tomorrow.
Serial number 59.
Preliminary hearing.
Preliminary hearing.
59, my lord. Covered by judgment, my lord. Yes.
Cover ಮಾಡೋಣ.
No, Lord, I request to connect these matters, my lord.
Item number 55. An acquisition of the year 1971. He is challenged in 2024. With respect to
55 somebody mentioned in the morning and took adjournment.
55, no.
Yes, they've taken adjournment in the morning.
25.
They said they've informed.
Not as an urgency for us, not. Kindly see what we didn't know, man. In fact, we were not told at all about it. My learned friend was there, not informed at all.
They said
I mean,
somebody moved in the morning saying that they have informed everybody.
no, my learned friend, we all been waiting here, my lord, for morning.
55.
My lord, the acquisition of 1971.
We'll have it tomorrow.
Lord, can it be tomorrow? Day after tomorrow. Can it be
Day after tomorrow.
tomorrow.
Day after tomorrow, ನೀವು ಒಬ್ಬರೇ
Can it be
ಬರಬೇಕು.
2:30, my lord?
2:30. 55. When the matter was not taken up in seriatim, Sri K.G. Raghavan, the senior counsel, moved the matter, mentioned the matter, made a submission about it, stating that he was not informed about an adjournment being moved, and that is the reason why he was waiting from the morning till now. In that view of the matter, relist tomorrow at 2:30 p.m.
Serial number 54.
Please, Serial number 127. Made a mention in the morning Second, at the end of it, it's not reached. I seek on 25th, my lords. Matter is of 321, one notice, my lords.
You ask us any date, we'll give it. It won't reach. There's already 100 matters
I
listed every
understand, my
day.
lords. However, the
Don't
matter
reach.
is very short, my lords.
127.
321, one notice.
If it reaches, everything is short. 127.
Serial number 54, my lord. My senior wants to make a submission, my lord. He's online.
Covered by my lord's judgment, my lord.
Yeah, just a moment, Mr. Procedural.
The agriculturalist, my lord. The respondent number 4 and 5, who are the private respondents. Serial number 58, my lords. The private respondents have blocked the usage of the road, my lord. Hence, my lord.
58.
Please, my lord.
58 released tomorrow at 2:30 p.m.
Serial number 59, my lord. I request to connect these matters, similar matters covered by judgment. Serial number 59, my lord. And notice is to be issued. It's mandamus, my lord. Seeking compensation.
59. 9. Connect with so and so.
And notice is to be issued, my lord.
List the notice ಹೆಂಗಪ್ಪ ಕೊಡಕ್ಕಾಗತ್ತೆ? ಯಾವ್ದ್ರಲ್ಲಿ 59 ಅಲ್ಲಿ notice?
59, my lord.
59 ಅಲ್ಲಿ ಯಾರು? Who are the parties?
Respondent number 1 is government, my lord. Respondent number 2 is Kenal, MB Convey, my lord.
59, the AGI accepts notice for respondent number 1.
SLA.
Respondent number 2 ಯಾರು?
MB Convey. Kenal. MB Convey, sir.
MB Convey. KNL MB Convey.
Yes, sir. As last time Surbhai Kulkarni has appeared, my lord.
Convey, you appear for KNL?
Yes.
Central government to KNL.
Normally, I will not take, my lord. Colleagues are there.
And I request to connect these matters from similar matter.
Actually, MB Convey for respondent number 2. Connect with so and so, released on 25th notice.
Preliminary hearing, my lord.
54, my lord.
Yes, Mr. Prabhu.
Yes, 54, my lord. Covered by my lord's judgment. Prosecution is initiated against me. Labor reference is also on the same issue. Covered by my lord's judgment, my lord. My colleague has the judgment.
54 released on 25th.
Great. Interim order.
Yes. Interim order may kindly
Serial
be
number
extended.
131, I seek apology, my lord.
Dismiss 10,000 cost.
Lord, I seek apology because
ನಿಮ್ಗೆ ಹೇಳಿದ್ವಿ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಾ ಅದಕ್ಕೆ ಡಿಸ್ಮಿಸ್. ನೀವು ಅಲ್ಲಿ ಸಕ್ಸಸ್ ಆಗ್ಲಿಲ್ಲ ನಿಮ್ಮ ಮೀಟಿಂಗ್ ಅಲ್ಲಿ ಅಂತ ಇಲ್ಲಿ ಬಂದು ರಿಟ್ ಪೆಟಿಷನ್ ಹಾಕ್ತೀರಾ?
Serial number 121.
ಹೇಳಿ.
Kindly taken on Tuesday or Monday.
ಏನಕ್ಕೆ?
It's a land acquisition lapsed under section 24(2).
ಅದು ಬಹಳ ದೊಡ್ಡ ಮಾಡಿ.
ಇಲ್ಲ, it's covered by the
ಉಳಿಕೆದೆಲ್ಲ
60th
54 ನೇ
Extend.
60
Has come
ಫ್ರೆಶ್
on.
ಎಲ್ಲ ನಾಡಿದ್ದು ಮಂಡೆ ಹಾಕೊಂತೀನಿ.
ನಾಳೆ ಡೇಟ್ ಕೊಟ್ಬಿಟ್ಟು ನಾಳೆ ಒಂದು ಸ್ವಲ್ಪ ನೋಡ್ರಿ ಪ್ಲೀಸ್, ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ
60
15 ಡೇಟ್
ಅಂತ ಹೇಳಿದ್ರು ಯಾರು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು.
ಅದೇ ನಾವು ಮಾಡಿದ್ದೆ ಮಂಡೇ ಅಂತಂದ್ರು, ಅದ್ರ ನಾಳೆ ಸ್ವಲ್ಪ ಮಂಡೇ ಮಂಡೇಗೆ ಅದು ಆರ್ಡರ್ ಸಿಗ ಬರ್ತೈತೆ.
ಆರ್ಡರ್ ಸಿಗುತ್ತೆ. ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ ಆರ್ಡರ್ ಸಿಗುತ್ತೆ.
ಕಂಪ್ಲೈ ಅಲ್ಲ, ಸಬ್ಮಿಷನ್ ಐತೆ.
ನಮ್ದೇನ್ ಮಾಡ್ತೀರಿ? 121 121 ಏಟ್ ಕೊಡ್ಬೇಡ್ರಿ.
59 25 ಕನೆಕ್ಟೆಡ್
25th
ಅಲ್ಲ
ಗೈಡ್ ನಾನು ಬರ್ಕೊಂದಿನ ಕಳಿಸ್ತೀನಿ.
ಅಲ್ಲ
ಹಚ್ಚಿದ ಕೆಲಸ ಬೇಡ.
ಶ್ರೀರಾಮ್, ನಮ್ಗೆ ಡೇಟ್ ಬೇಡ, ಹೋಗ್ಲಿ ಯಾವಾಗಾರ ಬರ್ರಿ ನೋಡೋಣ ಯಾರು ಬರ್ತಾರೆ.
ಸರ್ ಉಳಿಕೆದೆಲ್ಲ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ, ಮಾರ್ಚ್ ಬರ್ತದೆ.
150.
ಹಾ
ಅಲ್ಲಿ ಸಾಹೇಬ್ರಿಗೆ ಹೇಳಿದ್ವಿ, ಹಾಕಿದೀವಿ, ಆಲ್ಟರ್ನೇಟ್ ರೆಮಿಡಿ ಇದೆ ಅಂತ ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಹೇಳಿದ್ವಿ.
ಸರ್ 54 ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಯ್ತಲ್ಲ ಸರ್?
ಸರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ ಸರ್.
ಡೇಟ್ ಏನಾದ್ರು
ಡೇಟ್ ಕೊಡ್ತೀನಿ. ಮಾರ್ಚ್
ಮಾರ್ಚಲ್ಲಿ ಡೇಟ್ ಕೊಡ್ತಾರೆ 25th.
ಓಕೆ. ಹಾ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
ಮಾರ್ಚಲ್ಲಿ ಡೇಟ್ ಕೊಡ್ತಾರೆ.
ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
ಮಾರ್ಚಲ್ಲಿ ಡೇಟ್ ಕೊಡ್ತಾರೆ.
ನಮ್
ಡೇಟ್ ಕೊಡ್ತಾರೆ.
ನಿಮ್ ಡೇಟು ಬೇಡ, ಈ ತಿಂಗಳು ಒಂದ್ ಬೇಡ್ರಿ, ಈ ವಾರ ಒಂದ್ ಬೇಡ್ರಿ, ಹೋಗ್ಲಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳಿದ್ನಲ್ಲ ನಿಮ್ ಸೀರಿಯಲ್.
ಅಲ್ಲ ಸರ್, ಡೇಟ್ ಕೊಡ್ತೀರಾ ಮಾರ್ಚಲ್ಲಿ? ಡೇಟ್ ಕೊಡ್ತೀರಾ ಮಾರ್ಚ್?
ಡೇಟ್ ಕೊಡ್ತಾರೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 86 ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಸಾರಿ ಆಗುತ್ತೆ. ಆಮೇಲೆ ಡೇಟ್ ಏನ್ ಬೇಡ. ಡೇಟ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಲ್ಲೆಲ್ಲಿದೆ ಅದಕ್ಕೆಲ್ಲ ಡೇಟ್ ಕೊಡ್ತಾರೆ. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇಲ್ಲ ಅಂದ್ರೆ ಮಾತ್ರ
ಮುಂದಿನ ವಾರ ಯಾವ್ದಾದ್ರು ಕೊಡ್ತಾರೆ? ಮಾರ್ಚ್ ಕೊಡ್ಬೋದು.
ಮಾರ್ಚ್ 3rd ಮಾರ್ಚ್ ಇದು ಮಾರ್ಚ್ ಲಾಸ್ಟ್ ವೀಕ್ ಬರ್ತಾವೆಲ್ಲ.
ಮಾರ್ಚ್
ಕೊಡ್ತದೆ ಆರ್ಡರ್ಸ್ನಾಗ ಬರ್ತಾರೆ. ಇಮೇಲ್ ಹಿಂದೆ ಸರ್ ಅದೇ
ಮಂಡೇ ಡೇಟ್ ಕೊಡ್ತಾರೆ.
ಮಂಡೇ ಇಲ್ಲ, ಟ್ಯೂಸ್ಡೇ ಯಾವುದೂ ಇಲ್ಲ. ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ ರಜೆ ಇದೆ. ಅದು ಮಂಡೇ ಲಾಸ್ಟ್ ಅಂತಲ್ಲ ಇದ್ದಪ್ಪ, ಅದಕ್ಕೆ ಯಾವುದು ಕೊಡೋಣ.